bank matter, my lords. Bank matter, my lords. We have already received more than 1 crore and we have asked the respondent to take back the amount, my lords, because he is not the highest bidder, but he is not ready to take back and he is claiming interest. So it may kindly be posted tomorrow, my lords.
Interest ನೀವು ಎಷ್ಟು ಕೊಡ್ತಾ ಇದ್ದೀರಿ?
My lords,
ಅವ್ರು ದುಡ್ಡು ಬೇಡ ಅಂದ್ರೆ
my lords, he is not ready to take back the amount, my lords. We have sent so many reminders.
ನಿಮ್ಗೆ ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಏನಾದ್ರು ಬೇಕಂದ್ರೆ ದುಡ್ಡು 1 ಕೋಟಿ ಕೊಡ್ತಾರೆ.
Tomorrow, my lords.
Yes, Mr. Aji.
Yeah. One matter for preponement. On day before yesterday, matter was stands posted before this honorable court and appearing for the railway department respondent. But due to interim order passed by this honorable court, the railway department could not continue the work for a length of 6 kilometers. So that there is a urgency. Tender is already been given.
Work is stopped.
Stop tomorrow, please.
Adjournments, list 1, page 11, 52 to 54.
Let's serial number 46, Millets. Serial number 46. Inadvertently, Millets, R.K. Kulkarni is directed to take notice. Millets, Bhushan Kulkarni may be directed to take notice. Millets, it is covered by decision.
46. Shri Bhushan Kulkarni is directed to accept notice for respond number 2. The registry is directed to print his name as such and delete the name of Shri R.K. Kulkarni as that appearing for respond number 2. Relist on 28th January.
Grateful, Millets.
My lord, serial number 52, my lords. Serial number 52. Lord, I am for the petitioner. May I request for tomorrow, my lord, senior, we have engaged the senior counsel is coming physically tomorrow. Vikram,
Come today.
Lord, tomorrow or day after tomorrow.
At the request of counsel for the petitioner, relist tomorrow.
Please, my lord, obliged.
Page 12, 55 to 58.
55. Permitted to withdraw the
Petitioner is before this court seeking for the following leaves. A memo dated 22/1/25 has been filed signed by the counsel for the petitioner, which reads as under. Accepting the said memo and submission of the counsel for the petitioner, petition is dismissed as withdrawn.
Page 13, 59 to 61. Page 14, 62 to 56.
Serial number 62, my lord. 62. I request on next week, my lord. The reason, my lord, my counsel is appointed as a government advocate, my lord. So I request.
ನಿಮ್ಮ ಹೆಸರು ತೋರ್ಸದ?
We are engaging to other counsel, my lord.
ಯಾರ ಹೆಸರು ತೋರ್ಸ್ಬೇಕು ಹೇಳಿ?
1 week is time is granted, my lord.
ಆಮೇಲೆ ಮತ್ತೆ ಅವತ್ತು ಹೇಳ್ತೀರಾ? On 17.
Yes, 17, my lord.
ಎಲ್ಲ GK ಇರೋರು ಒಂದು ದಿನ ಲಿಸ್ಟ್ ಮಾಡಿಬಿಡಿ. ಎಲ್ಲ ಒಂದು ದಿನ you decide who
will appear. Okay.
Who is going to transfer the matters to and we'll print his name. ಒಂದೊಂದು ದಿನ ಯಾಕೆ ಸುಮ್ಮನೆ ಬಂದು ಕೇಳೋದು? ಗೊತ್ತಿದೆ ಅಲ್ಲ ನಿಮ್ಗೆ ಲಿಸ್ಟ್ ಒಂದ್ಸತಿ ಮುಗಿಸ್ಬಿಡಿ. Why should it happen? 62 at the request of counsel for the petitioner, relist on 29th January.
Yes, please, my lord.
List ಮಾಡಕ್ಕೆ ಹೇಳಿ.
Lord, 63 and 64 minutes. 63 and 64 minutes.
Yes.
Kindly 2 weeks time may be granted. I have
You
to
are
file
for?
statement of objections. Respondent.
Have you informed the petitioner?
Petitioner informed.
TV Somapur.
Please, my lords.
You are informed.
I have informed Raviraj C. Patil.
What about Mr. Somapur?
No, sir. I'll inform him. My lords.
Then wait.
Page 15, 67 to 72. Page 16, 73 and 74. Page 17, 75 to 79.
Let's serial number 78, my lords. I appear for petitioner. I pray for short accommodation, my lords. I have informed the counsel for respondent.
At the request of counsel for the petitioner, relist on 30th January.
Please.
Page 18, 80 to 86. Page 19, 87 to 91.
My lord, serial number 89. My lord, may I request this matter, my lord, to take up, my lord, post lunch, my lord, sometime. The matter is this. The trial court has directed the advocates are the petitioner before my lords in a suit. The trial court has directed them to withdraw their wakalat, or else, my lord, the court would seize it. Fact in brief, what? Seize the wakalat. And my lord, please.
Wakalat tane
seize the wakalat of the advocates.
Cancel the wakalat.
Yes, cancel the wakalat. And my lord said, the fact is only this, my lord. One ex-person, my lord, has
take that word, not
I'm grateful.
Page 20, 92 to 97. Page 21, 98 to 100. List 1,
The
number 1.
list to whatever compliances are to be done, please do it by afternoon. Process fee kodadu adu idu ella. We'll record it and pass orders.
List 1, 1, Shivraj Mudhol.
Yes,
The,
Mr. Mudhol.
the permitted to file, not the documents, not here. Annexure J, not issued by the authority, page 6, your arts see the Dhradikarana, and annexure E is, it is a part of the record, where, page 57, the signed by the same authority, but here, the endorsement of the PDO is not there.
Who issued the certified copy?
Not a certified copy issued by the Assistant Commissioner, Office of the Assistant Commissioner.
One submission. One submission. The document just now which is produced and the document which has been issued by the Assistant Commissioner, that is the as per page 56. Lord, I have secured the original records. Lord, the documents which they have now relied and the original record. The PDO is playing with the court. PDO is playing with the court.
Lordships allowed that writ petitions, therefore got it.
No, dismiss the.
Lord, second page may kindly be turned. He has identified the members at the top. Now the document which is produced before the Lordship today morning, he has signed Dhradikarana in the bottom. That is the original file. And below the Assistant Commissioner has signature that for having received.
Why is this PDOs getting involved in the no confidence like this?
Both the documents are
Certified copy did not have any of it.
yes.
There was no second certified copy produced by Mr. Mudhol, as it at the bottom of the page.
Yes. The original file.
As it at the top of the page.
Original file
The writ petition allowed, these things have been done. And the endorsement is the list.
Mail ಇದೆ.
When is the meeting?
Not meeting
First.
is
First.
1st February. But they are playing, this, it amounts to, fraud on the court. Officials, either petitioner or respondent, they have to come to court with the clean hands. If any person involved, they have to be penalized, punished, rigorously. Yes, all.
But who will inquire into this?
Yes, ma'am.
Yaro.
PDO. Allah, Assistant Commissioner PS is present before. Assistant Commissioner due.
Commissioner is
ಅವ್ರು ಬಂದಿಲ್ಲ ಇವತ್ತೆ.
Now
the first certified copy has been issued by the Assistant Commissioner.
he was transferred,
His office.
now I told he was transferred. Some other Assistant Commissioner come, now he is in the office. But yesterday, they have issued a certified copy.
Direct the Deputy Commissioner to have an inquiry and submit a report by 27th or 28th.
Please.
Matter, when the matter was taken up on
My lord, on
2025.
20th.
After hearing the parties, a oral order had been passed dismissing the above petition. However, the said order is yet to be signed. The matter is moved for being spoken to. Shri Shivraj Mudhol, learned counsel appearing for the petitioner, has filed a memo.
IA, my lord.
IA,
Application.
1 of 25, to place on record certain additional documents, one additional documents. This document is said to be the requisition notice, certified copy of the requisition notice issued by the Assistant Commissioner on 21/1/2025. His submission is that the copy of the requisition notice produced at Annexure E at page 56 and 57 of the petition did not bear any endorsement of the PDO. However, the certified copy now issued bears the seal, signature and endorsement of the PDO. Thus, he submits that the requisition notice is in contravention of the judgment of this court in Indus Trust case so and so. Learned AGA has produced the original records where the endorsement is available at the top of the page, whereas the certified copy produced by Shivraj Mudhol along with the aforesaid application indicates the endorsement to be at the bottom of the page. Apart therefrom, there is one other endorsement.
That is the Assistant Commissioner.
One other endorsement made by the Assistant Commissioner at the bottom of the said page, which is not found either in the document produced along with the petition or along with the application today. These are serious matters where documents have been produced before this court in a truncated manner, which documents have been issued, of which the certified copies have been issued in a truncated manner. The same would also amount to an abuse of the process of court by relying upon a truncated document, either by the petitioners or by the state or by the requisitionist. Be that as it may, the PDO, who had no business to affix a signature or seal or make any endorsement, has also done so. And the Assistant Commissioner's Office has issued a certified copy in a truncated manner. It is therefore required for the Deputy Commissioner
Belgaum.
to cause an immediate inquiry into the same and submit a report, which report shall be submitted by 27th January. The Deputy Commissioner would also be at liberty to take such action against such officer as may be required if found to be in default. Relist on 27th January.
Please.
The AG is direct to communicate the above order to the Deputy Commissioner forthwith.
Please.
Should be direct registry to show my name for respondents 4 to 10.
Registry is directed to print the name of Shri Sadiq Gudwala. Is that appearing for respond number?
4 to 10.
4 to
10.
10.
1 and 2.
AGA, is that appearing for respond number 1?
1 and 2.
3.
And 2 na?
3 PDO.
2 PDO ಇರ್ಬೇಕಲ್ಲ.
Shivraj Mudhol
V. Shivraj Remat.
V. Shivraj Remat.
And Shri V. Shivraj Remat. 1 and 2
Government.
AGA, 3 Shivraj Remat, 4 to 10 Sadiq Gudwala as directed by this court. Void order at para 1 of the order dated 20
That may not.
as directed by.
Please.
Grateful.
The order pronounced on the order dictated on 21/2025, which is yet to be signed, is kept under suspension. 20th.
Lord, operative portion of the order. Please.
Operative portion.
2 SP Hebballi.
Needful is done.
And counsel for this petition submit that the process fee and copies have been furnished. Issue notice to unserved respondents returnable by 25th March.
3 D Ravi Kumar.
Read the cost, I'll carry the amendment, Your Lordship.
Also,
Please.
3 H. N. Reddy.
Despite the order date 6/1/25, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution.
5.
Petitioner
Rao.
is before this court seeking for the following reliefs. A memo dated
17/1/2025.
17/1/2025 has been filed, which reads as under. Accepting the said memo and submission of the counsel for the petitioner, the petition is dismissed as infructuous. Pending IA stand disposed.
6. AD Siledar.
Yes. R1 are to take issue notice.
R1 is state.
Government.
You can process anything. And AG accepts notice for respond number 1. ಇದಕ್ಕೆ 7 ವರ್ಷ ಬೇಕಾ?
ಹೋಗಲಿಲ್ಲ sir.
ಒಳ್ಳೆ ಕಥೆ ನೀವು.
My name is to show no because AD Shilles are through wrongly come.
ಯಾರ ಹೆಸರು ತೋರಿಸ್ಬೇಕು?
AL Sandrimani ಮಾಡಿ.
Registry direct print the name of Shri so and so as that appearing for the petition. Delete the name of Shri AD Shiledar and Santosh Raut. ನಿಮ್ದು delete?
Yes, he is there.
ನೀವು ಇರ್ಬೇಕಾ?
Yes.
Print the name of Shri so and so along with Mr. Santosh Raut as that appearing for the petitioner, and delete the name of AD Shiledar as that appearing for the petitioner. AGS served copy ಇದೆಯಾ ಇಲ್ವಾ? ಇದೆಯಾ? And AGS seeks bond is granted 10 days time to obtain instruction, make a submission, relist on 5th February.
Date may give me.
5th February. Ella date fix ಆಗಿದೆ.
Please.
7. SH Mittal Court.
2 days time, my lords. I'll take first steps with respect to respond.
This is R2.
But I'll take.
Photo move ಮಾಡ್ಬಿಟ್ಟು ಇನ್ನ ತಗೊಂಡಿಲ್ಲ ಅಂತೀರಾ?
I'll file application to that also.
ಯಾವಾಗ?
In 2 days I'll file, my lords, because
counsel for the petitioner seeks bond is granted a week's time to make payment of process fee and file applications to bring the legal revenue deceased respond number 2 on record. If needful is not done by 30th, the above petition will be liable to be dismissed for non-prosecution, relist on 4th February.
please.
8. AS Patil. Sabil Ahmed.
None appears for the petitioner. 10 days time is granted to file necessary application to bring the legal revenue deceased respond number 9 and 13 on record. If needful is not done by 3rd February, relist on 6th for dismissal.
9. Santosh Hattikatigi.
I request please. Take, I have to ascertain the correct address, Lord, with regard to.
ಇಬ್ಬರ ಹೆಸರು ಬೇಕಾ ಡಿಲೀಟ್ ಮಾಡ್ಬೇಕಾ?
ಬೇಕು.
ಇಬ್ರು ಇರ್ತೀರಾ? Hattikatgi and you.
Hattikatgi may be deleted.
Delete the name of Santosh as Hattikatgi since Sri Ramesh I. Jirali has appeared for the petitioner. Process fee.
My lord, I have to ascertain the correct address, week's accommodation.
Counsel for the petitioner seeks for and is granted 2 weeks time to ascertain and furnish the current and proper address of the persons named in IA 1 to 3 of 2024. Relist on 12th February.
Please.
10. Vittal Teli.
Pass over.
I'll be permitted to comply though.
Pass over.
11. MC Hukkeri.
Already discussions of application mentioned. Filed in 16/1/25.
Certified copy of annexure H to be filed.
Yes, my lord.
H ಏನದು? ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ? 4 ಸತಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀರಾ?
Lordship mentions in disposition application filed in production of documents.
ಹೇಳಿ, ಕನ್ನಡದಲ್ಲೇ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ.
Disposition application ಹಾಕಿದೆ my lord. 16/1 ಹಾಕಿದೆ.
ಸರ್ಟಿಫೈಡ್
Yes.
ಕಾಪಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ರಿ my lord.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
annexure H my lord.
ಯಾವಾಗ ಸಿಗತ್ತೆ?
Lordship.
ಯಾವಾಗ ಸಿಗತ್ತೆ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ?
ಕಾಪಿ ಯಾವತ್ತು ಸಿಗುತ್ತೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ಕಾಪಿ ಯಾವತ್ತು ಸಿಗುತ್ತೆ?
ಹೇಳ್ಬೇಕಪ್ಪ ನೀವು. ಯಾವಾಗ ಸಿಗಬಹುದು?
The next week.
Learned counsel for the petition submit that an application for certified copy of annexure H has been filed and the same is awaited. Relist on 20th February. If by then office objection is not complied with, petition would be liable to be dismissed for non-prosecution. Astral Thornman.
Oh, publish.
12. Shivalila Arhunsi.
My lords.
Accepting reasons stated in IA 1 of 24, production certified copy of F and L is dispensed with. IA 2, type copies. Good. Again, cancel allappa. It's not legible. You have to produce type copies.
My lords, I'm not pressing on those, my lords. The bailiff report, my lords. It is the bailiff report, my lords. But I
My
request it may be
lords.
dispensed with, my lord.
A. A is not the bailiff report.
Annexure B is the bailiff report, my lords. Annexure A, record of rights, I'll submit the typed copy.
Produce all the type copies.
Please.
Counsel for the petitioner
Lords.
seeks for and is granted 10
My
days time
lords.
finally to produce the type copies of Annexure A, A1, B, F, G, H, J, and L released on 13th February.
My
One
lords,
submission.
I will undertake the wakalat for respondent, my lords.
Respondent.
Respondent corporation, my lords.
R1 HDMC.
Please, my lords.
Gurudev Gachinmat has appeared.
It was directed to take notice for Gachinmat, my lords.
I have received the copy,
Since he
my
was
lords.
not.
Harachangri.
No, my lords. Srimati Joshna Danve.
Ms. Josna Danwe submit that she would be appearing for respond number 1. Registry is direct, print her name and delete the name of Shri G.I. Gachinmat as that appearing for respond number 1.
My lords.
Who unclaimed.
One more submission. With respect to respond number 2, my lords. I may be permitted to serve the copies of the writ petition, my lords, on the advocate who is appearing in the trial court in the execution petition who is appearing for respond number 2.
Trial court ಅಲ್ಲಿ ಏನಿದೆ?
Al execution petition was there, my lords. In execution petition, the bailiff report was filed that he is objecting to come outside of the property which is passed by the HTMC, my lords. I'm seeking the question of
Question is Uma Sunil Sarwade and Shalini Swamirao Lokande. Respond number 2 is Aslam Khan.
Yes, he is a trespasser, my lords. He is sitting in front of our
party in this proceedings, in the execution. ಹೆಸರಿಲ್ವಲ್ಲ?
My lords, he was impleaded, my lords. He was impleaded in the execution petition. He himself filed an impleading application and he got impleaded.
Counsel for the petitioner seeks for and is granted a week's time to make payment of process fee in respect of respond number 2. If needful is done, issue emergent notice to respond number 2 returnable by 25th February. Counsel for the petitioner is also permitted to serve the counsel for respond number 2 appearing in execution petition number 261 of 2018.
Please, read from me.
13, Santosh Malligwad.
I appear for petitioner, my lord. Last occasion, your lordship granted 1 week time to deposit, my lord. Already 4 lakhs is deposited. But this is an order passed in the execution proceedings where I am not a party. 8 lakh rupees is, my lord, my agricultural land is now being attached. This court directed me to deposit 8 lakh rupees. That is the entire amount. 4 lakhs is deposited. I am not even party to the compromise. I am not party to the execution proceedings. But my property is attached.
So now you have deposited 8 lakhs.
No.
Has not
4
complied the
lakhs
order
I
of
have
this-
deposited.
Has
4
not
lakhs I have
complied the order of this court, my lords. There was conditional order.
Yes.
And moreover, this honorable.
11 you were asked to
Yes, I
further
was
sum of 4 lakhs.
4 lakh
4
rupees I was directed to deposit, my lord, which I have failed. I have conceded, which I have failed.
11 no.
Yes.
Inna was to be deposited by December end.
Yes. 4 lakhs within time I have deposited. Remaining 4 lakhs I have not deposited. I have fairly submitted. I'm not able to serve because it's the agriculturist, my lord. My difficulty is, my lord, in the execution proceedings. I'm not a party to the compromise. Your lordship.
There's an order passed already.
Oh.
We can't change that order. You have to comply with that.
I have to comply with the order, my lord.
They have
But
agreed and
on
obtained-
merits, if I make one submission.
It's first to vacate agate interim order.
Yes.
ಆಮೇಲೆ merits.
Yes.
They
My
are agree-
difficulty is, my lord, I have purchased the property from the respondents. The respondents inter se are the family members. They entered into compromise and the property fell into the share of one of the respondent. I am not a family member, my lord. After in the compromise, my lord, these properties fell into the share of one of the respondent. I purchased it from that person. Thereafter, my lord, in terms of the compromise, the respondent number 1 had to pay 8 lakh rupees. Now, which the amount I am directed to deposit. That 8 lakh rupees is supposed to be given by one of the brother to his sister.
You appear for whom?
I am for the respondent number 1 and 2.
Decree holders.
Decree holders.
And 2.
My lords, while obtaining the interim order, the petitioner has agreed and sought the interim order. As he's agreed, and he has agreed to pay the amount. Now,
my lord, in the execution proceedings, impleading application to implead the present petitioners, the application is filed, notice is issued. Along with the notice, attachment warrant is issued. I am not even brought on record in the execution process.
But now you have to comply with the order which has been passed. Otherwise, there's no point.
How so? But 4 lakh rupees, if they are agriculturists, they are not able to deposit. Your lordship may kindly take up on merits. It can be disposed of anyways, because in the execution, your lordship may kindly see page 112.
Subject to the already interim order hogide.
Oh.
Since the petitioner has not complied with the order dated 7/11/2024, not completely complied with the order dated 7/11/24, the interim order granted has automatically expired. Relist on.
Well, Mayor, it can be disposed, my lord.
Ready?
Ready.
Next date may be fixed.
Service agents.
Dispensed with 1 and 2. Yes. Ready?
Yes.
To next week it may be taken, my lords.
At the request of counsel for respond number 1 and 2, relist on 28th January.
In the fresh matters list. Otherwise, it will become infectious. B group al bandre infectious agata. Fresh matters list. May request.
Can't change this.
Yes. Please.
14. Prashant Kardeva.
Notice issued to respond number 1 has been returned with the endorsement refused, and service of notice on respond number 1 is held sufficient. Registry is direct print the name of respond number 1 with the endorsement refused. Ready?
Ready, sir.
Ready.
Please.
Yes.
Lords, the petitioner is the plaintiff, my lords. He filed a suit for my lord seeking cancellation of the sale deed by making my lord defendant number 1 and 2 parties before the trial court. And my lord, in the suit, my lord, kindly see my lord at page number 12, my lord, is the
Suit
plaint.
for cancellation and possession.
Please.
Of 2018. Yes. Yes. IA 8 ಏನದು?
IA, my lord, is filed, my lords, for my lord impleading
by
the proposed respondent number 3 and 4. IA number 8 is filed annexure D, page number 38. My lord, the trial court has not issued notice to the proposed defendant. And the defendant number 2, my lord, he filed, my lord, objections. On the, my lord, basis of their objection, my lord, it is, my lord, rejected.
Why do you want to implead them?
Please, lordship. My lord, kindly see, my lords, my lord, annexure A, my lord, plaint, lordship, the ornaments of the plaint. The proposed defendant number 3 and 4, my lords, are also, my lord, connected to the matter. We have, my lord, specifically mentioned their names in the plaint also. And, my lord, kindly see para number 5 onwards, your lordship.
What is 3 and 4?
Lord?
Who are 3 and 4 that you want to implead? What is their role?
They are all, my lord, connected to the transactions.
Connected andre hengappa?
They are, my lord, initially, my lords, what has happened, my lords, this Vijay Kumar Balmati is the friend of, my lord, plaintiff. He introduced the defendant number 2, 1. And, my lord, another person who is the proposed defendant number 4. And this Balmati, my lord, is the proposed defendant number 3. And, my lord, there are 2 transactions have been taken place. One is.
You want them to come on record for what reason? There's no relief which is sought for against them.
Kindly,
You're only saying that
kindly see, my lords.
Effect can be passed by without their presence and that.
Kindly see, my lords, their objections to the plaint as well as, my lord, the issues framed by the trial court.
Yes.
Please.
Where's the?
In their objections, my lord, page number 25, para number 5. The very same defendant number 2, my lord, he filed, my lord, this objection. Statement of objection, written statement. Para number 5, may I read it, lordship? With reference to para number 5 of the plaint, the plaintiff Vijay so-and-so Balamati and the defendant number 1, Syed so-and-so, are all good friends. The Vijay Kumar Balamati is also necessary party to this suit. In view of the facts narrated by the plaintiff, in the absence of the Vijay Kumar Balamati, suit cannot be effectively tried and issue involved in the suit cannot be decided effectively. Without admitting the claim of the plaintiff, it is submitted that the suit suffers from.
What about Narendra Kumar?
Narendra Kumar, my lord, that is proposed defendant number 4, your lordship. My lord, he, my lord, is the person, my lords, who has taken the GPA. And this objection is, my lord, filed, my lords. And my lord, issues framed, my lord, annexure C, my lord, page number 36. Issue number 1, my lords. Whether the plaintiff proves that the defendant number 1 and Mr. Balamatti colluded together to commit fraud upon the plaintiff, and some 2.5 hours after the GPA, the defendant number 1 executed a bogus, false, sham and illegal sale deed in favor of the defendant number 2. And my lord, issue number 3, whether the plaintiff further proves that.
Government, you are pleading in para 5.
Yes, my lord.
Is that
Yes.
has to be made
There
a
is no
party?
issues, my lord. There is no issues. First point.
Issues
Andre and Mr. Balamatti, because
yes.
he's-
Yes.
If it
Both.
is, if it is,
And my lord, trial court has not.
is not a party, the plaintiff is having right to examine on behalf of him.
Whatever.
Like your government are pleading in para 5
Yes, my lord.
that Balamatti is also a necessary party in view of the facts narrated. In
Yes.
the absence of Balamatti, suit cannot be effectively
Yes,
tried.
I have taken this as a contention, but the trial court has not framed such issues.
Can you
Even
oppose
then,
now?
even then, my submission is that if it is necessary, he has to implement the earlier stage. The court is come to, the trial is fag end of the trial. The case is posted for argument.
Final arguments.
How? Final argument.
But now you won't insist on Vijay Kumar Balamatti to be a party because you are opposing.
Yes, because of argument stage.
You will give up para 5.
Yes, I given up the para 5.
You are given up para 5.
Yes, fine.
I would.
And para 5 also, my lords, and this other, my lord, subsequent paras also has mentioned, my lords.
He'll give up everything as regards Mr. Balamatti.
Balamatti and, my lords, the proposed defendant number 4.
4,
Both are, my lord, interlinked.
4, there is no avowment. Only in so far as 3, he'll give up. 3, once he gives up, 4 is not necessary at all.
Lords,
If wants to this party as I added, the trial court, I request this honorable court kindly fix the time. If it is his party is
Lord,
necessary.
kindly see, my
Wants to
lords.
party
He has
included.
also mentioned the name of the proposed defendant number 4 at para number 13 in his written statement. Para number 13 in his written statement, page number 28. With reference to the para number 13, 14, 15 are concerned, it is clear that there is a good relation between the plaintiff.
And Mujib.
Yes.
Not
He is the
Narendra Kumar.
proposed defendant number 4, lordship.
Who? Proposed defendant number 4 is Narendra Kumar.
No. Proposed defendant number 4 is page number 39, Abdul Mujib.
Mujib.
Please.
You want Balamatti to be represented by Narendra Kumar.
Mujib, Balamatti is different and Mujib is. Both are, my lords, interlinked.
The plaintiff and proposed respondent.
And
there
throughout
is-
his written statement, my lord, he has taken, my lord, that contention. Without there being, my lord, party, my lord, the proposed defendant number 3 and 4, my lords, the suit is not maintainable for want of, my lord, the proper and necessary parties to the suit.
Mr. Matti, do you want to take the risk of deleting 5, 13, everything?
Sir, I request this honorable court may kindly give a opportunity to lead a, to add a parties, but the time is fixed.
That may be.
Petitioner is before this court seeking for the following release. Petitioner had filed a suit in OS number 138 of 2021 for cancellation of a sale deed in respect of suit property as also for possession. In the said suit, in the written statement, defendant number 1,
defendant
number 2 had taken up a contention that one, Mr. Vijay Kumar Balamatti, is also a necessary party, and in his absence, the suit cannot be effectively tried and decided. Further amendments had been made as regards the relationship of Vijay Kumar Balamatti with one Mr. Abdul Mujib. It is in that background that though belatedly,
Submission. The present plaintiff and proposed respondents, there is a dispute between the Bangalore properties. The one of the party filed a suit against the present plaintiff. That suit is compromised.
Now unnecessary that property is tagged with this property.
It's already compromised, that will also, that will apply.
But my objection may kindly be case number, objection
It's
case
in
number.
that background, that though belatedly, the petitioner had filed IA number 8 to implead the said Vijay Kumar Balmatti, represented by his GPA holder, and the aforesaid Mr. HS Abdul Mujib, which came to be objected by the defendant number 2 on the ground that no reliefs have been sought for against them, and that in order to create confusion, tagging a transaction which is not related to the present suit, they are sought to be made parties. The trial court, while the impugned order dated 15/10/24, rejected the application on the ground that the matter being posted for final arguments, the application has been filed belatedly to protract the proceedings, and as such, imposed cost of rupees 200. It is challenging the same. The petitioner is before this court. The submission of Sri Prashant S. Kardeva, learned counsel for the petitioner, is that it is by inadvertence that the petitioner could not implead the said parties at the earlier, despite arguments being made in the written statement. Though the matter is posted for final arguments, this court could put the petitioner on terms and allow the application which the petitioner would adhere to and comply with. The submission of Sri S.L. Matti, learned counsel for defendant number 2, respondent number 2, again is that the matter is being protracted and an unrelated transaction is sought to be brought on record, as regards which parties have already compromised, which has attained finality. Heard so and so Paris papers. Though the matter is posted for final arguments, it cannot be disputed that in the pleadings filed by defendant number 2, there is a specific argument made that Mr. Balmatti and Mr. Abdul Mujib are related to the transaction, and there is a specific argument made that without Mr. Vijay Kumar Balmatti being made a party, the suit cannot be decided, effectively decided. In that view of the matter, I am of the considered opinion that the application would have to be allowed, of course, by imposing suitable terms on the petitioner. As such, I pass the following order. Writ petition is allowed. The order dated 15/10/2024, passed on IA number 8 in OS number 138 of 2021 by the additional senior civil judge at Jamkhandi at Annexure F, is set aside. Consequently, IA number 8, notice is issued on IA number 8 to the said persons. The trial court is directed to issue notice on IA number 8 to the person named therein, and thereafter proceed with the matter. Needless to say that any compromise already entered into and having attained finality as regards any other property will not be subject matter of the suit. The submission of Sri Prashant S. Kardeva that he would cooperate with the trial court for speedy disposal of the matter is placed on record. But ಇವಾಗ ಇವರಿಬ್ರು ಯಾವಾಗ ಬರ್ತಾರೆ?
ಅದೇ ನೋಟಿಸ್ ಹೋಗಿ ಇದು ಮಾಡ್ಬೋದು ಅಷ್ಟೇ. I am the plaintiff, my lords. I am always, my lords, ready, my lord, for.
ನಿಮ್ಮ ಫ್ರೆಂಡ್ಸ್ ತಾನೆ?
ಇಲ್ಲ, ಅದೇನಾಗಿದೆ ಸ್ವಾಮಿ. Earlier they were friends. Because of all these transactions, now, my lord, their relations become, my lord.
If service were not to be capable of being effected within a reasonable time on the proposed defendants, defendant number 2 would also be permitted to take out hand summons.
ನಾನು ತಗೊಳ್ಳಿಲ್ಲ, ಅವ್ರು ತಗೋಬೇಕು. ನಾ ಡಿಪೆಂಡ್
ತಗೊಳಲ್ಲ, ಅವ್ರು ಡಿಲೇ ಮಾಡ್ತಾರೆ, ನೀವು ತಗೊಳ್ಳಿ.
ಅವ್ರು ಎಲ್ಲಿದಾರ ನಮಗೆ ಗೊತ್ತು.
So permitted notes, ನಿಮ್ ಫಾಸ್ಟ್ ಆಗಿ.
Plaintiff is, both parties are permitted to take out notice.
Permitted to take out hand summons. on the proposed defendants. The petitioner allowed subject to payment of cost of rupees 5,000 to be paid to the Advocates Clerks Association within a period of 10 days from today, that is on or before 4th February.
My lord, order, my lord, that transaction, whatever taken place between the Balamati, ಅದು ಸ್ವಲ್ಪ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಇದಾಗುತ್ತೆ ಸರ್.
That cannot be. That you file a separate suit.
I request
ಅದು that is with regard to another property, my lords. That is not with regard to this property.
That cannot be disturbed in this suit.
Please,
Don't try
that
to
cannot
unnecessarily
be.
drag in that.
But there is a series of, my lord, transactions have been taken place within the, my lord, after execution of the GPA. Within 2.5 hours, they have got, my lord, executed.
If it is
sale deed.
already compromised, you can't do anything.
That we have not compromised, lordship. They have taken a GPA from the plaintiff. Within 2.5 hours, my lords, they got compromised and they got, my lord, executed.
ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲಲ್ಲಪ್ಪ.
ಹೌದು, ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀವಿ.
ಮತ್ತೆ ಹೆಂಗಾಗುತ್ತೆ?
The GPA itself is under challenge, lordship. ಅದಕ್ಕೆ ಅದು ಮೆರಿಟ್ ಮೇಲೆ ಇದಾಗುತ್ತೆ ಸರ್.
15, sir.
My lord, date portion, my lords.
Time may be fixed, my lord.
21 suit, we can't fix time.
I request 6 months, sir, time.
My lord, that portion, my lord, finding will be.
It has to be there, Mr. Kardevar.
A series of action ಇದೆ ಸುಮ್ಮನೆ ಅದಕ್ಕೆ.
Yes.
Please.
15.
More relief is claimed against others, my lords. So they were not made up.
RTC not made parties.
Yes, my lords. We have not claimed any relief against them, my lord.
But they have a right in the property.
Even, my lords, it will not affect. We have challenged the award passed by the SLO in the year 2007. And till today compensation is not paid and possession is also not taken by the respondents.
Preliminary notification.
Yes, ma'am.
So that
Of
will
section
inure to their
24.
benefit. Accepting the submission of the counsel for the petitioner, the objection at seal number 15 is overruled, since it is the petitioner alone who is before this court challenging the preliminary notification.
No, preliminary, final notification and award, all the three are challenged.
Final notification.
Yes,
ಹೌದು,
ma'am.
award
Award is passed.
ಒಟ್ಟಿಗೆ ನೀವು ಒಂದೇ ಪ್ರೇಯರ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರೆ
B, C and D.
two 2004, 2005, 2007.
7, yes.
But now you want under a 2013 Act.
Yes, ma'am. Because the 24-1, my lords, they have not taken possession at all and they have not paid compensation till today. In view of section 24-1, my lords, automatically it lapses, my lord. And all, it's clear by
Land acquisition.
even, my lords, they too don't want, now they are saying that they have
ಬೇಕಾ
no.
ಲ್ಯಾಂಡು ಬೇಡವಾ?
Please.
ಲ್ಯಾಂಡ್ ಬೇಕಾ
ಅಲ್ಲ
ಬೇಡ್ವಾ?
ಅದನ್ನ ಕೇಳಿ ಹೇಳ್ತೇನೆ ನಾನು. First time ಬಂದಿದೆ, I will accept notice for all the respondents.
Accepting the reason stated in support of IA 1 of 25, production certified copy of annexure D is dispensed with. And AG accepts notice for respond number 1 to 6.
1 to 4.
It's a type to copy, man.
All respondents ಅಂತ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲ
1
ಇದರಲ್ಲಿ
to 4, 5 and 6, KNNL is there. No?
ಯಾರು?
KS Patil.
ಅಲ್ಲ ನಾನು ಅದೇನೇ ಬೇಡ ನಂಗೆ.
ನೀವಿಲ್ಲ, ಬೇರೆ ಯಾರು? Conflict.
KS Patil, Chetan Munwali is appearing. KS Patil, yes.
He is directed to accept notice for respond number 5 and 6. The learned counsel for respondents are directed to inquire and make their submission as to whether the respondents require the land, subject matter of the above
Even
petition
then,
or
my
not.
lords, in view of the new act, my lords, it stands lapsed, my lords, because the Indore development.
Submission record mode close mode.
Please.
Relist on 4th February.
Please.
Preliminary hearing. I request it in preliminary hearing.
ಅದಕ್ಕೆ ಕೇಳಬೇಡಿ, ಎಲ್ಲರೂ ಅದೇ ಕೇಳ್ತಾರೆ.
16, Emil Hiremat.
Lord, on the last occasion, honorable court was pleased to issue notice and also to serve the copy. Now all the respondents are served and except R6 my lord await service ide. So my lord, he is the co-defendant and he is the purchaser of the defendant number 1. So maybe not. Contesting respondent is represented by the counsel.
For the petitioner seeks for the dispensation of notice to respond number 6 since he is a co-defendant.
Please.
And no reliefs have been sought for against respond number 6.
Please.
Accepting the submission, notice to respond number 6 is dispensed with.
Please. Lord, the respondent number 1 herein has filed a suit for partition and separate possession.
Yes, but very simple matter, ma'am. Only
ಎಲ್ಲ
point,
simple,
ma'am.
ನಮ್ complicated.
No, only thing is, ma'am.
Hmm.
Suit for partition decreed, I filed FDP. In the FDP, ma'am, I filed application for appointment of the court commissioner. to demarcation of the land.
ಅವ್ರ ಪೆಟಿಷನ್ ಅವ್ರು
ಅಲ್ಲ,
ಹೇಳಿ.
ಅಷ್ಟೇ ನಾನೇ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಅವ್ರು ಹೇಳೋದು ನಾನೇ ಹೇಳ್ಬಿಡ್ತೀನಿ. Application was allowed on the same day. I am not disputing it. They sought for filing the objection. In fact, they have on the endorsed on the application. Same day application is allowed. If this honorable court is of the opinion that no opportunity is to be given, it can be given. If it is only an appointment of the commissioner, if they are not affected by the appointing the commissioner itself, if any report is adverse to them, they can file objections before the court.
Effect partition or so on.
Lord, RA is filed pending before the regular court, first appellate. ಹೌದು ಅಲ್ಲ ಸ್ಟೇ ಇಲ್ಲ, ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ 2 ವರ್ಷದಿಂದ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತಾ ಇಲ್ಲ, ಸ್ಟೇನು ಕೊಡಿಸ್ತಾ ಇಲ್ಲ ನಮಗೆ.
ಆರೇ ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ರು?
ನಾವು ಮಾಡಿದ್ದು ಪಿಟಿಷನರ್ ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1.
ನೀವು ಸ್ಟೇ
ಅಲ್ಲ we are pressing but they are seeking time to file objections to the said application for stay before the first appellate court. In the meanwhile, thereafter they file FDP. After lapse of 1.5 years.
They should press the court.
Now
we can't say the court to grant a stay in their favor.
So for that reason, my lord, we sought time to file objections to the said application.
It is for the respondent always to delay. It is for you to press it.
Press ಮಾಡಿದ್ರು ಅವ್ರ objection ಅನ್ಕೊಳ್ಳಿ.
ಅವ್ರ ಮೇಲೆ blame ಮಾಡಕ್ಕಾಗಲ್ಲ.
I am not blaming them.
As they have done in the trial court in the FDP.
My lord, after 1.5 years, thereafter they instituted FDP proceedings. In that, immediately they filed an application to appoint a court commissioner. We sought time to file objections. To place before the court that
order in regular courts everybody passes when FDP is
ಎಲ್ಲ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ.
ಅಷ್ಟು ತಗೊಳಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? FDP
ಅಲ್ಲ,
ಆಗಿದ್ರೆ
for that reason only, my lord, we sought time to file objections to the application, but that was denied and the application was allowed.
That is the only point. If this honorable court is of the opinion that opportunity is to be given, let them file a.
They will have to allow the commissioner.
ಅಲ್ಲ ಅವರು they are not if we are insisting, but the other side are.
That we will observe.
Yes, that can be done. Yes.
First appellate court will take up the matter.
Yes.
Petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by the order dated 13/11/2024 passed on IA number 1, filed under order 26 rule 13 of the CPC for appointment of court commissioner in FDP number 11 of 2024, allowing the said application. The submission of Shri V.S. Kalsurmat, learned counsel, appearing for the petitioner, is that the petitioner has challenged the preliminary decree in OS number 375 of 2010 in RA number?
RA number, my lord, 1 of 23.
1 of 23.
Please.
Wherein though the petitioner sought for interim orders, the respondents have not addressed their arguments in that matter, and the application for stay is not being considered. The said submission cannot be a ground seeking to challenge an order passed on an application under order 26 rule 13 of the CPC in a FDP proceedings seeking for appointment of a court commissioner. So long as there is no stay in the regular appeal, the FDP court would be well within its right to appoint a commissioner for effecting partition in furtherance of the preliminary decree already passed. It is for the petitioner to persuade the first appellate court to take up the application for stay, whether the respondent cooperates or not. When a FDP proceedings is filed, the first appellate court would have to take up the said application for consideration on merits. In that view of the matter, no grounds being made out insofar as the impugned order dated 13/11/24 is concerned, the petition stands dismissed. With CPCL ಯಾಕೆ ಸರ್ಶ್ಯೂರರ್ ಆಗಿ ಕೇಳ್ತೀರಾ?
Set aside.
You will have to ask for set aside. All the writs are under 226, not under 227. 227 is a supervisory jurisdiction. ನೀವು ಸರ್ಶ್ಯೂರರ್ ಮ್ಯಾಂಡಮಸ್ ಎಲ್ಲ CPCL ಕೇಳಕ್ಕಾಗಲ್ಲ. The CPC is under 227.
Please.
ಇದು 226 ಬರೀ ಕೊಡೋದಿಲ್ಲ.
The common routine practice is cultivated.
ಎಲ್ಲದರಲ್ಲೂ ಅದೇ ನೋಡ್ತಾ ಇದೀವಿ ಇಲ್ಲಿ.
226, 227.
ಒಂದ್ರಲ್ಲಿ ಯಾವ್ದೋ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟು ಕರೆಕ್ಷನ್ ಮಾಡಿದಾಯ್ತು, ಇಶ್ಯೂ ಸರ್ಶ್ಯೂರರ್ ರೈಟ್ ಟು ಕ್ವಾಶ್ ಅಂತ. We can't issue a certiorari right, it has to be set aside.
Henceforth that will be carried out. Please,
Yes.
please.
One class told.
My lord has to take more.
17, Sabil Ahmed.
My lordships, I appear for the petitioner in this case, my lordships.
Yes, sir.
9/1/2024, my lords have directed me to bring the respondents, names of the respondents in the appearing in the RTCs. I seek for a week's accommodation, my lordships. I'll take.
Counsel for the petitioner once again seeks for a short accommodation to produce the RTCs as directed. Void order date 9/1/25. If the RTCs are not produced by 13th February, adverse inference would have to be drawn. Relist on 13th February.
But
Much
of the judgment in Warner's Court, Your Lordship, they are trying to make entries. But RSA is pending, Your Lordship, before this honorable court. So till then, they cannot ask for.
RSA is
That RSA, there is no stay. Since past 4 years, it is in the stage of non-compliance of office objection, my lords.
They cannot seek
I
for
am
direction
directed to
to
implead the
against
names of the
Lordship.
parties whose names are appearing in the RTCs.
So
I'll
they have to impede
remove the
the
need.
party, Your Lordship.
They are not parties to this writ petition. You have only made the state a party.
Indeed, I was seeking only mandamus, my lordships. I am directed by
Without them being party, Mr. Abrar.
my lordships. I'll comply the orders of 9/1/25, my lordships. I'll make them as a parties within 13th February. I'll make them as a parties, my lordship.
Learned AGA accepts notice for respond number 1 to 3. If necessary application, necessary detail, if 9/1/2025 is not complied with by next date of hearing, the petition will be liable to be dismissed for non-prosecution.
Please, my lords, I'll do the need.
13th.
Much obliged, my lords.
One submission. Previous matter. The observation made shall not come in the way of the first applicant deciding my application. Dismissal of this petition, my lord, now. Allah, that
In fact, now we have observed that it has to be taken up in favorable.
Allah, dismissal in the what they should not.
The observation made in the present order shall not come in the way of the first appellate court considering the application for stay on merits.
18 Jagdish Patil.
This 2 days time, my lord. We'll file the typed copy, my lord.
Annexure K.
The relevant portion of the map, my lord, in the.
Oh, it last time, okay.
Please, please.
Counsel for the petitioner seeks for and is granted 10 days time to comply with office objection article number 52(4). If the same is not complied by 5th February, the petition will be liable to be dismissed for non-prosecution.
Please.
19 Abhishek Kalle.
It's in a suit for partition. Application has been filed under order 3 rule 2. It came to be dismissed.
43 and istond objection idave.
Petitioner is being represented by her GPA holder daughter, my lords. He herself filed the application.
43(1) to 4. 43(1) to 4 ಎಲ್ಲಿದೆಯಪ್ಪ? ಇಲ್ಲಿ. You have to comply with this. There are serious objections.
Lords, all those are relating to again the GPA holder. GPA holder herself filed the application before the trial court, who is the daughter of the petitioner. Petitioner is being represented by the GPA holder daughter, my lords. He herself filed application under order 3 rule 2, wherein petitioner is unstable and she is not well and could not attend the court proceedings for the purpose of deposing, pleading the evidence, my lords. Trial court at the stage of considering the application itself has made an observation that in fact the daughter could not have deposed, wherein taking note of the fact that she has no personal knowledge of the pleadings therein. While considering the application, lords, at that stage, the trial court could not have opined as to the.
You were born after 1976. You know, you can't have personal knowledge on the face of the document.
My lords, as regards the other pleadings, my lords, she is not well, my lords, she is immobile, and the daughter who is taking care of the old and infirm parent, my lords.
Immobile and old is different from infirm.
Lord, she is running.
Old andre commissioner can be appointed.
That is there, my lords. That provision is there. But my lords,
infirm andre adu bere.
She is even unstable, my lords. I have annexure G for a moment. My lords may peruse page number 1.
Medical certificate ಏನಿದೆ?
60, my lords. Page number 60. It is dated 13/12/2023. This is to certify that Mrs. Vijay Lakshmi Kulkarni, 68 years, female, underwent surgery for
Unable to walk, ashte, mobilization. Appoint a commissioner.
Lord, she is even unstable, my lords.
That is not what the medical certificate says.
I can even get the certificates to that effect, my lords.
You can get certificates for that. Don't manufacture things.
Absolutely not, my lords.
It is in your interest that she leads evidence, because the daughter has no knowledge, ex facie.
With regard to the partition,
Whatever she leads
partition.
evidence will not be acceptable.
Lord's notice may be issued. My matter may be disposed of.
We'll direct the court to appoint a commissioner. Idralle maadi mugisbidoಣ. You are the plaintiff.
Yes, my lords. I need not seek a stay for that matter. Lords, my only point is, she's not mentally fit. For that reason, the daughter is being leading the evidence on her behalf.
Let the commissioner be appointed. Let the commissioner give that report. Then it could be considered.
To that effect, observation may be made.
ಅದು ಇವಾಗ ಮಾಡಕ್ಕಾಗಲ್ಲ. He'll say commissioner right now.
Lords, as regards the mental state of
the commissioner will say once he starts cross-examining. The petitioner is before this court seeking for the following reliefs. In view of the proposed order to be passed, notice to respondents is dispensed with. The mother of the petitioner had filed a suit in OS number 288 of 2023 seeking for
seeking permission, permitting the GPA holder to proceed with the matter.
Partition and separate possession by declaring the partition deed dated 39/1976
amongst
to be not binding on the plaintiff's share, as also the other documents executed in pursuant thereto are not binding on the plaintiff. In the said suit, an application in IA number 2 came to be IA number
8
came to be filed by the daughter of the plaintiff seeking permission to prosecute the case on behalf of the plaintiff. The said application came to be rejected by the trial court. It's challenging the same. The petitioner is before this court. The submission of the counsel for the petitioner is that the original, their mother, petitioner is before this court. Challenging the same, the
GPA holder's
daughter, GPA holder has filed the above petition, challenging the same. The submission of Sri Abhishek L. Khaled and counsel for the petitioner is that the mother is old and has undergone a hip surgery, rendering her immobile, and as such she would not be able to attend the court to prosecute the matter. His other submission is that she is also infirm and her mental faculties are impaired, and as such she would not be able to tender proper evidence in the matter. Having gone through the medical certificate which has been produced, it is seen that the medical certificate only relates to the physical impairment on account of hip surgery and does not relate to any mental impairment. In that view of the matter, the said contention cannot be accepted as of now. Insofar as the physical impairment is concerned, the trial court could always appoint a commissioner to visit the residence of the plaintiff to record evidence, either by way of both by way of examination chief and cross-examination. For that reason, it would not be proper to permit the daughter to come on record by filing an application order 3 rule 2 to prosecute the matter. In the event of there being any mental impairment and the evidence could not be recorded properly by the commissioner, it would always be open for the petitioner to file such application as may be permissible under law, seeking for necessary reliefs. In that view of the matter, the present grounds made out as regards the application, as regards the impugned order not being sustainable, the petition stands dismissed.
Disposed of. Disposed of.
Disposed.
Disposed.
20.
Obliged.
SMS.
Please,
Court fee,
please, I have paid notes.
paid.
I have made good.
Complete address,
Yes. And so far as respond number 7 notes, I seek dispensation. Since our whereabouts are not known, even in the plaint also. It is
whereabouts.
mentioned. In the plaint also, notes it
ನೀವು
is shown.
ಕಾಸ್ಟ್ ಟೈಟ್ಲಲ್ಲಿ ಹಾಕ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
In the plaint notes, it is shown that whereabouts are not.
You are the plaintiff.
Yes.
ಅಲ್ಲೂ ಹಂಗೆ ಹೇಳಿದ್ದೀರಾ. But
ಹೌದು.
how will she be bound by it?
But insofar as notes, other LRs are already on record. And,
Other?
the other LRs, as against defendant number 2, she is the LRs. They are the legal representatives of defendant number 2.
Let counsel for the petitioner submit that the whereabouts of respondent number 7 are not known and is unable to furnish any address of the said respondent number 7. Hence, office objection at serial number 4 stands overruled at the sole risk, cost and peril of the petitioner.
Please.
Counsel for the petitioner submit that the court fee has been paid. He seeks for a week's time to comply with the other office objection. Really.
Please. Challenge is notes in respect of impugned order annexure L notes. The applications filed in notes IA 10 and 13, seeking notes for appointment of court commissioner and as well as for application under section 26 of specifically fact for rectification of exhibit P1 suit agreement. Suit is for specific performance of contract.
And why do you want a commissioner?
Please notes. In the present suit, an application was filed seeking even for the amendment of the plaint. And insofar as the suit schedule property is concerned, earlier it was 216 survey number, and it has been interchanged as 216B, 216B. An application was also filed for amendment of the plaint, and the amendment is allowed by this honorable court. At annexure M notes is the order passed by this honorable court. In page 74 notes, annexure K, in page 74, sorry. The amendment is allowed to the plaint by incorporating survey number 216B minutes. Now in the agreement itself, the survey number 216 is mentioned. The schedule in the plaint and as well as the agreement is entirely different. And sought for minutes rectification of the said document by virtue of IA 13.
Rectification of what document?
Exhibit P1 minutes, that is agreement of sale.
How can you seek for rectification of an agreement?
Insofar as minutes, the agreement is concerned, there is a joint possession minutes by
the agreement will be what it is. You can't change the agreement. Unilaterally, you can't seek for rectification.
But insofar as minutes,
if there's a mistake in the agreement, there's a mistake.
By virtue of minutes, rectification
No,
of the said
how can you rectify a contract to favor you? It's a bilateral contract between two parties. You can be only entitled to what is there in the agreement.
By virtue of that, minutes, I have sought for amendment of plaint. And the plaint has been amended.
Plaint will be allowed to be, you can write anything. You can say, Mr. Bangi owes you 2 crore of rupees and file a suit.
For that reason, minutes.
2 kilometer ಹೋಗ್ಬಿಟ್ಟು ಒಂದು suit ಹಾಕ್ಬೋದು. Not that it will succeed.
Even to verify the said fact, notes, IA 10 is filed for minutes appointment of court commissioner to rectify insofar as minutes.
Rectify an agreement.
Not for rectification. Insofar as to minutes the taluk surveyor to verify minutes the suit schedule property is concerned. Even IA 10 minutes was required to be minutes considered. Even after completion of trial, it is filed minutes. After completion of trial, the IA 10 was filed earlier. It was ordered to be considered. But insofar as minutes IA 10 is concerned,
petitioner is before this court seeking for the following reliefs. Notice to the respondents is dispensed with in view of the proposed order to be passed. A suit in OS number 294 of 2014
that is now
had been
renumbered.
filed before the senior civil judge at Ospet, which came to be renumbered as OS number 14 of 2019, seeking for specific performance. In agreement date on illa.
18/6/2013.
Agreement.
18/6/2013, my lords.
Fixing the date antapadu. Lawyer notice on 18/10/6, fixing 18/6. Where is the agreement date?
My lords, para 3, my lords. Para 3 of the amended plaint.
Date only.
18/6/2013.
Agreement of sale set to be executed. Of an agreement of sale set to be executed by respondent number 1 herein in favor of the petitioner. After trial, an application under 26 Rule 9 of the Code of Civil Procedure was filed by the petitioner plaintiff seeking for appointment of a court commissioner to visit the suit land and survey the entire suit land, fix the boundaries of the plaintiff and defendant's land, and conduct panchnama and give a detailed report with the sketch. The said application having been opposed came to be dismissed by the trial court vide its order dated. Adu IA 10 na?
IA, my lords.
26 Rule 9 is IA?
Appointment of Commissioner, IA 10, my lords.
IA 10. In a 13 yavadu?
13, my lords, section 26 of specific relief act. Rectification of exhibit P1.
Another application under IA 10. Another application IA 13 came to be filed under section 26 of the specific relief act to amend the suit document exhibit P1 as regard the schedule is concerned in respect of the description of the property. This both the application having been opposed, the trial court vide its impugned order dated 6th January 2025 dismissed the applications. It is challenging the same. The petitioner is before this court. The submission of the learned counsel for the petitioner is that there is a discrepancy in exhibit P1 marked in the said suit as regard the schedule of the property which was agreed to be sold, and it is for that reason that a commissioner is required to be appointed to determine the land in possession of the defendants and that agreed to be sold in favor of the plaintiff, and on that basis permit rectification of the agreement of sale. Having heard learned counsel for the petitioner, I have the considered opinion that the suit document being the agreement of sale, which is a contract, bilateral contract between the parties, cannot be sought to be amended and or rectified on the basis of a application filed on the basis of a commissioner report to be submitted in furtherance of the application filed by the plaintiff. The plaintiff will be bound by the contents of the agreement and the details of the property mentioned in the said agreement, and unilaterally cannot be sought to be changed by the plaintiff. Thus, the very purpose of appointment of a commissioner is being to ascertain the land allegedly agreed to be sold and thereafter rectify the agreement of sale not being permissible. I do not find any infirmity in the orders passed by the trial court. The petition making out no grounds, the petition stands dismissed.
21 Rai Kumar D. Kokakar.
876 days.
Respondent sought time to seek some instructions.
Please, Your Lordship. Last event, my lord, I sought time, my lords.
You would appear for 4 to 10.
Yes, please, my lords. I have sent my communication, but not yet received their reply, my lords. I am trying, my lords, to contact them, my lords.
Shri A.S. Patil once again seeks bond is granted 2 weeks' time.
Please, Your Lordship.
Instruction, make a submission. Relist on 13th February.
Please, Your Lordship. God bless.
22, Prithvi KS, FP Patil.
In this, Your Lordship, in current matter, I seek 1 week time, Your Lordship.
22, accepting the reasons stated in support of IA2 of 24, the documents produced by the said applications allowed, the documents produced by the petitioner is taken on record. Learned AGA seeks for and is granted. Week's time to file his affidavit in terms of the order dated 8/1/2025. Learned AGA accepts notice for respond number 3, 4,
3 to 6.
5 and 6. Registry is directed to print his name as such.
Meanwhile, my records may kindly be called.
In the meanwhile, Learned AGA is also directed to secure.
Records received.
Learned AGA submit that records have been received. Counsel for the petitioner and the other respondents are permitted to take inspection of the same at the office of the Learned AGA. Relist on 17th February.
23, Mahesh Padia.
Made up 2 applications. 3B has expired and 6 is also expired. Notice has to.
During the pendency of the above matter, respond number 3B and respond number 6 have expired. As such, IA 1, 2, 3, 4, 5 and 6 of 2025 have been filed. Issue notice on the same returnable by 20th March.
24, Vidyavati Kotushkar.
What is the amendment, madam?
My lord, this is the matter wherein CL 14 they have issued. CL 7 is there. Now demand notice is issued to collect the fee of CL 7. Your lordship disposed of the matter.
Other matters.
Adರಲ್ಲಿ amendment prayer, main prayer notice refund ಕೇಳಿದೀವಿ, but notice is not challenged. Therefore, now I made an amendment to quash the notice.
Accepting the reasons stated in support of IA 1 of 25. Being of the considered opinion that the amendment which has been sought for is necessary for properly and effectively deciding the list between the parties. IA 1 of 25 is allowed. Counsel for the petitioner is permitted to carry out necessary amendment and file amended petition.
Please.
Eli.
ಕೊಡ್ತೀನಿ.
ತಂದ್ಬಿಡ್ಬೇಕು ಇವತ್ತೇ ನೀವು ಡಿಸ್ಪೋಸ್ ಆಗೋದು. Relist on 4th February.
3rd February.
3rd February.
Please.
25, Narayan V. Yazi. Narayan V. Yazi.
Monday, Your Lordship. Monday.
Excise matter. None appears. Yes, Mr. Yaji. Monday.
Monday. The morning.
At the request of both the councils, relist on 27th.
26, Srikanti Patil.
IA 1 of 23 is allowed. Accepting, IA 1 of 24 is dismissed as not pressed.
But the revision petition, my lord. Challenging, my lord, the order passed, my lord, by the DC, my lord, at annexure E. But
You are appearing for respond number 1.
Respond number 1. Respond number
4, 6 L. Asma Makandar and Nirmala BG. They are contesting here.
but contesting are, my lord, respond number 1 and 2 and respond number 6, my lord.
2 is served.
2 is served, my lord.
Nirmala BG. Pass over Karpan Bani.
And 3 is also served, my lord.
We'll pass over Karpan Bani. You are ready?
I'm ready.
Pass over.
27, M.R. Hirematar.
Who do you want to implead?
Writ of mandamus.
Impleading application.
Application for impleading R6, the committee, the regularization committee.
Accepting the reasons stated in support of IA 1 of 25, the said applications allowed, the regularization committee is brought on record as respond number 6. Learned AGA accepts notice for respond number 6.
May kindly be
Counsel
disposed
for
of.
the petitioner to carry out necessary amendment, file amended cause title. The grievance, the order sheet, main disposal. The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the application filed by the petitioner for regularization submitted in terms of Form 57 at Annexure D on 17/1/2023 has not been considered and orders passed by respond number 5, 4. Whenever any application for regularization is submitted, then Form 57 on the Form 53 on the
Yes, my lord, the form number 50, form number 53 and 57. 3 applications are filed and all the applications are.
ಎಲ್ಲ grounds ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ. Another application, another application is not been whenever any application is filed, delete ಮಾಡಿ. Orders passed, I'll stop by respond number 4. Another application in terms of Form 53 has also been filed by the petitioner on 26/2/2015 at Annexure C, which has also not been considered by respond number 4. Whenever any applications are filed for regularization of unauthorized possession under Form 50, 53 or 57, the same is required to be considered and necessary orders passed, either allowing the regularization or rejecting the same within a reasonable period of time. Needless to say, if the order is of rejection, the same would have to be accompanied by necessary reasons. Neither of them having been done, I pass the following order. Writ petition allowed, a mandamus is issued to respondents to consider the application in Form 57 at Annexure D, Form 53 at Annexure C within
3 months.
90 days from the date of receipt of a copy of this order.
Twenty-eight, Kiran Angdi.
Please, my lords.
This
My lords.
is reading application.
Please, my lords. Earlier, this court was, this honorable court was pleased to grant an order of interim stay, thereby restraining respondent number 6 from alienating suit scheduled property, my lords. Now it has come to the notice of the petitioner that the respondent number 6 has already alienated
Hold the property to them.
in bits and pieces
On
to
IA
respondent number
2
8.
of 2024, returnable by 5th March. Since there was an order of stay, what is the earlier order?
My lords.
What is the earlier order?
Earlier order, there was an order of interim stay, thereby restraining respondent number 6 from
Since
alienating suit.
21/7/23, respondent number 6 was restrained from alienating the suit scheduled property. The alienees of respondent number 6, namely the proposed respondent number 8 to 13, would also be bound by the said order. Hence, respondent number 8 to 13 are also restrained from alienating the suit scheduled property or any part thereof, the petition scheduled property or any part thereof, till the next date of hearing.
My lords, extension of interim order.
Process fee and copy. Now we have granted, extension is of no use. They have already
No,
violated.
the earlier order.
They have already violated, they sold it.
Please, my lords.
Process fee and copies to be paid by end of day 23rd January, failing which the interim order will stand automatically vacated. 6 has sold the entire property, alva?
No, majority portion.
Majority, na?
Some part is still remaining.
Interim order earlier granted is extended till next day.
Please, my lords. Oblige.
29, Mrityunjay Tata.
You want to initiate contempt?
Yes, I had filed Millard contempt petition before the division bench. There is a
Why
direction.
before this court?
Millard, there is direction in the Millard before the division bench to make an application in the pending writ petition as the interim order passed in the present.
Where is
writ-
the order of division bench? Yes.
Lord, for purposes of road widening, property, small portion of the property was demolished without any acquisition. Lord, I have requested that, my lord, you acquire the portion of the property which you intend to, my lord, demolish for the purposes of road widening. My lord, there, the respondent authorities say will issue TDR, transfer of development rights. My lord, I request
Respond number 3.
respondent number 3.
Who appears for respond number 3?
We appear for corporation. I will submit. That's the reason is that since petitioner is participated, accepted TDR before the deputy commissioner, the procedure which was laid down we have followed.
Where is his acceptance? Acceptance document
That deputy commissioner meeting he participated before the deputy commissioner.
Signature.
That I place it before the court. And moreover, after the interim order of this honorable court, we have not touched the property belongs to the petitioner. We have other property which was for.
If there is a signature accepting TDR, everything will go.
Yes,
We'll dismiss the petition by imposing cost.
Yes, I have specifically stated.
If there is no signature,
please, that I'll
and if there is no acceptance,
please, I have taken a
your officers will be proceeded with strictly.
My specific contention to your lordship is that since they have participated and we have published in the gazette, we have given 30 days time also. No objections were received. After that, we have proceeded. That all the documents are placed before your lordship. So that we have not touched the property belongs to the petitioner. As on today, it is lying after the interim order. Remaining work we have completed. Those documents because he is participated in the proceedings before the deputy commissioner office. That also I'll place it because we have the
One ಕೆಲಸ ಮಾಡಿ ಇನ್ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಡಿ ಬಂದ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡ್ಬಿಡಿ we'll record that you have argued. Is that participation? Unless you are able to show to us that he is signed.
For that
We'll give you time.
Please.
But you are put on notice. Both of you are put on notice.
Yes. No, this
you participated, your client is in trouble by signing.
Yes.
If he has not participated, your officers are in trouble.
Yes. Please, that material.
Learned counsel for respond number 3 and 4. Submits that the petitioner had participated in the proceedings before the deputy commissioner and had agreed to receive transferable development rights (TDR) in view of the acquisition of land for widening of the road, acquisition of the property of the petitioner for widening of the road. He seeks for and is granted a week's time to place the document evidencing the consent on part of the petitioner on record. Needless to say, if such a document is placed on record, then necessary action would have to be taken against the petitioner. If no such document is placed on record, by next date of hearing, adverse inference would have to be drawn and necessary action taken against the officers of the third respondent who have sought to take possession of the petitioner illegally. Relist on 29th January.
Please.
Please.
Amended cost title.
Yes, my lord. I have amended their laws. I have amended cost title.
Counsel for the petitioner has today filed the amended cost title. Registry is directed to make necessary entry in the CIS and the same is taken on record.
My lords,
Yes, who is the?
my lord, in this
Lords, I
matter,
filed objections, my lords. I filed objections on last occasion.
Ready?
Yes.
my lord, the land of the petitioner, my lord, the respondents have entered the land of the petitioners without, my lord, finalizing their proposal, without issuing the final notification and passing any award, my lords. And your lordship may kindly come to page number 34, that what has,
Krishna Bhagya Jala Nigam.
please.
Hmm.
Now, page 34, my lords, for a moment.
Yes.
Please,
ಇದು ಮೊನ್ನೆ
my lord,
ತೋರ್ಸಿದ್ರು.
I have twofold submissions, my lords. Number one, my lords, that they have entered my land and caused a damage, my lords, without, my lord, issuing a final notification, passing any award, my lords. Then number two, my lords, that they have changed the alignment, my lord, in order to save the property of another person, my lords.
That is not under challenge before us right now. We are on
That also, my lord, I have laid a challenge, my lords.
ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
Final note, my lord,
Cannot challenge that here.
no, my lords, I have sought for declaration to declare it as, my lord,
Entering the land ಅಷ್ಟೇ ಕೇಳಿರೋದು.
please, my lord.
Mandamus directing compensation.
No, my lords, to declare the acquisition proceeding itself is this, my lords.
Have you sought?
My lord, prayer number 1,
Fourth line, my lords, change of alignment.
illegal and, my lord, contrary to.
Not challenge the acquisition notification.
No, my lords, it's only a preliminary acquisition. In the preliminary acquisition, the other person's land was there. Preliminary notification, other person's land was there. Without issuing a final notification, they have done this. After filing the writ petition, my lord, they have issued a final notification and the,
Where have you challenged the preliminary notification?
my lord, I have not challenged the preliminary notification. I've challenged, my lord, their action of entering my land, my lords, without paying the compensation.
What we said, the first portion only will deal with. Second portion you are not challenged.
My lord, in the second portion, my lord, there is no finalization, my lord, by them.
There's
Now,
no
my lord,
preliminary notification issued.
preliminary notification, everybody lands is shown. There, it is not final, my lords. After finalize,
He can't advise you. You will have to think about it. We can only say this much and leave it at that.
now another aspect, my lords, that during pendency of the, there is an order for not to precipitate the matter, my lords. During pendency, my lord, they have issued a final notification. I may have to challenge that final notification.
You are appearing for
KBGNL beneficiary of the project, my lords.
ABGNL.
Please, my lords.
Who is to issue the acquisition notification?
SLA, respondent number,
State has to issue.
state, my lords. State has to
It is
issue.
not made a party.
The deputy commissioner is a party, my lords.
Third and fourth respondent, my lords.
ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಬೇಕು ಮಿಸ್ಟರ್ ಅಲಿಕೇರಿ?
My lord, since I did not challenge the acquisition, my lord, I have not made a party, my lords.
Now you are coming to the point.
I'll file, my lord, now they have
How
issued
did
a
you
final
enter
notice.
without finalizing the acquisition?
My lords, as per my lords, tender notification. My lords, basically this project is for lifting the water from Krishna River to, my lords, supplying the water to 3 districts, Bagalkot, Koppal, Gadag, my lords.
Is the acquisition complete?
Illa, complete.
Without completion, how did you enter his land?
My lords, tender was issued.
Who asked you to issue the tender? Did he ask you to issue the tender?
Preliminary notification was issued.
Consent ಕೊಟ್ಮೇಲೆ okay, no problem.
Yes, consent ಅಲ್ಲ, joint measurement was done subsequently, and
Consent ಇಲ್ಲದೆ ನಿಮ್ joint measurement is useless, Mr. Munoli.
ಇಲ್ಲ, consent, they were present in the joint measurement.
Signature ತೋರಿಸಿ. That they are consenting for acquisition.
ಇಲ್ಲ, ಆ ತರ.
ಇದು ಪ್ರೆಸೆಂಟ್ ಅಲ್ಲಿ ಅವ್ರ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ಅವ್ರು ಇದ್ದೇ ಇರ್ತಾರೆ. ನೀವು ಇಲ್ಲೇ ಇದ್ದೀರಾ. ತಗೊಳ್ಳಿ serial number 74 ಚೇತನ್ ಮುನೋಳಿ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. He is present.
It is not so.
So show the consent.
They have received the compensation.
You have received the compensation.
My lord,
Yes, when clause is this, my lords. Clause is.
Lordship may kindly see my application seeking vacating state annexure R3, page 44, my lord.
When did you file?
Filed on 27/8/2024.
27/8. Contractor is more efficient than you.
ಇಲ್ಲ, I was about to tell that, and then
Contractor is ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದು ಏನು ಮಾಡಿಲ್ಲ ಅವ್ರು.
ಇಲ್ಲ, I have also produced the same. I have also produced along with my
Page
state.
44 may kindly be seen.
ಅವ್ರಿಗೆ ದುಡ್ಡು ಬರೋದು ಅದಕ್ಕೆ ಅವರು.
ಇಲ್ಲ, entire project is, or except this.
This 150 meters
is left, my lord. Entire project is stalled.
Page 40.
Page 44, my lord.
What is this? This is your contract.
But
Yes,
I will read one clause, my lord. This
They
is,
are not concerned with your contract.
this has been acted upon by receiving the compensation. This-
Show us the receipt.
Yes, my lord. I have produced.
ನೀವು ಇಬ್ರು ಏನೇನೋ ಕಾಂಟ್ರಾಕ್ಟ್
Annexure R4, my lord. Annexure R4. We have deposited the compensation in his account. 97, page 97.
Where is the consent?
He has received the compensation in
ನಾಳೆ
view of this
consumer
clause.
account ಅಲ್ಲಿ compensation deposit ಮಾಡಿ outline ತಗೊಂಡ್ಬಿಡಿ.
One line I will read in page 44 and I will show your lordship.
Show is consent, that's all.
But when he has agreed to receive the compensation, we have
ಅದೇ agreement ತೋರಿಸಿ ಅಂತ ಹೇಳ್ತಾ ಇರೋದು.
I will provide.
Any amount can be deposited in your account also, Ms. Nilopan.
One line I will read from page 44 and I will conclude my arguments.
That is your agreement, we are not.
Certainly, power has been given to the contractor to negotiate with the owners and to deposit the compensation.
So where is the negotiated agreement?
Our document I will. Yes.
If he has consented, produce it.
Yes.
If he is not consented, what you have done is wrong.
Thereafter, my lord, whether he has objected for depositing of the compensation is the material.
How does he know from where the money came?
ಅವ್ರಿಗೆ ಗೊತ್ತಿದ್ದ ಅವ್ರು ಕೇಳಿನೇ ಅವ್ರ ಅಕೌಂಟ್ ನಂಬರ್ ಪ್ರೊವೈಡ್ ಮಾಡಿದಾಗೆ ನಾವು ಅವರಿಗೆ we are not aware of his account number, my lord. We have produced the passbook, my lord.
Your page 44 is very interesting clause. ನೋಡಿದ್ದೀರಾ clause? How can such a clause be incorporated? What are you doing, state? Eminent domain has been transferred to a contractor. How can you do this? What do you think of yourself, KBJNL?
It is just a negotiations only, nothing else.
Eminent domain cannot be exercised even by you, it is only by the state. And you are transferring the thing to the contractor to write roughshod or constitutional right.
Not, we have stated only after negotiations only you can do the work and nothing else. We are not stated, my lords, you go and do this. Only after negotiation and other things only. We are straight away we have not given them any powers, my lords. Wherever there is no, my lords, acquisition, finalized, my lords, process of acquisition, there you negotiate and you do the work.
Need the chief secretary's affidavit on this. No less. This cannot be done like this. You want to give rise to a Gunda's culture by doing all this? They will write roughshod over everybody.
Certainly not.
That is why the safeguards in the acquisition proceedings. At no cost to KBJNL, in case of any obstruction from the landowner during the construction period or during the maintenance period referred to in so and so, contractor has to make his own arrangement to get the dispute settled and to bear the extra cost. What kind of a clause is this?
After negotiations that we have.
Who are they to negotiate? You are also not authorized. You are directing them and they are going under this clause. Only the SLO can do it. This is a shocking case, told, where a work order has been issued by the Krishna Bhagya Jala Nigam Limited to a contractor to carry out various works stated therein. The grievance of the petitioner is that without acquiring the property of the petitioner, the contractor has illegally entered upon the land of the petitioner and carried out excavation work. Sri Arjunilopan, learned counsel for the contractor, would submit that the actions taken by the contractor are in pursuance of the work order, aforesaid work order dated 9/12/2019, and places reliance on the additional and clause 1 of the additional conditions of contract, which reads as under. His submission is that the KBJNL has authorized the contractor to enter the lands and carry out the works by negotiating with the landowner. And as such, the contractor has negotiated with the landowner and deposited the compensation amount in the bank account of the landowner. No document evidencing consent of the landowner has been produced, except to state that the landowner had furnished the bank account details wherein the amounts have been deposited. The perusal of the aforesaid clause 1 of the additional condition of contract would indicate the shocking manner in which the KBGNL has acted. Wherein it is stated that if any or all of the lands required for the work are yet to be acquired by KBGNL, it shall be the responsibility of the contractor to obtain possession of such lands from forest authorities, stroke LAQ authorities, stroke MOEF clearances, stroke landowner by negotiation between him and the contractor at no extra cost to the KBGNL. Para. The power of eminent domain is required to be exercised only by the state. In the present case, the KBGNL has sought to contend as if that it is acquiring the land when it has no power to do so, and has further authorized a private contractor under a work order to negotiate for acquisition of the land, which is completely impermissible. This would require necessary action to be initiated against the concerned. The Chief Secretary, Government of Karnataka, is directed to look into the same and submit a report as to whether KBJNL is authorized to do so. If not, what action is proposed to be taken against the concerned office of the KBJNL and the contractor. You are also not going away.
I pursuant to this.
You should be aware of law and not ride roughshod. Admittedly, acquisition not having been completed insofar as the land of the petitioner is concerned, and no consent having been produced by the respondents on part of the petitioner, the action taken by the respondents in entering upon the land of the petitioner and carrying out excavation work is completely illegal. The jurisdictional ADLR is directed to carry out a survey of the property of the petitioner and submit a report as regards the extent of excavation carried out, so as to enable this court to determine the compensation liable to be paid to the petitioner on account of such illegal actions. Survey to be carried out commencing from 28 January at 10:30 p.m. The petitioner and or the respondents are permitted to participate in the said survey. There will be no requirement of issuing any fresh notice to them. In the event of they not participating, they will not be entitled for any equities. Affidavit of the Chief Secretary to be filed on or before 4th February, released on 4th February. Interim order earlier granted is extended till next date.
31 is Chaklabbi.
Lord, I pay for the respondent number 1. I have filed, Lord, I have for vacating of interim.
Ready for merits?
Yes. Please.
ಹೇಳಿ.
The petitioner has filed this petition seeking to set aside the order passed by the trial court, wherein my application under order 6 rule 17 came to be rejected.
6 rule 17.
Please, Lord.
ಅದ್ರಲ್ಲಿ 1 rule 10 ಅಂತ ಬರ್ದಿದ್ದೀರಾ?
But two applications.
Two applications. And ಇನ್ನೊಂದು connected matter 1 rule 10 ಇದೆ ಸ್ವಾಮಿ.
Connected ಇದೆ.
31 ಇನ್ನೊಂದು. 6 rule 17 and 1 rule 10
Suit for?
Suit for partition and separate possession filed by the present petitioner against his adopted father, Lord. The respondent number 1 is the adopted father of present petitioner. He has filed a suit for partition before the Hunugund court. After issuance of notice, both the parties have appeared before the trial court and filed their written statement. In the meantime, with the assistance and suggestion of the elders, the present petitioner has filed a memo, Lord. The memo at page number 73.
72.
In
Yes.
73, please. Wherein the adopted father has sold one of the property bearing survey number 30/1, 6 acres 27 gunta, without the consent of the present petitioner. The purchaser and the villagers have suggested the present petitioner to settle the matter. We will give his share if the petitioner has filed, withdraw the allegation in respect of defendant number 2, that is purchaser loss. Thereafter, the present petitioner has filed a memo. After filing up the memo is filed on 24/11/2022.
ನಾನು ಮೇಲ್ಗಣಿಸೋ ಈ ಆಸ್ತಿ ದಿನಾಂಕ ಸೋಂಸರಂದು 1ನೇ ಪ್ರತಿವಾದಿ 2ನೇ ಪ್ರತಿವಾದಿ ಹೆಸರಿಗೆ ಮಾನ್ಯ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಇಲಾಖೆ ಸೋಂಸರಂದು ಇನ್ನು ಮುಂದೆ ಸದರಿ ಆಸ್ತಿ ನನ್ನದು. So you gave up your right on the half share?
Yes, Lord.
For me, for 49,50,000?
No. It is a consideration amount which has been sold
so
by
half
the
share of that?
Yes, Lord.
So you'll have to get 24,75,000?
Yes.
ಬಂದಿದ್ಯಾ?
No, Lord. Therefore,
Kavira.
I have filed an application seeking
Harmonious.
amendment. Complete Martin. Therefore, when they have not complied the order of this honorable court, I have filed an application seeking amendment to add the present property as a suit property.
This is the memo filed.
Please, Lord.
What is the order on this memo?
Please, Lord. The court has passed an order. I have produced the order sheet. Memo allowed at page number 84, Lords.
Memo is allowed as plaintiff has to amend the plaint andre?
Alla, illide first. Defendant counsel state no objection to memo dated 24/11/2022. Hence, suit against defendant number 2 is hereby dismissed. And second, and the same memo again on 21/2023, the memo is allowed. Hence, the plaintiff has to amend the plaint.
By deleting that?
Defendant, please.
By deleting defendant number 2?
Defendant number 2 as well as the suit
deleting
property.
the property.
Please. Thereafter, I have filed an, though I have several times I requested the present defendant, defendant number 2, he is not a party to the this petition, he is a party to the second petition. Several times I have requested and they have not come forwarded. I have filed an application seeking amendment to my plaint, requesting the honorable court to permit the present petitioner to add the property
and implead him back.
Impleading in on the application file.
Reverse.
Please, Lord. That the court has held that once the very plaintiff has withdrawn his claim against the respondent number 2, it is not permissible under section 115 of Evidence Act. Therefore, my application came to be rejected. That's it. For a moment, kindly see my affidavit at page number 101.
Have you paid the money?
Your Lordship, what has happened? Lord, now, Lord, kindly see, Lord, his prayer in the plaint. Lord, he sought for partition separate position, first prayer, Lordship, and second prayer, Lordship, for seeking, Lord, saying that, Lord, whatever the sale transaction between defendant number 1 and 2 is not binding on him, my Lordship. And he made, my Lord, annexure B a suit schedule
Have
B
you
and
paid
C.
the money?
Yes, my lord. The money is paid, but that is not
24
on the
lakh
record.
75,000.
That is, that transaction is taken place between the defendant number 2 and
Where is the
plaintiff.
proof of payment?
Plaintiff number 2 and, my Lord,
Then he skipped.
the defendant number 2 and the plaintiff.
Proof of payment kodi yaar kotre ಏನಂತೆ?
None instruction though. I'll take instructions on that, my Lord.
Produce the proof.
Allala.
We'll dismiss this petition. If you don't produce the proof, we'll allow the petition. That's all. You can't take advantage of both.
Please. Lord, I am not taking advantage. He is the
Please, my-
plaintiff.
one more
Allala, one
submission.
second.
One more
He is the
submission. Wait.
plaintiff and he filed, my Lord, suit by making, my Lord, defendant number 1 and 2
He
as a
filed a
part.
memo to which you said no objection. That is why the memo was allowed. The contents of the memo indicate that it is settled.
Please.
Did not object to the memo. You said
ಅಲ್ಲ
no
ಅವರು
objection.
ಅದರಲ್ಲಿ ಅವರು ಕ್ಲೇಮ್ ಬಿಡ್ತಾನೆ ಅಂತಂದ್ರೆ ನಾನು ಹೆಂಗೆ
ಅಲ್ಲ ಅದು ರಾಜಿ ಆಗಿದೆ ಅಂತ ಬಿಟ್ಟಿದ್ದೀರಿ ಹಂಗೆ ಬಿಟ್ಟಿದ್ದಲ್ಲ.
ನೋ ನೋ
If you continue like that, you will be in more trouble. Your conduct will be reflected in the order.
I'll take instructions.
ಇವಾಗೇನ್ ಸಬ್ಮಿಷನ್ ಇವಾಗ ಪೇಡ್ ಅಂತ ತಗೊಳೋಣ ಇಲ್ಲ ನಾಟ್ ಪೇಡ್?
ಇಲ್ಲ ಇಲ್ಲ ಅದ್ರ ನನಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ನನಗೆ.
ಏನು ಇಲ್ಲ ಅಂತ.
ಹೌದು.
Learned counsel for respond number 2.
I for the defendant number 1, respond number 1.
Respond 1 and 2 ತಾನೆ.
Defendant.
ನೀವು ಅವ್ರ ಮೇಲೆ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಅವ್ರು ಇವ್ರ ಮೇಲೆ ನಿಮ್ಮ ಮೇಲೆ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ಇಲ್ಲ ಅವರು ಡಿಫೆಂಡ್
Collected
ನಂಬರ್ 2 ಗೆ
petition
ಅಪೇರ್
ಅಲ್ಲಿ
ಆಗ್ತಾರೆ.
ಅವರಿದ್ದಾರೆ. First
ನಾನು
petition
ಡಿಫೆಂಡ್
ಅಲ್ಲಿ
ನಂಬರ್ 1
ಒಬ್ರು
ಗೆ
ಇದ್ದಾರೆ.
ಅಪೇರ್ ಆಗ್ತೀನಿ.
The respective counsels for respond number 1 and 2 seek for and are granted a week's time to place on record any document evidencing the payment of the amounts as detailed in the memo produced at Annexure D to WP number 106024 of 2024, namely an amount of rupees 24,75,000 to the petitioner. If no document is placed on record by next date of hearing, adverse inference would have to be drawn and the matter proceeded with. Relist on 5th March, 5th February.
One more submission. Consideration amount is only 48 lakh lots. The sale amount has rupees 6 crores.
You can go only by your memo.
Please, please.
Interim order earlier granted is extended. Who do you want to implead, Mr. Kulkarni?
Petitioner is a student of law. He took admission in university, law university. He passed 3 examinations, 3 semesters. For 4th semester, he was not allowed on the ground of shortage of attendance. So he got readmitted for 3rd semester. Then he met with an accident. There also he could not comply. Thereafter, he took transfer from that university to other college.
The attendance was easier.
Please. Annexure C is the transfer order.
Your bar council, who is the standing council?
Bar council ಯಾರು ಇಲ್ಲ. For Raja Rakmangouda, Gangadhar Vaskeri is appears.
ಬೆಂಗಳೂರಲ್ಲಿ ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ?
ಶ್ರೀಧರ್ ಪ್ರಭು ಇದ್ರು ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ.
ಅವರಿಲ್ಲ, ಇವಾಗ ಒಂದು ಲೇಡಿ ಇದ್ದಾರೆ. Ms. So-and-so is directed to accept notice for proposed respond number 3.
Gangadhar Vaskeri.
Gangadhar Vaskeri is directed to accept notice for respond number 4. Counsel for the petitioner to serve 2 sets of the petition along with the annexures as also the application IA 1 of 24 on the said counsels. Relist on 13th February.
Earlier.
ನಿಮ್ಮ ಬಾರ್ ಕೌನ್ಸಿಲ್ ಇಂದ ಏನೂ ಬರಲ್ಲ ಅಲ್ಲಿ.
And the difficulty is, but while giving transfer, the directed petitioner to pass additional 2 subjects. He passed. Now entire course is completed.
6th February. ಅದು ಹೆಸರು ಕೇಳ್ಬಿಟ್ಟು ಕೊಡಿ ಬೆಂಗಳೂರಲ್ಲಿ.
33 Nirmala Bani.
From the proxy counsel appearing on behalf of Nirmala Bani.
Accepting the reasons stated in support of IA 1 of 24, the production of original copy of Annexure N is dispensed with. B and N. N type copy ಬೇರೆ. A perusal of annexure B and N indicates that the same are not legible, hence IA 2 of 24 is dismissed. Counsel for the petitioner is directed to produce type copy of annexure B and N. Notice ಯಾವ್ದು ಹೋಗಿದೆ?
15-1.
ಇವರೇ ಇದ್ದಾರೆ. And AGA accepts notice for respond number 1 and 2. Administrator APMC no ನೀವೇ ತಾನೆ?
No, man.
Administrator.
I will take notes. For director, the government will take note. Three
Administrator
and 4, I will take notes.
So also accept notice for respond number 3 and 4. Counsel for the petitioner to furnish 2 sets of the petition along with
And
annexures.
petition is not maintainable because earlier my lord has passed.
Proxy counsel. Relist on ಯಾವ್ದು ಬರ್ತಾರೆ?
Next week.
Relist on 29th January.
My lord has passed an order in this matter. They have withdrawn the
prayer, let us not proxy counsel.
Please.
34, Sabil Ahmed.
Lordships, I appear for the petitioner in this matter, my lordships. Notices are served on the
Respondent
respondent.
number 4. It's identical matter is Muller's listing on Muller's 30th. Wherein also identical matter is Muller's listing on 30th.
They're listed on 30th.
Muller's the counsel for the petitioner who is appearing here Muller's was Muller's day before yesterday. There was a matter Muller's against the corporation. It was listed on 30th. Same matter. Same.
Connect with WP number.
Muller's I'll furnish.
Also on relist on 30th.
Interim order may be extended, my lords.
Interim order earlier granted the extent till next date of hearing.
Much obliged.
Accepting the reasons stated in support of IA 1, production certified copy of annexure B is dispensed.
My lord,
Much
since SS Chalwal is appearing for R4, my lord, kindly name of CVND may be deleted.
Since Shri SS Chalwadi has entered appearance for respond number 4, registry that delete the name of Shri CV Angdi as that appearing for respond number 4.
35, Sadiq Goodwal.
Accepting the reasons stated in support of IA 1 of 24, the production of certified copy of annexure F is dispensed with. Yes.
Let's I have recently filed wakalat malats. Copy iskobe.
Copy ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಡ್ತೀನಿ. I have given.
Counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures to the counsel for respond by end of day tomorrow. Counsel for respond seeks for a week's time to obtain instruction, make a submission. Relist on 30th.
Please, ma'am.
36, PM Nada, Gayatri Esther.
Appear for petitioner, my lords.
Yes.
Let's property of the father of the petitioner herein was acquired for the BTDA. Pursuant to which, my lords, A category site was allotted to the petitioner herein, my lords. Later on, we submitted a representation seeking C category of sites, my lords. That was not considered. The petitioner herein approached this honorable court, my lords, wherein that matter was settled before the Lok Adalat, my lords, pursuant to which the BTDA has directed me to deposit 13,000 rupees, my lords, 13,900, to which I have deposited for allotment of C category site, my lords. Now they are not issuing the Hakkupatra, my lords. After taking the deposit amount,
Consider, my lord.
let's, we are,
ಅದು ಕನ್ಸಿಡರೇಷನ್ ನಡೀತಾನೆ ಇದೆ 1 ವರ್ಷ ಆಯ್ತು. ಅದು ಕನ್ಸಿಡರೇಷನ್ 1 ವರ್ಷ ಅಲ್ಲ 3 ವರ್ಷ ಆಯ್ತು.
My lord.
Then why do you come before the local Adalat and say you'll consider and pass orders?
He consider.
allotment is already made, my lords.
Directions
Hakkupatra needs to be
given, my
issued.
lord. Because they all deposited, my lord.
There is no representation to consider the representation. We are seeking positive mandamus.
Positive mandamus with observations
Please.
Please, my lord.
against the conduct of respondent. ಲೋಕ ಅದಾಲತ್ ಆದ್ಮೇಲೆ 3 ತಿಂಗಳಲ್ಲಿ ಮುಗಿಸ್ಬೇಕು.
Yes, my lord. It's our mistake, my lord.
Petitioner is before this court seeking for the following reliefs. The petitioner property was acquired by the Bagalkot Town Development Authority for the purpose of the Upper Krishna project in the year 95-96. Pursuant to which a category site was allotted. The petitioner on 16/8/22 had submitted a representation to allot a C category site. The same not having been considered, the petitioner had approached this court by filing WP number 102025 of 2023, which came to be referred to the Lok Adalat, where the matter was settled with the respondents agreeing to consider the representation within a period of 6 weeks. Post the disposal of the matter before the Lok Adalat, on 19/1/2024, another representation was submitted by the petitioner. Pursuant thereto, on 4/9/24, an intimation letter was issued by the respondents that a C category plot had been allotted, calling upon the petitioner to deposit a sum of rupees 13,680 within 15 days, which came to be deposited on the very same day. Thereafter, no action having been taken, the petitioner is before this court seeking
That's
for.
one more submission, Mulats. That Hakkupatra needs to be issued in terms of Annexure E, wherein they have passed a resolution in 122nd board. The
Thereafter,
allotment date
though a
shall be.
resolution had been passed on
Let's date.
6/11/15.
6 November 2015. In
15,
terms of that,
2015.
Mulats, this
7/20/15.
allotment has to be dated
Yadu
earlier
earlier.
date. Please, Mulats.
Thereafter, no action has been taken, even though a resolution had been passed way back on 6 November 2015 as per Annexure E.
Let's,
Para. It is rather shocking that after the matter was settled before the Lok Adalat, the respondents have taken such a long time, having undertaken to consider the representation within 6 weeks from 9/12/2023. It is only on 4/9/2024 that an intimation was issued by the respondents after a gap of nearly 1 year. And despite the deposit having been made on 4/9/24, the allotment is not completed and necessary sale deed executed. Lease cum sale, sale.
lease cum sale deed.
Lease cum sale deed not executed in favor of the petitioner. The respondent by the above have completely sought to set at naught the settlement process before the Lok Adalat, having agreed to consider the representation within 6 weeks. It was expected of the respondents to do so within that time and complete the process. Even after settlement before the Lok Adalat on 9/12/2023, the process is not completed as on date. In that view of the matter, I pass the following order. Writ petition is allowed. A mandamus is issued directing respondent number 1 and 2 to issue the necessary Akkapatra in terms of the intimation letter dated 4/9/24 and the resolution dated 6/11/2015 within a period of 3 weeks from date of receipt of
4 weeks.
this order, though cost could be imposed on the respondents. ಯಾಕೆ impose ಮಾಡೋಣ, ಆಗ್ಲಾರ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮಾಡ್ತೀರ. ನಾವು ಬಿಡ್ತೀವಿ ಅಂತ respondent number 2, respondent number 1 and 2 are directed to deposit cost of rupees 2,500 each to the advocates clerks so and so within a period of 2 weeks for having taken an inordinately long time to comply with the undertaking given before the Lok Adalat.
37 Manjunath Jadai.
Lords, I am challenging the order of the Annexure D, my lords, which have filed an application under order 1.
Suit for Nivaro.
Suit for partition and separate possession, my lords.
And you
I
are?
am the plaintiff in this suit, my lords. And I have filed an application under order 1, rule 10 of 2, my lords. to implement the proposed defendants.
Who are they?
They are the purchaser of the lands, my lords, of the item number C and D, my lords,
Sale
which
deeds
is I
are
have filed the annexure A, my lords, page number 9, my lords, of plaint, my lords. And page number 14 is the schedule C and schedule D, my lords. They are the purchaser, my lords. And this is the suit is for the ancestral and joint family properties, my lords. To adjudicate the proposed defendants are necessary, my lords. And
They objected to.
they objected, my lords.
Now they can't take any other ground
No, my lords.
in the FDP. If you allow them to come, they'll take lot of grounds, delaying the matter.
They suggested that in the FDP proceedings, they can be allowed as a defendants, my lords.
If they objected now to come on record, they cannot take any defense in the FDP. It's in your benefit.
Yes, my lords.
ಅದನ್ನ ಯಾಕೆ challenge ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
One of the defendants has been already died, my lords, and only single person, my lords, to adjudicate the proceedings.
They are opposing. They won't have any defense left in the FDP. Why do you want to bring them on record and stay your proceedings? You will delay your thing.
No, my lords, they are necessary parties to adjudicate the proceedings, my
They are
lords.
not necessary. Issue notice to the respondents returnable by 25th March. The further proceedings in OS number
215 of
2015 pending on the file of the additional civil judge in JMFC. Gangavati is stayed till the next date of hearing. Issue notice. ಅವ್ರನ್ನೂ ಮಾಡಿದ್ದೀರಾ ಇಲ್ಲಿ?
Yes, my lords.
Impeding. Proposed defendant ಎಲ್ಲಿ ಮಾಡಿದ್ದೀರಾ?
Proposed defendants have not filed.
ಅವ್ರನ್ನ ತಾನೇ ಮಾಡ್ಬೇಕು ನೀವು ಇಲ್ಲಿ.
ಅವ್ರನ್ನ ಮಾಡಿಲ್ಲ, my lords.
ಹೊಡೆದಾಕಿ. Counsel for the petitioner seeks for and is granted a week's time to file. But issue notice to the respondent same, as also to the persons named in IA 9 filed in OS number 215 of 2015 at annexure C to the above petition, returnable by 25th March.
Stay maybe, guys. Stay maybe.
Stay ಕೂತಿದ್ದೀವಿ.
Please.
It's ನಿಮ್ಮ goes against you.
38, Sabilamat.
My lordships, I appear for the petitioners, my lordships. In 38, no notice is ordered, but in connected matter, notice was ordered and respondent number 5 is reported dead, my lordships. My lordship, I may be permitted to take out steps in both the petitions in 38 and 38.1, my lordships.
Issue notice to the respondents. Returnable by 25th March. 38.1. Issue notice, counsel. You have to take.
I have to take steps in for disease R5, my lordships. I'll take steps.
What steps? You have to file application first.
I have to file application to bring his LRs on record.
Counsel for the petitioner is granted 3 weeks time to file necessary application to bring the deceased, legal opinion deceased respond number 5 on record. 38.2.
38.2.
Yeah,
In this case, my lordships, I had sought for the copy I have sought for the certified copies of records in OS number.
38.2. Standing counsel. Who is the standing counsel for the respondents?
Respondent number 1 is Shri Jagdish Patil, my lordships. Senior counsel Jagdish Patil.
Accept notice for respondent number
1 as well as 2 and 3, my lords.
Registry is direct, print his name as such. Counsel for the petition furnish 2 sets of the petition along with annexures on the
Much
same
obliged.
counsel, released on 25th March.
Much obliged.
39, KL Patil.
petitioner is allotted with a site by the respond number 2, my lords. And the same came to be cancelled by order dated 18/11, sorry, 8/6/2004, my lords, which was not
Buddha Yaro.
Buddha.
M.A. Hulyar.
Hulyar, Sheikh, last occasion, Dr. Sheikh, S.B. Sheikh appeared in this matter.
Learned AG accepts notice for respond number 1. Shri S.B. Sheikh is directed to accept notice for respond number 2. Counsel for the petition serve 2 sets of the petition along with annexure set counsel.
Not for interim order to stay the
Stay of VNO.
annexure K, my lords, order dated 27/11/24.
The response are your cancellation.
Please,
On what ground was it cancelled?
since we have not constructed the building within 3 years from the data.
Not constructed. The operation of the order bearing so and so dated 27/11/24 at annexure K. Please state till the next date of hearing.
40, Anandar Kolli.
We are written the nature of mandamus directing the respond number 2 and 3 to delete the name of the petitioners and to rectify the. So the petitioners are the landowners. It is covered by judgment of this honorable court.
Unless he question the entry, your lordship, he cannot seek for direction.
Column number 9 and 11. Mads.
Delete somebody's entry.
Unless he question that entry, your lordship, he cannot seek for direction. The next, see, it is the prayer made, your lordship.
Cannot be covered by any judgment. No
They are
judgment.
relying upon court, in that also quashing is sought for, but in this only mandamus sought.
Annexure D is the. Mads.
Are hereby quashed ಅದರಲ್ಲಿ ಇಲ್ಲಿ ಬರೀ mandamus ಕೇಳಿದ್ದೀರಾ?
Yes.
ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು we'll have to pass orders.
Yes.
You have not made them parties also.
ಬೋರ್ಡ್ ಆಫ್ ವರ್ಕ್ ಮಾಡಿದ್ದಾರೆ.
Board party ಇದೆ. Respond number 4 is work board matters. B. Mohammed Ali is directed to take notice for R4.
Board ಮಾಡಿದ್ದಾರೆ.
Yes, ma'am.
Delete the name of Syed Peer Makkum Sudi ಅಂತ ಹೇಳಿದ್ದೀರಾ?
Work property. ಅವ್ರ ಹೆಸರು ಕೂಡಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Waqf has to be made a party.
ಅಲ್ಲ ಬೋರ್ಡ್ ಇದೆ matters. Respond number 4 is the work board.
But ನಿಮ್ prayer ಅಲ್ಲಿ ನೋಡಿ in the name of Syed Peer Makkum Sudi ಅಂತಿದೆ.
ಅದು ಆ ಪ್ರಾಪರ್ಟಿ ಆ ಮಕಾನ್ ಸುಡಿ ಅಂತೇಳಿ ಆ ಪ್ರಾಪರ್ಟಿ ಹೆಸರು ಕೂಡಿಸಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ RTC?
ದರ್ಗಾದ ಹೆಸರು ಅದಕ್ಕೆ ಕೂಡಿಸಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ದರ್ಗಾ ಹೆಸರು.
ಹೌದು. ಪೇಜ್ ನಂಬರ್ 14 minutes. Syed Peer Makan Sudi.
ಯಾವಾಗ ಎಂಟ್ರಿ ಮಾಡಿರೋದು ಇದು?
2023-24
ಡಿಲೀಟ್ ಮಾಡಕ್ಕೆ ಕೇಳಿದಾರಲ್ಲ. And AG accepts notice for respond number 1 to 3. 4 ಯಾರು?
B. Mohammed Ali minutes.
So and so is direct to accept notice for respond number 4. Counsel for the petition furnished 2 sets of the petition along with annexures on the said counsel released on 30th.
For preliminary.
41, Anil Kale.
Two.
Appear for respond number 2. Minutes. I'll collect the petition paper from him and make submissions. Minutes.
I'll furnish not today.
Counsel for the petitioner undertakes to furnish 2 sets of the petition along with annexures on the counsel for respondent by end of day tomorrow. Released on 30th.
Yes.
42, NL Batkurki.
Direction is, award is passed in 2022. Till today, they are not ready to pay the compensation amount. Though they have issued a
37-2
notice under section 37-2 of Act, my lord.
ಅವ್ರಿಗೆ ಬೇಡ ಅಂತ ಲ್ಯಾಂಡ್ ಕೊಟ್ಬಿಡ್ತಾರೆ.
Submerge.
Submerge. ನೀರು ತೆಗೆದುಬಿಟ್ಟು ಕೊಡ್ತಾರೆ. And AG accepts notice for respondents. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that though The final notification had been published.
Award is
The
passed on
section
5th.
19 bracket 1 under the Right to Fair Compensation so and so Act 2013 on 16/4/2021, and award, general award was passed
Yes,
on 1/6/2022.
15/6/2020.
15/6/2022.
Award is passed on 15/6/2022.
One and 15/6/2022, 13/6/2022. And notice under section 37 of the act had been issued. The compensation has not yet been paid to the petitioner.
So that is the award dated 15/6/2022.
13/6 award.
14/7/2022 is 13/7/2 notice is
7
issued.
is 30, this
19/7/2022 at the bottom.
19/7
2022 issued on.
notice under 37 on 13
ಅಲ್ಲ 19/7/2020
7
2022 ಇಲ್ಲಿದೆ date
2022. Hence, the petitioner submitted a representation on 18/7/2024, which has not been acted upon. When an award has been passed on 13/6/2022, and notice under section 37 was also issued in that year, the lands having been submerged and not being available for use to the petitioner, it was but required for the respondent to make payment of the compensation amounts at the earliest. The same not having been done, I pass the following order. Writ petition is allowed, a mandamus is issued directing respondent number 4 to make payment of compensation within a week in terms of the general award dated 13/6/2022 and in terms of the relevant provision of the Right to Fair Compensation Act, as also interest on the said amount for delayed payment within a period of
4 weeks.
4 weeks from the date of receipt for a copy of this order. In the event of the aforesaid amounts not being paid by that time, the respondent shall be liable to make payment of interest at the rate of 24% per annum
Thereafter.
thereafter. Thereafter, ಹೇಳಲ್ಲ, ಅಲ್ಲಿಂದ ಮಾಡಬೇಕು. Thereafter, till the date of, calculated from within 4 weeks, that is on or before 27th February. If the same is not paid by 27th February, respondent would be liable to make payment of interest at the rate of 24% thereon, calculated from 27th February till the date of actual receipt by the petitioner.
43, Irangouda, Kapoor.
Please, my lords. Suit for partition, my lords. The I under 500, under order 23 rule 1, with kind permission, I may be permitted to file the memo along with the I. The annexure C, it has been the different I which has been filed. I under 39 rule 1 and 2 has been filed. The I. The suit for partition.
Fresh suit. And what is the ground?
On the ground that there is some technical grounds. The order is at, my lords, is at page number.
Only 2 grounds. Some of the defendants are dead and some of the properties
Please,
are
my
not
lords.
included. You can file a application to bring the legal heirs and to amend.
I am for the defendants. That application came to be allowed. Page number.
With liberty.
Please, my lords. That is being challenged.
Issue notice to the respondents.
Number 1 to 4.
1 to 4.
And
returnable by 18th March. Notice to respond number
4 to 42 may be
42.
dispensed. 42 minus.
42 is dispensed with at the request of counsel for the petitioner since they are co-defendants. Further proceedings. The order.
I sought that the operation of
dated 10/12/2024 passed in OS number 282 of 2022 at annexure E is stayed till the next date of hearing. Counsel for the petitioner is also directed to serve the counsel for the respondents 1 to 4 in OS number who had appeared.
Please, matters.
In OS number so and so and file acknowledgement thereof by January.
Please, matters.
Process fee and copies to be furnished by end of day 23rd January. Failing either of which, the interim order will stand automatically vacated.
My turn.
44, HM Dharwad.
for the petitioner.
This is a third round of litigation, my lord. The property of,
ನೀವಿದ್ದಾಗ fourth round ಆಗ್ಲೇಬೇಕು.
the property of the petitioner acquired by the, my lord, the CMC, my lord, in the year 1965, 1,494 square feet for formation of road.
Lord, AGA accepts notice for respond number 1. Respond number 2 ಯಾರು?
Gurudev Gachinmat is.
Shri Gurudev Gachinmat is directed to accept notice for respond number 2. Counsel for the petitioner served 2 sets of the petition along with annexures and said counsel released on 4th February.
Please.
45, Vinay Kumar.
My lord, the petitioner is the absolute owner of survey number 16/2 1B, my lord. Wherein, my lord, I made a representation, my lord, before the respondent number 3 to consider my representation, my lord. My lord, hence, my lord, the petitioner is seeking the mandamus in the nature of mandamus directing the respondents to consider my representation, my lord.
NHA ಏನಕ್ಕೆ ಮಾಡಿದಿರಾ?
My lords, now the record of rights in the column number 9, the record of rights in the name of National Highway, my lords. Without acquiring the petitioner land, my lord, they are.
Annexer C, your lordship, make annexer C, annexer D make and less, your lordship. In that, your lordship, the land, your lordship, by virtue of the mutation entry, name of National Highway Authority entered. In the annexer C also, your lordship, it is stated, page number 9, your lordship, mutation MR number H97/2013 foot, unless you challenge that order before the concerned authority.
Here, my
He is
lords,
not entered for any leaves, your lordship.
How can you?
if your lordship may peruse annexure E at page number 29, my lords, the respondent number 1 clearly says that my petition land is not acquired by the National Highway. These are the survey numbers, my lords, in column number 1, 16(1), 16(2), 16. These are lands, my lords. These are the petitioner neighboring lands, my lords. These are lands which are acquired by the National Highway. Petition land is not acquired by the National Highway. He clearly reveals in the annexure E, my lords.
Shri Shivsai Patil is directed to accept notice for respond number 2. Lord, AGA accepts notice for respond number 1, 3 and 4. Counsel for the petitioner to furnish 2 sets of the petition along with annexure and said counsels released on 5th February.
Please.
Lord, AGA and
Only 3 and 4, your lordship. I am 3 and 4.
SLO 1.
That is 1, your lordship, National Highway.
National Highway, my lords.
ಅವ್ರೇ ಅಪೇರ್ ಆಗ್ತಾರ, ನೀವು ಅಪೇರ್ ಆಗ್ಬೇಕಲ್ಲ. State.
SLO correct. Yes, 1, 3 and 4.
Learned AGA and the counsel for the national NHA are directed to obtain instruction, make their submission as to whether the land of the petitioner has been acquired for the benefit of NHA or not.
Please. In the meanwhile, lordship, let him produce the mutation entry as per annexer C, lordship.
ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮ್ ಇದು. 3A ನೋಟಿಫಿಕೇಶನ್ ಏನೂ ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ. ಆ ಬೇಸಿಸ್ ಮೇಲೆ ಎಲ್ಲ RTCL ಎಂಟ್ರಿ ಮಾಡ್ತಾರೆ.
MR number ಪ್ರಕಾರ ಎಂಟ್ರಿ ಆಗಿದೆ ಅಲ್ಲಿ. I think
SLO ಕೊಟ್ಟು
according to his main contention in the petition, he is residing at Bangalore, it is the enter. So lordship behind.
ಇವತ್ತಿದೆ ಅಲ್ಲ, ನೋಡೋಣ ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗ. 3A notices, notification is defective.
Please, madam.
Section 47, PG Mogali.
Yes, Mr. Mogali.
But the order passed by the AC and DC challenge. The grandfather of the petitioner abroad had certain children. Annexure G page 30.
Asking for stay of 2018 order.
Yes, my lord. Mutation entry without notice, my lord, the mutation entry expected. There is a will, my lord, in favor of petitioner.
Waited for 7 years, you can wait for 2 months. And AGA accepts notice for respond number 1 to 3. Issue emergent notice to respond number 4. Returnable by 25th February.
For limited period, because there's the respondent, what happened, they entered into compromise without behind my back in the writ petition.
We don't know what has happened for last 7 years. Let us get their details. But a recent order, we would have stayed. 7 years, Admiral, we can't stay.
48, I.I. Jalgar.
Petitioner.
Yes.
See, senior is appearing. Senior is.
Yeah.
Rajesh Mahadev.
48.
Automatic ಬರ್ತಾ ಇಲ್ವಾ?
Lord,
Yes.
Lord, I am appearing for the petitioners in this case.
Yes.
Lord, here, Lord, the one Fakirappa Galigi, Lord, is the owner of the property, Lord. Lord, I have entered into an agreement to sell with his children and to buy half share of Lord RS number 107, Lord. And Lord, I had filed a suit, Lord, OS number 72 of 2011 for specific performance. In that, my lord, it is partly decreed by my lord ordering only refund, my lord. Against that, my lord, I have filed RFA number 4221 of 2013, which is pending before this honorable court. Now, my lord, when this matter was being argued, the RFA, my lord, the other side, that is my vendors, informed that, my lord, one Kaza Saab had filed one other suit, which is OS number 765 of 2009, claiming, my lord, that, my lord, one of the power of attorney holder of Fakirappa Galagi, that is our the vendor's father, my lord, that he had executed, my lord, agreement to sell in his favor, and, my lord, on 4/3/1988. Now that suit, my lord, is decreed, my lord. And against that, my lord, RA number 24 of 2022 is pending, my lord, before the district judge, my lord. My lord, once I came to know about this RA which is pending, my lord, regarding the same property, I filed an application, my lord, under Order 1, Rule 10(2) for impleading in that appeal, my lord, to protect my interest. Now that application has been rejected by the impugned order. Your lordship will see at page 26.
Yes.
Page 26, my lord, about middle of page. So now the intending purchaser Kashim Saab is not at all a proper and necessary party to this suit. He has not approached the trial court in OS number 765 of 2009 and not sought any relief to implead himself in that suit. So at this appellate stage, he is not at all necessary and proper party to the said suit. His appeal is pending before the Honorable High Court of Karnataka and his rights will be decided in that case.
Issue notice to respond number 125, returnable by 5th March. Notice to respond number 6/2/28 is dispensed with at the request of the counsel for the petitioner since they are co-respondents. The further proceedings in RA number 24 of 2022, pending on the file of the principal senior civil judge and JMFC Ubballi, is stayed till the next date of hearing. SSP and copies to be furnished by end of day 23rd January, an acknowledgement for having served the notice in the above petition on the counsel appearing for respond number 125 in the aforesaid regular appeal to be filed on or before 29 January, failing either of which the interim order will stand automatically vacated.
Obliged.
49, Vadiraj.
As against the rejection of the ad interim injunction by the learned appellate court, my lords, this writ petition is filed, my lords. The facts of the case are that, my lords, the petitioner herein has filed a suit, my lords, for a permanent injunction and mandatory injunction, wherein the respondent had also filed a counterclaim for permanent injunction. The learned trial court, my lords, partly decreed my suit and granted permanent injunction, and also counterclaim also been allowed, my lords. There are two permanent injunction, my lords. And as for
By the RA court.
Please, my lords.
What happened before the trial court?
Trial court, my permanent injunction suit is granted, my lords, partly decreed.
Where is that order?
That's at page 41, my lords, the operative portion, which is in Kannada. ವಾದಿಯು ಸಲ್ಲಿಸಿರುವ ದಾವೆಯನ್ನು ಈ ಕೆಳಗಿನಂತೆ ಭಾಗಶಃ ಡಿಕ್ರಿ ಮಾಡಲಾಗಿರುತ್ತದೆ. ವಾದಿಯು ಈ ದಾವೆಯಲ್ಲಿ ಕೋರಿರುವಂತಹ ಶಾಶ್ವತ ನಿರ್ಬಂಧಾಜ್ಞೆ ಪರಿಹಾರವನ್ನು ಪಡೆಯಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ದಾವಾ ಅನುಸೂಚಿತ ಆಸ್ತಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪ್ರತಿವಾದಿಯಾಗಲಿ, ಪ್ರತಿವಾದಿಯಿಂದ ಆದೇಶ ಪಡೆದವರಾಗಲಿ, ಏಜೆಂಟ್ಗಾಗಲಿ, ಅವರ ಕೆಲಸಗಾರರಲ್ಲಿ ಮತ್ತು ಅವರಂತೆ ನೇಮಕಗೊಂಡ ಬೇರೆ ಯಾರಾಗಲಿ ದಾವಾ ಅನುಸೂಚಿ ಆಸ್ತಿಯಲ್ಲಿ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ವಾದಿಯ ಶಾಂತಿಯುತನ್ನು ಸ್ವಾಧೀನಾನುಭವಕ್ಕೆ ಅಡ್ಡಿ, ಆತಂಕ ಮತ್ತು ತೊಂದರೆ ಮಾಡುವಂತೆ ಶಾಶ್ವತ ಮಂಜೂರು ಮಾಡಲಾಗಿರುತ್ತದೆ. Even the counterclaim of the respondent is also allowed, my lords. And mandatory injunction has been rejected to the petitioner on the ground that the particulars of the encroachment has not been given.
You are the defendant.
Plaintiff, my lords.
Your suit is decreed.
That is what mandatory injunction has not been granted, my lords, and it has been mentioned in the very judgment that during the pendency of the suit he has constructed the wall and put up the
mandatory injunction. You can't get ex parte.
No, man, I have sought for order 39(1), my lords, not to trespass into the property, my lords, as against
that has been decreed, alva.
That is what still there's a threat is looming, my lords.
No, when there's a you have gone on challenge as regards non-grant of the mandatory injunction.
Please, in RA court,
portion is in your favor.
That is what still he is coming. That is what.
And you have to file contempt.
No, my lords, if he tries to, if his endeavor is successful.
ನಾವು ಇಂಜಂಕ್ಷನ್ ಕೊಡ್ತೀವಿ.
No, my lords, what I,
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂಜಂಕ್ಷನ್ ಕೊಡ್ತಾರೆ, ಹಂಗೆ ಕೊಡ್ಕೊಂಡು ಹೋಗ್ತೀವಿ, ಅವ್ರು ವೈಲೇಟ್ ಮಾಡ್ತಾ ಇದ್ರೆ
no,
ಏನ್
so what
ಮಾಡ್ಬೇಕು?
I have to file the recovery suit, my lords, again, if he's.
You have to file contempt proceedings, not this. We'll reserve that liberty.
Obligation.
Petitioner is before this court seeking for the following. Notice to respondent is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The petitioner had filed a suit in OS number 375 of 2020 seeking for injunction, permanent injunction, restraining defendant from interfering with his possession as also for a mandatory injunction. The said suit came to be partly decreed, wide
OS, judgment and
decree dated 25th October 2024, granting the permanent injunction, restraining the defendant from interfering with the possession, but however the mandatory injunction was refused. Challenging the said refusal, the petitioner had filed RA number 67 of 2024, wherein the petitioner once again made an application in IA number 2 therein, seeking for injunction restraining the respondent from interfering with the possession of the petitioner. The said application having been rejected by the ad interim prayer sought for being rejected, the petitioner is before this court. The submission of Shri Vadiraj Padakandla, learned counsel for the petitioner, is that the threat of dispossession and as such said application had been filed. An order of injunction having already been passed, a judgment of permanent injunction having been already been passed, as afore detailed, the question of further ad interim injunction being sought for in an appeal filed by the petitioner would not arise, since the challenge is only as regard the non-grant of the mandatory injunction and allowing of the counterclaim by the defendant. If at all there is any violation of the injunction, if at all there is any interference with the possession of the petitioner, thereby violating the injunction granted in OS number 375 of 2020, the petitioner could always file necessary applications for contempt. Another application for injunction, and that too an ad interim injunction not being maintainable, no grounds being made out, the petition stands dismissed, reserving the aforesaid liberty.
Obligation.
50, MR Hirematar.
Suit for recovery of money, my lord.
Suit for
Recovery of money.
recovery of money.
The plaintiff is an education society, my lord, represented by its chairman. And defendant number 1 and 2, the respondent number 1 and 2, respondent number 1 is the person with whom the plaintiff entered into agreement of supply of building materials worth rupees 8 lakhs. And he became defaulter. He did not supply the building materials. Therefore, the plaintiff filed a suit for recovery of money. And the transaction has been initiated upon the recommendations of defendant number 2, who is the employee of plaintiff society. And they have appeared before the court, but they have not, defendant number 1 and 2, they have not filed any WS in their defense. And IA number 1 was filed by the plaintiff seeking for production of documents, though from the custody of defendant number 2.
What are the documents sought for?
My lord, one document is the resolution dated 16/3/2020, whereby the school management committee has approved payment of advance of rupees 8 lakhs to the defendant number 1.
So that should be with you.
He is the defendant number 2 is the proper custodian of the document, because we have also made the defendant number 2 a party in the proceedings.
Is your former employee?
He's presently he's working with the education society itself, my lord. But because his personal interest is involved, he may not, the chances of that he will not produce the documents before the court. And though he has appeared before the court, he has not filed any WS, my lord. Therefore, the seeking of those documents from his custody, that's important. Because, my lord, we have made him the defendant number 2 personally liable for this transaction, this particular transaction. Along with, upon his recommendations, 8 lakh rupees has been paid to the defendant number 1. And now they are avoiding the chances of defendant number 2 not producing these documents are not there. And he has not filed any objection to IA number 1, my lord.
To notice to the respondents, returnable by 26th March.
51 CS sector.
My lords, this petition is filed challenging the order passed on IA number 23 and 24, my lords. This is a suit for partition and separate possession filed by respondent number 1 and 2, my lords. A genealogy may kindly be seen, my lords, at Annexure A, page 14, my lords.
Page number?
14, my lords, Annexure A.
14.
Suit is filed by Baurava and Shushila, my lords, who are wife and daughter of the propositors. And rest are the other daughters, my lords, who are the defendant number 1 to 3, my lords, in the OS. My lords, contention is, my lords, the defendant number 2 has filed an application and in 23 and 24, my lords, seeking for production of documents and for amendment of counterclaim, my lords, pertaining to the property of husband of Shushila, who is plaintiff number 2, my lords, husband and daughter-in-law of plaintiff number 2, my lords. Our contention is they are nowhere related to the suit, my lords, as they are not arrayed as the parties. And their property is sought to be included in the hopscotch. Trial court, overlooking the nature of the suit properties, my lords, sought to be included, and overlooking the rights of the owners, my lords, has allowed this
application has been filed under for production of documents.
Yes, my lords. Pertaining to the properties, my lords,
as well as the
of
documents, my lord.
husband.
As well as for amendment.
Yes, my lords. The properties sought to be included are belonging to the husband and daughter-in-law of plaintiff number 2, my lords.
It's for them to prove it as to whose property it is. It is for subject to evidence.
Yes, my lord. But they are not arrayed as a part. Owners are not arrayed as parties in this suit, my lords. And they are the separate properties of
Properties were, my lords, purchased subsequent to the death of the propositors, my lords, during pendency of the suit.
She claims that it has been purchased from the joint family funds.
Yes, my lord.
Though in the name.
But it
So
is
this
in
all
the
to be
name of
established.
daughter-in-law, my lords. It is a separate property.
It has to be established.
Yes.
It is from the joint family funds or not. In the name of, it's not brought in the name of a woman, it's been brought in the name of the father.
These properties sought to be included are in the name of daughter-in-law, my lords.
Yaudu.
These properties which are sought to be included by the way of application, my lords, are belonging to the daughter-in-law, my lords.
That defense will be available to you.
Yes.
Amender, so and so. Are purchased by defendant number 4 out of her joint family funds in the name of his spouse and father.
That is their contention. That
Defendant number 4 is the son of defendant
is
number.
the son, yes, my lords.
So it's not in her name.
Not in her. It is in her name, my lords. But their contention is they have purchased it out of the joint family property.
Sale deed is in whose name?
Sale deed is in the name of the daughter-in-law, my lords.
Daughter-in-law plaintiff number 2.
Daughter-in-law is not arrayed as a party in this suit, my lords.
They'll array it. Petitioner is before this court, seeking for the following reliefs. Notice to respond number 1 to 3. 1 to 3 and 5 is dispensed with in view of the proposed order to be passed. The petitioner is defendant number 4 in the suit filed in OS number 88 of 2020, seeking for partition and separate possession. In the said suit, defendant number 2 had filed an application order 8 Rule 8 for production of certain documents which came to be numbered as IN number 23, as also an application and order 6 Rule 17 which came to be numbered as order IN number 24. By way of the amendment, by way of the said application, in IA 24, an amendment to the counterclaim was sought for, and by way of IA number 23, documents in support of the amendment to the counterclaim were sought to be produced. The contention in the amendment application is that certain properties had been purchased from the joint family properties by defendant number 4 in the name of her daughter-in-law.
In the name of
Name
wife,
of his
wife
spouse
and
and father.
By plaintiff number 2 in the name of the daughter-in-law. Our daughter-in-law is the wife of defendant number 4. The aspect of the trial court allowed the said application in order to provide a fair opportunity to establish the case of defendant number 2 in a counterclaim. The submission of learned counsel for the petitioner is that the daughter-in-law is not a party to the suit, and as such the amendment could not have been allowed and the documents be brought on record. Whether the daughter-in-law is at present party to the proceedings or not, the defendants could always file necessary application to bring her on record and necessary reliefs sought for in relation thereto. At present, an application has been filed to amend the counterclaim and produce documents. The same cannot be rejected on the ground that the daughter-in-law is not a party. In the event of the defendant not bringing the daughter-in-law as a party to the proceedings,
daughter-in-law
no
and
relief could
husband.
be sought for against her, and as such the same would not be binding on her, which the which the petitioner can always take advantage of. With the above observation, no grounds being made out, the petition stands dismissed.
Much obliged.
The group matter 52 urgent 53 SC Hiremat.
Records ಬಂದಿದೆಯಾ?
Correspondent 4 to 9 mile.
Yes.
I request to thereafter tomorrow adjourn thereafter.
No adjournment, 2010.
File has been misplaced, man.
Fine.
Thereafter.
Where is Mr. SC Hiremat?
SC Hiremat.
Pass over.
54 Jagdish Patil.
Sachin
senior
Kulkarni.
permission.
ಇದ್ಯಾಕೆ ಹಿಂಗ್ ಬರ್ದಿದ್ದಾರೆ ಇದರಲ್ಲಿ?
ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಸರ್ ಇಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ಲ ಅದಕ್ಕಂತ.
ಇವ್ರ ಹೆಸರು ಇಲ್ಲಿ ಸರ್ಚ್ ಮಾಡಿದ್ರೆ ಬರಲ್ವಲ್ಲ? ಶ್ರೀರಾಮ್.
ಎಸ್
ಸಚಿನ್ ಸಿ ಕುಲಕರ್ಣಿ ಇಲ್ಲಿ ಬರ್ಬೇಕಲ್ಲ, ಇಲ್ಲಿ ಸರ್ಚ್ ಮಾಡಿದ್ರೆ ಬರುತ್ತಾ? An impleading application has been filed in IN 1 of 23. However, the name of the counsel who has filed the impleading application is not shown in the relevant place. That is, as that appearing for the impleading applicant. It is probably for that reason that the said counsel is not present today. The additional registrar judicial is directed to instruct the concerned to print the name of the advocates appearing for the impleading applicants in the relevant location so that the same is searchable and the council can ascertain if any of his cases are listed and appear in the same. Relist on 29th January with the name of the counsel for the impleading applicant being printed in the proper place.
BV Somapur.
Mr. Kayakmat, ready?
I'm ready, sir.
Pass over.
Dinesh Kulkarni.
In this case, in this case, on last occasion, this honorable court directed the bank, respondent bank, Canara Bank, to produce the encumbrance certificate.
Yeah, respond number 3.
Mr. Bilki appears for the bank.
Where is he? Pass over.
Sir. Please.
Certainly under adverse influence on the
Exactly.
No further time.
Please.
58 Sanjay Katgeri.
Yes.
Thank you. Pass over.
Pass over. Ready?
59 Shivraj Belakki.
Please, Lords, I appear for the petitioner. Lords, the matter is of 2017. I will not take much of the time. Lords, as brisk as I can, I will give the facts. Lords, I was a graduate of MBBS. I appeared in PGET for admission to post-graduation.
Education matter, 2017.
Please. I appeared in post-graduation entrance test. I participated in the counseling. And my lords, in between the counseling, I felt that here I may not be able to fetch the necessary seat. And I cancelled and I moved back. But my lords, the authority has withheld 1 lakh rupees as penalty without any authority of law. And the interpretation they are developing from the rules and from the brochure and from their impugned order, they are not matching anywhere, my lords.
Is the seat re-allotted?
Lords, seat is not allotted, it is lying vacant, my lords. It's a government quota seat.
I will take your lordships to the decision of the committee where
ಒಳ್ಳೆ seat ಬಂದಾಗ ಯಾಕ್ರಿ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ರಿ?
Please, my lords. After I
seat ಕೊಡಿ ಅಂತ ಬರ್ತಾರೆ ನಮಗೆ ನೀವು ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ಬರ್ತೀರಲ್ಲ.
I exited from the counseling. There were 2 more rounds left. 2 more rounds left. None of them have taken. The government is pushing me to take a college which I am not willing to take, or none of the other students are willing to take. And for that, they are holding my 1 lakh rupees for last 10 years, my lords. I will show the rules they are relying upon, my lords. And there is no such provision of re-allotment or allotment. And my lords, the penalty imposed, it varies from 1,000, 5,000, 1 lakh, 50,000, baseless, completely baseless. I will show the list, my lords. I have annexed the list.
Yes.
Lords, before that, I will just show 2 of the definitions they have provided in the brochure. Lords, the choice 2 at page 41. On first round, my lords, I was allotted Davangere College. I opted for choice 2. My lords, at page 41, there is a choice 2, a marginal note. May I please read, my lords? Satisfied with the allotted seat but wishes to participate in the next round. Such candidate should undergo biometric verification, which I have undergone, pay the prescribed fees at KEA and submit the original documents I have submitted, and wait for allotment in the second round. Further, they should not collect admission order. This line is important, my lords. I have not collected admission order. As soon as the second round allotment was done, I gave a representation saying that I don't wish to participate in further rounds and please return my fees. And my lords, at page number 47 in the brochure. This makes clear that, my lords, after I choose choice 2, the admission order is not granted to me. It's only allotment.
If my lords now may please come to 47. There is a forfeiture of seat selected. May I please read, my lords?
Yes.
Every candidate, including in-service candidate, shall pay a sum of rupees 1 lakh for degree and 50,000 for diploma, which they have not followed, my lords. They arbitrarily imposed penalty, and I will show it to your lordships. To the government in case he or she takes admission orders during counseling and fails to join. That is important, my lords. I have not taken admission order. In the interval between the allotment and obtaining admission order, I have withdrawn. Relying on this clause, they have withheld my 1 lakh rupees for past 10 years, my lords. And the scheme of reallotment and repayment, that's baseless.
It says 1 lakh of rupees, it's been fixed.
My lords, again I will show choice 2. My lords, further they should not collect admission order. I have not collected admission order.
For
And
choice 1.
As for the first round.
If you don't succeed in choice 2, the first round will prevail.
Please.
If you get upgraded in choice 2, the college that is upgraded
will be cancelled. Upgraded will be
you will be entitled to take it.
I will be entitled to take an admission order, which I have not taken.
You have not done this, you have not done that.
Neither.
You are sitting quietly. So
My lords,
pay
I
money.
got a better opportunity in Comet K.
Oh, good.
In that interval where there is no provision to levy penalty.
You have made all these people work.
Lords, may I please?
You have got a better opportunity. We will wish you all the best.
May I please say this?
But for all these things that you have done, you have to pay.
At least for the sake of equity, my lords, I will show how they have, my lords, how they have imposed very arbitrary, my lords. Please come to page number 54, my lords. From 54, it starts the list. The list of students imposed with penalty. My lords, may please come to serial number 32 at page 56. Penalty is 20,000. At 56, there is serial number 32, my lords, G. Jaya. Penalty 20,000 rupees. Again on next page, my lords, 44, penalty 0. And my lords, there are many 0 penalty cases. At least on the, my lords, at page 65, Gutta Sri Harsha, penalty again 0, my lords. They are very arbitrary. Some amounts are of 5,000, some of 0, and my lords, at page 68, there are at serial 90, penalty is 5,000. Again, one more serial number below that, again penalty is 0. My lords, again at page 71, there is a penalty 0. I don't know why state chose me to withhold 1 lakh rupees.
They have chosen 73 also for 1 lakh.
Lords, all of them are not imposed with 1 lakh rupees, my lords. And there were 2 more other rounds left after me. And there are at 166 and 169, my lords, 20,000 and 20,000. Nowhere in the rules. My lords, again at 200, penalty 0. At 2140, and my lords, at 216, it's 50,000. That's as per rules. But my lords, at 240, page number 80, 10,000 rupees, baseless penalty. And my lords, I have one decision of division bench of this honorable.
207, 3,35,000.
My lords, that's completely baseless. That's how they have imposed their own rules. And my lords, there is a decision of division bench of this honorable court.
Which rule allows you to?
My lords, with my objections, I have enclosed, my lords, rules of 2006 at annexure R2, page number 12, my lords. The relevant provision is at page number 20. Lords, these are the rules governing admissions to, my lords, postgraduate medical seats. Lords, these are the amendment rules. Page number 20, my lords, substitution of rule 15 at the bottom. May I read rule 15, my lords?
When was this introduced?
2006, my lords. This was amended in 2013. I've produced the amendment rules.
From 2013, you produce a list of what is the penalty you have levied for all the people who have got cancer. If you have levied 1 lakh of rupees for everybody, we'll
That's
dismiss
before
this
that. May I just, my lords, draw your lordship's attention to, my lords, some of the other clauses in the brochure which my learned friend, my lords, has not read. Page number 41, my lords.
Whether you are levying the same for everybody is the question.
Please, please.
If you are
Lords,
levying
regarding
for
that, I'll
everybody,
ascertain.
there's no problem.
The ones that my learned friend, my lords, pointed out, the details of admissions of those students are not before, my lords.
You ascertain.
Please, please. Regarding that, I'll ascertain, my lords.
Article 14 violation should not be there.
Please, please. Regarding that, my lords, I'll ascertain. And in respect of this case, my lords, may make some submissions.
Not required. If you
Because, my lords, there were only two, my lords, rounds of counseling, and the second round was the last round. On the date of allotment in the second round, my lords, the petitioner got a allotment seat in Mandya, my lords, in another institute which was upgraded. And, my lords, when a candidate exercises choice 2, there is no, my lords, choice between the two seats. The first one, my lords, gets cancelled when the second.
we are not on that right now. We are
Please,
only on
and
the
my lords, the date of the petitioner when sought for cancellation is the date of allotment in the second round. On 27/5/2014, that seat in the second round is allotted. And on that day specifically, she comes and, my lords, seeks for cancellation. However, in the brochure, it is clearly mentioned.
how you are dealt with other people.
Please.
What's the list that I have
Only
enclosed?
on Article 14.
Please, please,
You have the power. If you are levied 1 lakh for everybody, then there's no problem.
please.
Otherwise, whatever is the lowest?
What's the list that I have?
There's one more clause, my lords, that if anybody, my lords, wants to exit the counseling,
There
it
are
has to
lot
be
of
done
clauses.
before second
You
round.
have to implement the clauses equally.
Please.
Apply it
I
equally,
would
there's no
require
problem.
at least 2 weeks time because this is of 2014. The records
We'll
would
give
be,
you
my
2
lords,
weeks.
hard to.
The submission of learned counsel for the petitioner is that though the respondents have the power to levy forfeiture, to impose forfeiture, the said power has been used in an indiscriminate manner, inasmuch as for some of the students who have exited the counseling, no penalty has been levied, or penalty of varying amounts have been levied from 5,000 to 50,000. But the penalty levied on the petitioner is the entire amount of rupees 1 lakh, thereby violating Article 14 of the Constitution of India. The counsel for respond number
2,
2
my
and
lords.
3,
Only 2, my lords.
2 is granted 2 weeks time to place on record the penalty imposed by respond number 2 on all the students who have exited the counseling at different rounds, more particularly round 2, within 2 weeks from now. Relist on 12th February.
Also, on the next day, let them ascertain from where they are getting this rule of reallotment, because it's not there in the rules. The committee has taken its own view.
If they levied the same thing, then we won't interfere.
I will abide by that. I'm grateful.
60, VM Shilwant.
Getting to the respondent.
There are two lands. Survey 126 measuring loss 21 guntas.
Come back and take it. How long will you take?
About 15 minutes.
Kindly once.
ನಿಮ್ದೆಲ್ಲ ಲಿಸ್ಟ್ ಮಾಡ್ತಾ ಇದೀವಿ. ಒಂದೊಂದು ದಿನ ಬರ್ತಾ ಇದೆ.
Serial number 81, may I request any other details?
81.
Yes.
Inform ಮಾಡಿದಿರಾ respondent?
Yes, my lord, I informed the other side.
81 at the request of counsel for the petitioner relist on 6th February.
Interim order.
Interim order earlier granted is extended.
Correct. Serial number 20, my lords. Serial number 20, I failed to mention.
20?
20. My lords, the observation made in the petition, my lords, shall not come in the way of adjudication of suit on merits. 20 my lords came to be disposed of.
Yes.
Observation made in the petition, my lords, shall not come in the way of adjudication of the suit on merits, my lords. The observation, my lords, is required.
ಏನ್ observation ಮಾಡಿದೀವಪ್ಪ? ಏನು
Only for
ಇಲ್ಲ.
that reason, my lords. 20, please.
ಕಾಸ್ಟ್ ಹಾಕಿದೆ 36 ಅಲ್ಲಿ
2,500 rupees ಅಷ್ಟೇ ಹಾಕಿರೋದು.
ಆಫೀಸರ್ ಇದೆ ಪ್ಲೀಸ್. ಅಲ್ಲ ಅದರಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಅವರು ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ. ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದಕ್ಕೆ ಇಶ್ಯೂ ಮಾಡ್ಲಿಕ್ಕೆ ಆಡಲ್ಲ. ಆರ್ಡರ್ ಬಗ್ಗೆ ಏನಿಲ್ಲ, ಓನ್ಲಿ ಅವರು ಚೀಫ್ ಇಂಜಿನಿಯರ್
so that they'll follow it.
ಅವ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿ ಹೋಗಿದ್ದಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ. ಅವ್ರು ಚೀಫ್ ಇಂಜಿನಿಯರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದ್ದಕ್ಕೆ ಅದಾಗಿದೆ. ಈಸ್ ನಾಟ್ ದೇರ್. ಅದು
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ. Yes.
63 and 64 months. 63 and 64 months.
60,
May be granted.
63 and 64. You are for?
Respondent.
I appear for the petitioner in 64.
Have you informed 63?
63, I am for the petitioner.
Yes.
Weeks time.
They're connected matters, both of them? Both of them are connected matters?
No, they are not. They are not connected.
63 and 64 at the request of counsel for respond number 63 at the request of counsel for respond number 1 and 2 relist on 5th February. 64 at the request of counsel for respond number 3 and 5 relist on 5th February.
Serial number 80, your lordships. I'm not seeking adjournment. There are some office objections. I may kindly be permitted to comply. File I'm seeking it, your lordships.
End of the list, no, because end of no, at 4:30 election matter, no. 24th is the
Yav election.
Gram Panchayat. No conference motion.
Cooperative societies.
No conference motion.
No conference. Dismiss ಮಾಡ್ಬೇಕು.
No, that's already PDO has played the
PDO. Some PDO will have to take action. ಅದ್ರಲ್ಲಿ ಆಗತ್ತೆ.
Please.
Sir, along
ILO ಮಾಡಿ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿದ.
Second list let's check, first list continue.
100205.
Serial number 88.
31 ತಗೊಂತಾರೆ.
Vijay sir. 100205.
205
of 25.
25. Okay. ಅದು ಜಜ್ಮೆಂಟ್ ರಿಲೀಸ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ ಇನ್ನು.
ಅದು ಏನು
ಗೊತ್ತಿದೆ ಸರ್.
ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಅಂದ್ರೆ ಏನು
4 ಗಂಟೆನೇ ಸ್ಕೂಟ್ನಿ ಆಗಬೇಕಲ್ಲ.
ಆಗಿದೆ, ಬೋರ್ಡ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೆ.
ಬೋರ್ಡ್ ಅಲ್ಲಿ
ತರಿಸಿದ್ರೆ 2:30ಗೆ ರೆಡಿ ಬರ್ತೀನಿ.
ಮೇಡಮ್ ಹೇಳಿ.
88 ಚೆಕ್ ಮಾಡ್ಬೇಕು.
ಏನ್ ಚೆಕ್ ಮಾಡ್ತೀವಿ?
ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಏನು?
88 ಇಲ್ಲ ಇದೆ.
ಹಾ ರೀ ಸರ್, ಥ್ಯಾಂಕ್ಸ್.
ಸರ್ ಅದು 11 serial number 22
ಸರ್ ಸರ್
ಇಲ್ಲೇ ಕೇಸ್ ಫೈಲ್ ಮಾಡಿದ್ಮೇಲೆ ಮತ್ತೆ ಡಿಕ್ಲರೇಷನ್ ಇದನ್ನ ಪರ್ಮನೆಂಟ್ ಇಂಜೆಕ್ಷನ್ ಹಾಕೊಂಡ್ ವೇಸ್ ಹಾಕೊಂಡ್ರೆ ಇಲ್ಲೇ ಮೇಂಟೈನ್ ಆಗಂಗಿಲ್ಲ. ಇಲ್ಲೇ ರಿಟ್ ಹಾಕೊಂಡಾರ್ರಿ. ಇಲ್ಲಿ ರಿಟ್ ಹಾಕೊಂಡ್ಮೇಲೆ ತೆಳಗಿನ ಕೋರ್ಟ್ನಾಗ ಮತ್ತೆ ವೇಸ್ ಹಾಕೊಂಡಾರ ಪರ್ಮನೆಂಟ್.
ಲಿಬರ್ಟಿ ಇದ್ರೆ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ರೆ
ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ರೆ
ಇಲ್ಲಿ ರಿಟ್ ಅಲ್ಲಿ ಲಿಬರ್ಟಿ ಏನಾರ ಕೊಟ್ಟಿದ್ದು ಇದ್ರೆ ಮಾಡಬಹುದು. ಇಲ್ಲ
ಅದು ಚೆಕ್ ಮಾಡಕ್ ಬರತ್ರಿ ಸರ್. ಸೀರಿಯಲ್ ನಂಬರ್ 88 ಅಲ್ಲಿ
ಮಧ್ಯಾಹ್ನ
215 ಬರ್ಲಿರಿ ಸರ್.
ಇಲ್ಲ ಇಲ್ಲಿ
Username fill ಮಾಡಬೇಕು. Username fill ಮಾಡಬೇಕಲ್ಲ, ಏನು username ಏನು? ಏನಾಯ್ತು? ಎಲ್ಲ ಬೆಂಚಸ್ ಬಂತ, ಇದು ಆಟೋಮೆಟಿಕ್ ಬರುತ್ತೆ. It will automatically ಬರ್ತಾ ಇರುತ್ತೆ. ಇಲ್ಲಿ ಕಾಸ್ಟ್ ಇಂಟಿಗ್ರೇಟ್ ಆಗಿದೆ. ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿದ್ದೀರಾ? ಕೇಳಿಸ್ತಾ ಇದೆಯಾ? The learned AG accepts notice for respond number 1 and 2. Sri M.V. Ramat, who has filed caveat for respond number 23 and 24, accepts notice for respond number 22, 22 and 25. Registry is direct print is named as such. The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the respond number 2 has acted upon a requisition submitted by respond number 3-25, which bears the endorsement of the Panchayat Development Officer along with a seal, signature and writing, which is contrary to the decision of the coordinate bench of this court in Sanganagowda Biradar, please, versus so and so. Please. A perusal of Annexure C does indeed indicate the PDO having made endorsement and signed the requisition notice. In that view of the matter, I am of the considered opinion that the said endorsement having been made on 30/12/24, much after the decision of the coordinate bench dated 26 November 24 in Sanganagowda and Biradar's case, the said PDO has acted contrary to the orders passed by this court, requiring disciplinary proceedings to be initiated by respond number 1 against the said PDO. In that view of the matter, I pass the following order. Writ petition is allowed. A certiorari is issued, so and so at Annexure D is quashed. Respond number 1 is directed to initiate disciplinary proceedings against the Panchayat Development Officer Sridhar Gadde, Bellary Taluk, and file necessary report within a period of 30 days from date of receipt of a copy of this order. Though the above petition is disposed, relist on 27th February 2025 for filing such a report. Liberty is reserved to respond number 3-25 to move a fresh requisition notice in accordance with law. Please.
To 30 matter, 101, Prasad Kumar Gunki.
I represent the petitioner, my lord.
Yes.
May it please, my lord. One, Sri Vittal, one Sri, one Sri Yallappa Devappa Dakuliche, resident of Belgaum, my lord. for the owner of vacant land bearing survey number 701, measuring 3 acre and 3 guntas, and also survey number 203/4/4, measuring 30 guntas, my lord. Upon the coming into force of the ULC Act 1976, my lord, the said Yallappa filed his statement before the competent authority on 13/8/1976, giving all particulars of the land, my lord. On the basis of the said declaration, the competent authority held that the declarant held land in excess of the ceiling limit to the extent of 10,241 square meter in survey number 701, my lord. And so far as survey number 203/4/4 is concerned, then area measuring 3,035 was held to be excess vacant land, my lord. Thereafter, my lord, the competent authority issued notifications as required under section 10(1), section 10(2), and 10(3) of the ULC Act, my lord, as per annexure A, B, C, respectively, my lord. Thereafter, my lord, finally, the competent authority issued a notice under section 10(6) of the ULC Act, as per annexure D, my lord, calling upon the declarant to hand over possession. It was specifically mentioned in the said notice, my lord, if he failed to give possession, the possession would be taken as per under section 10(6) of the ULC Act, my lord. Accordingly, my lord, the competent authority claims to have issued notice as per annexure D, my lord. May I read it, my lord? Section 10(5) notice. ಕರ್ನಾಟಕ ರಾಜ್ಯಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 27/11/86 ಪೇಜ್ ನಂಬರ್ 22, my lord.
Yes.
Annexure D. ಕರ್ನಾಟಕ ರಾಜ್ಯಪತ್ರದಲ್ಲಿ ದಿನಾಂಕ 27/11/1986 ಪ್ರಕಟವಾದ ಭೂ ನಗರ ಪರಿಮಿತಿ ಕಾಯ್ದೆ 1976 ಪ್ರಕರಣ 10(3) ಪ್ರಕಾರ ನೀಡಲಾದ ಅಧಿಸೂಚನೆಯನ್ನು ಅನುಸರಿಸಿ ನೀವು ಹೊಂದಿದ ಕೆಳಗಿನ ಮುಂಚಿದ ಜಮೀನು ದಿನಾಂಕ 27/11/86 ಸರ್ಕಾರ ವಶಕ್ಕೆ ನಿಹಿತವಾಗಿರುವ ಪ್ರಯುಕ್ತ ನೀವು ಕೆಳಗೆ ಕಾಣಿಸಿದ ಜಮೀನುಗಳನ್ನು ತಾರೀಖು 22/3/1988 ಮುಂಜಾನೆ 11 ಗಂಟೆಗೆ ಕಂದಾಯ ನಿರೀಕ್ಷಕರು ಬೆಳಗಾವಿ ಇವರಿಗೆ ಕಬ್ಜಾ ವಹಿಸತಕ್ಕದ್ದು. ಇದಕ್ಕೆ ತಪ್ಪಿದಲ್ಲಿ ಮೇಲೆ ಹೇಳಿ ಪ್ರಕಾರ ಕಾಯ್ದೆ ಪ್ರಕಾರ ಪ್ರಕರಣ 10(6) ರಲ್ಲಿ ವಿವರಿಸಿದಂತೆ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು. In this case, my lord, it is specifically mentioned that if possession is not given, then possession will be taken as per under section 10(6), my lord. Now, coming to the revenue inspector claims to have taken over possession as per annexure E, my lord. Annexure E, page number 27, my lord. Very important document, my lord. As per Kabja Panchanama. According to the revenue inspector, my lord, it is the case of the revenue inspector that despite issue of notice to the declarant, he remained absent, my lord. Now, my lord, I would like to go through the Panchanama. ಯಾದಾಸ್ತ ನಾವು ಕೆಳಗೆ ಸಹಿ ಮಾಡುವ ಪಂಚರು ಸಾಕಿನ ಅನುಗಳು ಬರೆದುಕೊಳ್ಳುವ ಪಂಚನಾಮ ಏನಂದ್ರೆ, ನಮ್ಮ ಊರಿನ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿ ಹಾಗೂ ಅರ್ಬನ್ ಲ್ಯಾಂಡ್ ಸೇಲಿಂಗ್ ರೆವೆನ್ಯೂ ನಗರ ಬೆಳಗಾವಿ ಅವರು ನಮ್ಮ ಆಫೀಸ್ನಲ್ಲಿ ಕರೆಸಿಕೊಂಡು ಮೆಹರ್ಬಾನ್ ಸ್ಪೆಷಲ್ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಸಾಹೇಬ್ ಬೆಳಗಾವಿ ಇವರ ನಂಬರ್ ULC-DSR 2703/46/1985 ಇದನ್ನು ಓದಿ ನಮಗೆ ಸಮಜಾಯಿಸಿ ಹೇಳಿದರು. ಈ ಪ್ರಕಾರ ಅನುಗುಣ ರಿವಿಷನ್ ಸರ್ವೆ ನಂಬರ್ 701 ಮತ್ತು 703/4/4 ಇದರ ಮಾಲೀಕ ಶ್ರೀ ಯಲ್ಲಪ್ಪ ದೇವಪ್ಪ ದಾಖಲುಚೆ ಇವರಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಆಗಿದ ಪತ್ರವನ್ನು ಓದಿ ತೋರಿಸಿದರು. ಆ ಪ್ರಕಾರ ಆಫೀಸ್ನಲ್ಲಿ ಆಗದೇ ಇದ್ದ ಮೇಲಿನ ಸರ್ವೆ ನಂಬರ್ದ ಕಬ್ಜಾ ತೆಗೆದುಕೊಂಡು ಅದರ ಪಂಚನಾಮ ಮಾಡಿದಕ್ಕೆ ಹೇಳಿದ ಪ್ರಕಾರ ನಾವು ಎಲ್ಲ ಜನರು ಕೂಡಿ ಮೇಲಿನ ಸರ್ವೆ ನಂಬರ್ 701ರಲ್ಲಿ ಹೋಗಿ ತಿರುಗಾಡಿ ನೋಡಿದೆವು. ಸಂಪೂರ್ಣ ಜಮೀನಿನಲ್ಲಿ ಯಾವುದೇ ಗಿಡಗಳು ಮಾವು ಇರೋದಿಲ್ಲ, ಹುಲ್ಲಿನ ಪಡ ಜಮೀನು ಇದ್ದಿದ್ದೆ ನಮಗೆ ಕಂಡಿತು. ಸರ್ವೆ ನಂಬರ್ 700 ಪಶ್ಚಿಮ ದ ಬೌಂಡ್ರೀಸ್ ಆರ್ ಗಿವನ್, my lord. ಸದರಿ ಲಾಸ್ಟ್, my lord, ಈ ಚಕ್ಬಂದಿಯಲ್ಲ ಕ್ಷೇತ್ರ 10,741.57 ಚದರ ಮೀಟರ್ ಜಾಗೆಯನ್ನು ನಮ್ಮ ಸಮಕ್ಷಮ ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇವರು ಕಬ್ಜಾ ತೆಗೆದುಕೊಂಡರು, my lord. ದೇರ್ ಸೊ ಆಲ್ಸೋ ಹಾಗೂ ಅನುಗುಣ ರಿವಿಷನ್ ಸರ್ವೆ ನಂಬರ್ 703/4/4 ಇದರ ಕಬ್ಜಾ ತೆಗೆಯಲು ನಾವು ಪ್ರತ್ಯಕ್ಷ ಕಬ್ಜೆಯ ಮೇಲೆ ಹೋಗಿದ್ವಿ, ತಿರುಗಾಡಿ ನೋಡಿದೆವು. ಜಾಗೆಯಲ್ಲಿ ಗಿಡಗಳು ಬಾವಿ ಏನೂ ಇರುವುದಿಲ್ಲ, ಪಡ ಜಾಗ ಇದ್ದು ಕಂಡು ಬಂದಿತು. ಇದು ಚೆಕ್ ಬಂದಿ ಸೋ ಅಂಡ್ ಸೋ my lord. ಈ ಜಾಗೆಯ ಕಬ್ಜೆಯನ್ನು ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಇವರು ನಮ್ಮ ಸಮಕ್ಷಮ ತೆಗೆದುಕೊಂಡರು ಅಂತ ಬರೆದುಕೊಟ್ಟು ಕಬ್ಜಾ ಪಂಚನಾಮ. In this connection, my lord, when a person or a declarant fails to give possession as required under section 10(5), it is for the competent authority alone to take possession, my lord. Revenue inspector is not competent to take possession so far as section.
Coordinate bench judgment kodi.
Yes, my lord, I'll come to that. I'll come now.
Judgment.
Yes, I'll come to the point, my lord. Yes, yes, these are the simple facts, my lord. Though the revenue inspector claims to have taken possession.
Mr. Prasad Kumar, you read the file. Give us the judgment. We'll pass it in your favor.
In this connection,
Procedure.
I'd like to rely.
Follow the procedure.
Yes, my lord. In this case, my submission
I
is
am for
that
Responsible Development Authority.
though
Judgment kodi.
yes, please, my lord, please, my lord. I would like to rely upon writ appeal number 3307 of 2005 decided by the Division Bench of Constitutional Court dated 9/9/2018 in para number 10 and 9 and 10. Copies, you know, they are already on record, my lord. I have produced them along with the list of memo, this judgment, my lord. Yes, copies are supplied, my lord.
Writ appeal number 100102 na?
Writ appeal number 3307 of 2005 decided on 9/9/2008, my lord, in the case of Mangalore Urban Development Authority versus Leelavati and others. Paragraph number 9, my lord. Assuming that the revenue inspector.
Nimde copy kodi.
Paragraph number.
This is long over. Recent judgments are there. Solved.
Yes.
Yes, Mr. Kalsurmat.
May I pass on? This is the
And what is it according to you?
Lord, as per the full bench decision having been taken, has been
My submission.
inspector is competent to take possession of the excess land under the ULC Act under the instruction of the competent authority. The division bench of the full court in the case of Kannaya was Malot has also another division bench judgment in Kavadu Siddhappa Patil in writ appeal 100102 has held that meaning of competent authority to take possession means possession must be taken under the supervision of the competent authority.
Without doing subsection 6 of section 10.
Yes.
How can you do that? That competent authority will come under subsection 6 of section 10.
In the act, competent authority is the deputy commissioner which has been declared. But since on the instructions given by the deputy commissioner, the revenue inspector.
Subsection 6 says if any person refuses or fails to comply with an order made under subsection 5.
Yes, ma'am.
The competent authority may take possession of or cause it to be given to the concerned or to any person duly authorized by this behalf and may for the purpose use such force as in the subsection so and so.
Please. So, my lord, in every cases, my lord, wherever the possession has to be done, it would not be the deputy commissioner who go and take possession. It is the competent authority.
Where is the authorization?
Authorization, my lord.
For the revenue inspector.
Since my lord, there is no such as that.
ಅದರಲ್ಲೂ ಇಲ್ಲ.
ಇಲ್ಲ.
ಅದಕ್ಕೆ ಎಲ್ಲದರಲ್ಲೂ ಕಾಶ್ ಆಗಿದೆ.
ಹೌದು.
ಇದರಲ್ಲೂ ಕಾಶ್ ಆಗಿದೆ.
Oh my lord, this case, division bench only held that this full bench of this all.
You produce a notification authorizing him, then we'll consider it. If there's no notification authorizing, then he is not authorized.
No, already
become
state
a
of Assam
competent
and other cases, Supreme Court has any other cases has held that the revenue inspector is competent to take position. State of Assam.
You notification illa andre illa, Mr. Ulial.
It is implied, not notification, not necessarily.
ಬರಲ್ಲ. ನಿಮ್ಗೂ implied ಬರಲ್ಲ. ವಕಾಲತ್ನಾಮಾ ಹಾಕಿದ್ರೇನೆ ನಿಮ್ಗೆ ಬರೋದು.
Your lordship, please note, ULC Act was repealed in 1909. Whereas writ petition filed in 2019.
Delay.
Delay. Before repeal of the ULC Act, no appeal was filed. No, this was not challenged on this ground.
I may come to my lord.
Who is in possession?
That's Buddha. Allottees are in position. Your lordship, I have filed a statement of my objections. My statement of objection may kindly peruse, my lord. Because he admitted.
The revenue records in the year
Now
1988
I'll come to
itself,
the point, my lord.
its government name has been entered. Lord, along with the statement of objection filed by the state, in the year 1988 itself, my lord, government name has been entered. Revenue records as per annexure R1.
Yes.
In fact, matter has been remanded by the Honorable High Court to KTA, and KTA thereafter final order has been passed by the Deputy Commissioner.
My lord, can be permitted to go on with matter.
Lord, in the year 1990, name of the Belagavi urban development came to be entered as per annexure R2. Discussion has been affected.
Possession has been taken.
Yes,
And
Possession taken, award is also filed.
I'll continue, my lord.
Let him complete.
Though the revenue inspector claims to have taken our possession, my lord, the version of the revenue inspector, so far as Kabja Pavati and Kabja Panchanama, and also the issue of notice under section 10(5), no reliance can be placed on these three documents, my lord. Because my submission is that the respondent number 4, the development authority itself has clarified in paragraph number 9 of his statement of objection, saying that during the I'll refer to the statement of objection, my lord, filed by the respondent number 4, my lord. Lordship may kindly see that page number 6 of the statement of objection filed by the respondent number 4, my lord.
ಯಾವತ್ತು ಫೈಲ್ ಆಗಿದ್ದು?
15/7/2024.
18/7?
Sorry, 1/7/2024. 15/7, July.
On page number, paragraph number 9, my lord.
No, page number 6.
Page number 6.
Returnable land.
Yeah. On page number 6, my lord.
Statement of objections ಕಾಣ್ತಾ ಇಲ್ಲ, ಪೇಜ್ ಆಮೇಲೆ ನೋಡೋಣ.
ಕೊಟ್ಟು 15 ಅಲ್ಲ ಸಿಕಲ್ ಕೊಟ್ಟು ಆಫೀಸಲ್ಲಿ ಕೊಟ್ಟು ಕಂಟ್ರೋಲ್
ಸ್ಟೇಟ್ ಇದೆ, ನಿಮ್ದಿಲ್ಲ.
Page number 6, sir.
ನಿಮ್ದಿಲ್ಲ ಅಂತ.
It was filed in the month of July 2024, my lord.
ಇದೇನಿದು?
Right.
July 24.
Please, my lord. As I already was submitted, my lord, the revenue inspector claims to have taken over position in the absence of the declarant as per the Kabja Pavati and Kabja Panchanama dated 22/3/1980. My lord, my submission in this connection is that no reliance can be placed on the Kabja Pavati and Kabja Panchanama, my lord, for the simple reason that the respondent number 4 itself has clearly stated in paragraph number 9 of his statement of objection, my lord, on page number 6. The second line, my lord, on page number 6, after annexure 9. Yes.
Yes.
It is submitted that during the pendency of the above land acquisition proceedings and after conclusion of the proceedings under the Urban Land Ceiling Act, the above excess land has been handed here to the then Improvement Board, Belgavi, my lord. Here is a clear clarification made by the respondent number 4 that even during the pendency of the ULC proceedings, the possession was taken
After conclusion of the proceeding.
after conclusion. I'll come to that, my lord.
Pendency.
When he says that during the pendency he had taken possession, there is no question of giving possession again under section after conclusion, my lord.
State has taken possession given to the CITB.
One thing is clear that during the pendency of the petitioner ULC proceeding, it was the Buddha which was in possession, my lord. So my submission is that there is no vesting of the land in the state government as required by law, my lord. There is absolutely no vesting of the land in the state government. Further, no compensation at all is paid to the declarant till today, my lord. In respect of this submission, my lord, I would like to rely upon a decision relying upon yes. The same judgment, my lord. Leelavati, Mangalore Urban Development Authority versus Leelavati and others, wherein their lordships have clearly held that paragraph number 9, my lord. Assuming that the revenue inspector took possession of the land.
The citation?
Citation is ILR 2008 K Karnataka 5059, my lord. Yes.
List 23, 2015, 24, 2010, 98 and 2012 ಇದೆ ಅಷ್ಟೇ 6 ಇದಾವೆ.
Yes, my lord.
Only 6 citations are there in your list.
Judgment ಕೊಟ್ಟಿದ್ದೀವಿ.
It is there, my lord. It is there, my lord.
ಇಲ್ಲ ಫೈಲ್ ನಲ್ಲಿ ಇಲ್ಲ.
It is here, my lord. Wherein the lordship have clearly held that.
ಕಾಪಿ ಐತೆ.
ಐತೆ.
ಕಾಪಿ is there.
ಈ ಮೆಮೊ ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ.
Copy them, my lord.
ನಮ್ಮ ಹತ್ರ ಇಲ್ಲ. We have a memo which is different.
It is already there, my lord.
ಇಲ್ಲ ಅಂತ. ಇದು ಕಾಪಿ ಕೊಡ್ಬಿಡಿ.
ಎರಡು ಸತಿ citation ಹಾಕಿದೀರಾ?
Yes. So far as this Leelavati case is concerned, my lord, it is very much made clear by the lordships.
There is a memo of 23.
Yes, my lord.
ಇದೆಯಾ?
Yes, my lord.
Yes, sir.
Yes, my lord.
Yes.
At para
Which page number?
Page number 3, my lord. Page number 3. Page number 3, my lord.
Yes.
At para number 9, my lord. Assuming that the revenue inspector took possession of the land, no document is produced to show that he was competent to take possession under section 10(6) to take possession of the land, which is declared as surplus land under section 10(3) of the ULC Act. The language used therein is that the competent authority may take possession of the land or cause it to be given to the state government or to any person duly authorized by the state government in this behalf. There is no document in the original file of the state government to show that possession of the land was taken by the competent authority and given to the state government. Even if the alleged merger is construed as document regarding taking possession of the land in question, possession was not given to the government, but was given to the development authority, my lord. Viewed from any angle, it cannot be said that possession of the land was taken by the competent authority from the owner of the land in question and given to the government. Therefore, the question of wasting of the surplus land with the state government did not arise at all. It's a clear case that the land never vested in the state government, my lord. Therefore, my submission that once the land, there is no vesting of the land in the state government, the land continued to the private property of the declarant, my lord. In view of Manikyama versus Raudri Housing Cooperative Society, reported by the Supreme Court, my lord.
Judgment ಇದು.
ಆಯ್ತು ಇದರಲ್ಲಿ ಇದೆ. I'd like to draw the attention of this honorable court to the judgment reported in 2015 1 Karnataka Civil and Criminal Reporter, short notes 50 Supreme Court, my lord, page number 37, my lord, wherein the lordships have clearly held that this was decided by the Honorable Supreme Court,
37, huh?
37, my lord. In the case of G. Manikamma and others versus Raudri Cooperative Society and others, my lord. Urban Land Ceiling Regulation Act 1976, Section 10, excess land, vesting or taking possession would not take place until procedure contemplated under is followed. If not, land remains private property, notwithstanding determination of such property as one in excess of the ceiling limit, my lord.
Yes.
So when the land has not vested in the state government, my respectful submission is that the possession taken by the Buddha, response number 4, illegal, my lord. When the land has not vested, because under ULC Act is a self-contained code, my lord. ULC Act is self-contained code. Section 23 provides for not only acquiring the land, but also for disposal, my lord. Disposal of the land is constantly provided only under Section 23. Section 23 says that where the land has vested in the state government, it shall be competent for the state government to dispose of the land only under Section 23, my lord. In this case, there is absolutely no disposal of the land in favor of the respondent number 4, my lord. Therefore, my submission is that the possession taken by the respondent number 4 is totally illegal, my lord. Therefore, now coming to the next point, my lord. I have produced annexure J1 to J7, my lord, which clearly established that an area measuring J1 to J7.
Yes.
J1 to J7, which are the record of rights on survey number 710 bar 701, my lord, which clearly says that the respondent number 4, after taking possession and during the pendency of the VLC proceeding itself, formed a layout and showed the plots to the public, my lord, as can be seen from annexure J1 to J7. My submission in this connection is that when the land never rested in the state government and the state government never made any disposal in favor of the respondent number 4 as required under Section 23, there is no question of being any illegality in the matter, my lord. As can be seen from annexure J1 to J7, we show that Buddha has made and showed a plot to the public, my lord. Therefore, my submission is that this action on the part of the respondent number 4 is in clear violation of Article 300A of the Constitution of India, my lord. Secondly, the record of rights, my lord, which are produced along with this writ petition, show only so far as in area measuring 2 acre 9 quintal, my lord. The question remains is, what happened to the remaining land, my lord? What happened to the remaining land? The Tahsildar, whose duty it is to maintain correct record of rights, has not maintained any record of rights in respect of the remaining, my lord. This is a clear fraud on the petitioners as well as the original declarant, my lord. In this connection, my lord, but nevertheless, the Buddha claims to have acquired the entire land, including the retainable land, my lord. Yes. My submission in this connection is that during the inquiry under the VLC Act, my lord, the competent authority had come to the conclusion of granting about 19 guntas of land as retainable land to the declarant Yellappa Devappa Dakuliche, my lord. Once the land was given to Yellappa Devappa Dakuliche, who was absolute owner, without doubt, my lord, he was absolute owner, and an area measuring 19 guntas was given to the declarant, my lord. This 19 gunta, according to the petitioner, my lord, is not acquired by Buddha, my lord. Not at all acquired, nor any compensation paid, my lord. But the development authority has produced award copy, my lord. As per ಇಲ್ಲ ಇಲ್ಲ ಅದಲ್ಲ. Yes, page number 34, my lord. Page number 34, very important document.
34.
34, my lord. Produced by the respondent number 4 along with the statement of objection, my lord. Page number 34 says that in the third column, ಸ್ವಾಧೀನವಾದ ಕ್ಷೇತ್ರ 19 ಗುಂಟೆ 12 ಅಣೆ 0 ಪೈಸೆ. ಐತೀರ್ಪುದಾರರ ಹೆಸರು ಇಂದ ಐತೀರ್ಪುದಾರರ ಹೆಸರು ಕಾಲಮ್, my lord. The name of the ಐತೀರ್ಪುದಾರ is shown as Dakulche Vittal Devappa, my lord. Vittal Devappa Dakulche, my lord, was not the owner of the land at all, because as can be seen from 4-1 notification and 6-1 notification produced by the respondent number 4 himself, my lord. It was.
Where is the 4-1 notification?
Annexure R1, my lord. Annexure R1.
Annexure
After
R1.
R8, page number 12. Relevant portions, page number 13. Serial number 2.
Yes.
Dakulche
Even,
Yellappa
even,
Devappa.
even according to the 4-1 notification, my lord.
This is in 1977.
Yes, 77. 3/3/1977. Even before passing of the.
Mr. Uliali.
As can be seen.
Serial number 2. Dakulche Yellappa Devappa 701. Serial number.
It was
Because three
Yellappa
guntas.
Devappa Dakulche who was found to be the owner, whose name is mentioned on the Khatedar and Anbodhar, my lord. As can be seen from page number 13 of annexure.
He was the Karta of the family.
Yes. So also,
Not
my
the
lord.
absolute owner.
So also.
No, I will say.
So also, my lord.
Guntas.
3 acres, 3 guntas. Even
So,
prior to this issuance, declares this.
My lord, so also, on page number 21, my lord, annexure 9, the name of Yellappa Devappa Dakulche is shown as owner of the land, my lord. When Yellappa Devappa Dakulche was the owner, the award passed by the respondent number 4 in the name of Vittal Devappa Dakulche,
This
not
is a
by him.
notification issued on 15 January 1977.
Yes.
For a final notification for
Gazette
acquisition.
dated 3/3/77. Gazetted on 3/3/77.
Preliminary date of preliminary notification is 3/3/1977, and the date of final notification is
7/4/1980.
9/4/1980, my lord. But the award was passed in the year 1990 after a delay of 8 years, my lord.
Final notification illi.
19, next R2, my lord. R9, my lord. Page number, relevant page number.
Final. It is annexure R9, my lord. Final notification R9 at page number 21. This is under section 6 of the LA Act, my lord. 6(1).
For 1980.
6.
Yes.
Under 18.
9/4/1980.
Improvement Boards Act.
1980.
6 allied.
After 8 years.
This is Improvement Boards Act.
Yes, ma'am.
Not under Land Acquisition Act.
Improvement Boards Act.
As can be seen from section.
Idರಲ್ಲಿ serial number?
Serial number 2 only, my lord. Dakulche Yellappa Devappa.
Serial number 2, my lord.
Page number 22, next page.
Serial number 2, Dakulche
Page
Yellappa
number 22,
Devappa.
my lord. 22.
22.
Yes, ma'am.
Dakulche Yellappa
Yes, 3 acres, 3 guntas.
3 acres, 3 guntas.
Yes. In
This
this
attained finality on 7/4/1980.
serial number also shown, and the name of the Yellappa Devappa Dakulche is shown, my lord. Therefore, my submission is that any award passed in favor of Vittal Devappa Dakulche is.
Only as regards 701.
Yes.
Yes, my lord.
What about the other land? 203.
I'll come to that, my lord. That relates to serial number 203/4/4, which is situated.
3/4/4, that was not acquired.
ಅದಕ್ಕೆ ಆಮೇಲೆ ಬರ್ತೇನೆ, my lord. I'll come to that point. Yes, yes.
ಇನ್ನ 701 ಅಲ್ಲಿ ಇದೆ.
So, admittedly, when Yellappa Devappa Dakulche alone was found to be the owner of the land, the award, there's the so-called award passed by the respondent number 4 in the name of Vittal Devappa Dakulche is no award in the eye of law. Therefore, my submission is that when no award is passed.
Did you challenge this acquisition notification?
That was challenged, a writ petition was filed.
No,
and
no.
a writ-
Acquisition
ಮಾಡಿದ್ದಾರೆ.
Acquisition notification will not challenge.
Acquisition not done, my lord.
Acquisition notification not to be.
ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ. They have not been challenged.
ಇವ್ರು ಮಾಡಿದ್ದಾರೆ ಅಂತಾರೆ.
ಒಂದು ಇವರೇ ಹಾಕಿದ್ರು notification ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು on the basis of delay the entire writ petition was dismissed.
Where is that?
ಅದು whether this land ಅಂತ ಯಾಕಂದ್ರೆ ಇವರೇ ವಕೀಲರು ಹಾಕಿ
701.
No, no, no.
Acquisition was a
No,
challenge.
not challenged. Till today, not challenged. Even award is also not challenged.
I will verify and make submission.
That's a very important
It
fact.
was also confirmed before the division bench also for that.
It will have a big bearing challenge iದ್ರೆ. Be clear on it.
That is-
ಇಬ್ರು ಇಲ್ಲ ಅಂತ ನೀವು ಒಬ್ರೇ
My lord.
ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
These documents, my lord, are enough to hold that.
If so, who had challenged it if they had challenged it?
It is,
Not
the
that.
matter is almost coming to an end, my lord. My submission is that, therefore, my lord, the response number 4 claims to have passed an award, but it is not passed in the name of the real owner, Yellappa Devappa Dakluche. Therefore, my submission is that when no award is passed in favor of the real owner, when no award is passed in favor of the real owner, my lord, all the provisions of the new act apply. Accordingly, my lord, section 24(1)(a) of the Right to Fair Compensation Act applies, my lord. May I read it? We say that where land, section 24(1)(a). Yes. A land acquisition process under section, Act number 1 of 1894 shall be deemed to have lapsed in certain cases. 1. Notwithstanding anything contained in this act, in any case of land acquisition proceedings initiated under the Land Acquisition Act 1894, A, my lord, where no award under section 11 of the said Land Acquisition Act has been made, then all provisions of this act shall relating to the determination of compensation shall apply. In this case also, my lord, though award is passed, it is not passed in favor of the declarant, original owner, Yellappa, my lord. Therefore, the award passed by him is not binding on me. Therefore, I am entitled for compensation in terms of the new act, my lord. Secondly, my lord, though there is absolutely no wasting of the said land in favor of the respondent number 4, my lord, the respondent number 4 claims to have leased about 33 guntas of land in favor of respondent number 5, my lord, for a department. This lease deed is produced by the respondent number 4 at annexure 4, my lord, page number 35. R4. When the question of lease comes, my lord, my first submission is that who can grant a lease? Whether Buddha was the owner of the land in order to make a lease? No, my lord. The land never vested in favor of the government. There no award is passed, no compensation is paid. Therefore, my submission is that respondent number 4 had absolutely no semblance of a right to make any lease in favor of respondent number 5, my lord.
10 rupees. Who is respondent number 5?
Forest Department.
10 rupees. Stamp duty.
Forest, conservator forest.
So also, my lord.
Not registered.
Lease in favor of the deputy conservator of forest.
And we are leased out with this because
10 rupees.
survey number 7014 and others are reserved for open space in the layout plan of the authority. Already scheme is handed to corporation in 1996 itself. And it is open space in the layout plan. I'll produce that layout plan.
The open space.
Open space, open space.
The first question.
Purpose of
701 ಇದ 203 ಯಾವ್ದು open space?
701.
701.
701, my lord.
The entire 701.
Yes.
3 acres, 3 guntas.
That's part of the, not only 701, other land. It is there.
Entire part. You'll have to be specific.
I'll verify.
The forest department has been given about 34 guntas of land, my lord.
34 guntas. 34.
34 guntas, my lord. Remaining land. This land includes the retainable land measuring 19 guntas also, my lord. And so for the
ಎರಡು ಪ್ರಾಬ್ಲಮ್ ಇದೆ. ಒಂದು ULC.
Yes.
ಇನ್ನೊಂದು acquisition.
Yes.
ULC ಅಲ್ಲಿ 19 guntas retainable.
Yes.
Land acquisition ಅಲ್ಲಿ entire land acquired.
Yeah, they claim to have acquired entire land, and they also claim to have passed an award.
Under that, you will be entitled only for compensation of 19 guntas if everything is.
Yes, sir. Compensation is paid. They say that the compensation is paid in respect of 19 guntas in favor of Vitthal Devappa Dakluche, who is not the owner of. Second submission in this report, the said deed is not registered on as required by law, my lord.
Same.
said lease deed exists alleged by the executed by the response number 4 in favor of response number 5 is not a registered document, my lord. Any lease exceeding year to year must be compulsory registered as required by law. This lease deed made on 10 rupees bond paper, my lord. Therefore, my submission is that this lease deed does not create any right, title, or interest.
10 rupees, sir.
Yeah, 10 rupees, my lord.
Not
Therefore,
on
my
proper stamp
submission
and
is
not registered.
not registered, not registered. Therefore, my submission is that when the response number 4 never became the owner of the land, it could not have leased any portion of the land in respect of, in favor of response number 5, my lord. And 1 minute. Now, coming to the, I would like to draw the attention of this honorable court to page number, award passed by the response number 4 in respect of the entire land, my lord.
Where is
Page
the
number
award copy?
34,
34, page number
34, my lord.
34 of objections, sir.
Objection filed by respondent number 4.
Yes, my lord. Very interesting, this is my who Belgaum Nagaradi Pradhikara Aitirpu Patrika. This is award, my lord. Award passed by the. As can be seen from the award, my lord, an area measuring 19 gunta 12 anna 0 paise. So far as this land is concerned, award was passed in favor of Vittal Devapada Akuluche. All right, my lord. Now,
So for 19 guntas.
Yes, my lord.
Which is the remaining retainable area.
Yes, my lord.
Not for 3 acres. 3
Retainable, which exclusively was given to me, my lord, as can be seen from annexure Q, which is the order passed by the competent authority during the inquiry, my lord. Now coming to next, my lord, column number 2, survey number 701, measuring 2 acre, 1 gunta, and 4 anna. This award has been passed. They claim to have passed an award in favor of the Karnataka Sarkara urban land ceiling.
Yes.
In this respect, my lord, my submission is that the state government cannot pass award in favor of the state government, nor the state government can acquire its own land, my lord.
Yes.
So on the face of it, my lord, this award is a nullity, my lord.
Because it has been passed in favor.
Yes.
They
say that they are passed an award in favor of the government, my lord. Again, so for the Korakalu Jamini, 20 gunte, Matu Karab gunte yard jamin, total land measuring 3 acre 3 guntal manora. Therefore, looking into this award, my lord, no award is passed in favor of the real owner Yallapadi Opadakuluche. Therefore, my submission is that when no award is passed in favor of the real owner, the provisions of the new act shall apply. So for a
to the
section.
extent of 19 guntas.
Yes, my lord. Including entire land, my lord, entire land. Because
Argument, both of them are contradictory.
Yes.
ನೀವು either ULC ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಹೋಗ್ಬೇಕು. ನೀವು ULC ಅಲ್ಲಿ ಹೋದ್ರೆ
ULC
3 gunters ಬರುತ್ತೆ.
I'll come to that point.
ಬರೀ 19 gunters.
So far as ULC is concerned, no amount has been paid. Therefore, the proceedings stood lapsed, my lord.
Yes.
So far as the land acquisition act also concerned, no amount is paid till today, my lord. Therefore, my submission is that when no amount is passed by the response number 4 in favor of the real owner, all provisions of the new act will apply and attracted by section 24 1A of the right to fair compensation act. Therefore, my submission is that. Therefore, my respectful submission is that since no award is passed in favor of the real owner till today, the respondent number 4 may kindly be directed to pass an award in respect of this land in view of the right to fair compensation act.
Produce the entire award.
Yes.
If there is a challenge, produce that. And next, you'll have to say under the ULC, what is the compensation paid?
Original records may be called for from the deputy commissioner.
Idea. So these are 3 things that you'll have to satisfy.
And one submission, my lord. Last submission, my lord.
Really?
There may arise a question regarding delay and latches, my lord.
There may Allah, there will.
Delay, he already delays there.
My submission is that this honorable court, the division bench of this honorable court was pleased to pass judgment saying that
Their will Allah, it has already.
land acquisition, the division AR 2018 NOC 115 Karnataka, wherein this Honorable Court Division Bench was pleased to hold that Land Acquisition Act 1894, Section 4 and 6, my lord, delay and laches, acquisition of.
NOC Allah ಕೊಡ್ಬೇಡಿ, give us a full judgment. There's no reason. You can, the full judgment ಕೊಡಿ. You can download from the website and give us. ಬರೀ ಹೆಡ್ ನೋಟ್ ಕೊಟ್ಟರೆ ನಾವು ಹೆಡ್ ನೋಟ್ ನೋಡಲ್ಲ.
Please, my lord.
Full judgment.
And so far.
Prasad Kumar B. Gunki, learned counsel for the petitioner. For arguments of the respondents. ಯಾವ ಕೊಡ್ತೀರಾ ಇದೆಲ್ಲ?
Any date, next date, any date.
Next week, we list on 29th January.
Yes, please.
Learned counsels for the respondents are directed to place on record any document evidencing compensation paid in furtherance of the land being taken possession of under the Urban Land Ceiling, the Urban Land Bracket Ceiling and Regulation Act 1976. To place on record the award passed in furtherance of the entire award passed in furtherance of the final notification dated 7th April 1980 produced at Annexure R9 to the statement of objections filed by respondent number 4. 3. If any challenge had been made by the petitioner to the acquisition proceedings. 4. Document evidencing relationship between Dakal Kuche, Vittal Devappa and Dakluche Yellappa Devappa.
He's the Karta of the family.
ಏನಂತ trace ಮಾಡಿ in respect of land in survey number 701
203
of Angol village, Belgavi Taluk. Respondent number 4 is also directed to place on record the details of the plan, layout plan,
Yes.
and the allotment made, if any, in respect of the sites, if any form. Relist on 29th.
Yes, please.
At 2:30 PM for further hearing.
Yes.
2:30.
My lords, I'm unable to hear the honorable court.
You can hear us?
Now, yes, my lords, now I can hear.
Yes.
My lords, I inquired with the concerned officers. There is no additional document upon which they rely. The map was the land plans.
Then that goes, Mr. Ladda.
My lords, yes, my lords. My only request would be judgment of the Honorable Supreme Court in Kushala Shetty may be considered.
We will deal with both the judgments.
My lords.
In fact, in another matter, in the morning, we had the same issue which arises from this only. You issued one notification. Your SLO went and gave the documentation to the revenue officers. They made entry in all the RTCs. It belongs to NHA. We have issued notice in that to NHA.
My lords.
Without any acquisition. And there's one more endorsement issued by NHA saying that we have not acquired the land. Notification mentions survey number. Entry is made in RTC for the survey number. An endorsement issued by NHA saying that it's not acquired for NHA. You have to be clear and specific. Nobody will come in the way of your acquisition. Mr. Nandish Patil is getting away with it today. But if you do it properly, then Mr. Nandish Patil cannot raise any issue.
I had a similar word with my client also, my lords. But only in the present matter now, the record speaks for itself, my lords.
In future, advise them.
Definitely, my lords. I have, yes.
My lord, in fact, my lord, in the new act, my lord, have prescribed one form
which I have also extracted in my rejoinder. That gives all rejoinder. my lord.
Rejoinder, ಯಾವ್ದ್ರಲ್ಲಿ file
I
ಮಾಡಿದ್ದೀರಿ?
filed in all the matters, my lord, the rejoinder.
In all matters.
3rd December 2024.
Pasted paper in all matters.
My lord, in
ಒಂದ್ರಲ್ಲಿ ಹಾಕಿದ್ರೆ ಸಾಕು.
105937. My lord. Lord, I have a copy. Lord, if your lordships could kindly see, my lord. Page number 6, my lord. I have extracted form 2, my lord. This form, my lord, is published in the new act. And my lord, whenever an acquisition, my lord, preliminary notification is called for, it has to be called in this format, my lord. If your lordship sees the table, my lord, there is serial number, survey number, type of land, type of title, type of land, area under acquisition, name and address of the person interested, and also boundaries, my lord. If they do it in this format, my lord, then my lord, that will comply, my lord, the brief description as stipulated in 3(2)(a), my lord.
Niche Act. Form number 2, na?
And in fact, in the form 2, my lord, the trees also, my lord, the variety, number, and the structures also, my lord, there is a column for that.
But this is under section 11.
Please, my lord.
Not under section 3A.
Not under the schedule 1, 2, and not that, my lord, but at least for the reference purpose, my lord, I thought it, my lord, would be fit, my lord.
We cannot direct them
No,
do it in this
I'm
way.
not
We can
saying
say
a
what they have
direction.
done is wrong.
My lord, I'm not saying a direction, my
Them to
lord,
do
but
it in
if
the
they
right manner.
follow this format, my lord, it will be beneficial for the land.
Can make an
user.
observation. That's
Please. Only to that extent, my lord.
Well, it's one submission regarding the project in question only. The 3D notified land is of approximately 500 acres. Out of that, award for the extent of 276 acres has been passed, and landowners of 123 acres have received the compensation. My only anxiety is the order of the honorable court should not come in the middle of the project.
petitioners here.
Well, it's,
Lord,
yes,
my instructions are that, my lord, out of 33 villages, only for 5 villages they have passed award.
that's what I'm submitting,
We
Manoj.
pass orders only for the petitioners,
Please.
Yes.
not for people who are not
Yes.
before us.
That should not hamper the project, Manoj. That's my only
That doesn't
anxiety.
mean that you go file tomorrow.
That's my
notices.
anxiety, Manoj. That's my anxiety.
Don't issue notices. Give us both the judgments.
Lord, judgment.
Judgments good. Nam their judgment too.
Please.
ವಾಪಸ್ ಕೊಡ್ರಿ.
Petitioners in all the above matters are before this court, seeking the following reliefs. The petitioners claim to be owners of various lands as indicated below. Andish, one table ಮಾಡ್ಕೊಡಿ. Serial number.
It's on record.
ಎಲ್ಲಿದೆ ಅದು?
ಇದೆ.
ಯಾವುದು? ಕೊಡ್ರಿ ಸರ್.
ಕೊಡಿ ಅದು.
I'll file it.
ಕೊಡಿ ಅದು ಕಾಪಿ ಕೊಡಿ.
ಇದನ್ನ ಕೊಡ್ಬಿಡ್ರಿ.
Has the writ petition number, my lord, and survey number, village.
Writ petition number.
Survey number, village.
The petitioners in each of the above matters are the owners as indicated below. Serial number, writ petition number, survey number, extent, situate at.
Lord, my learned friend will have to file in his petitions, my lord.
That I will file.
In his petitions, my lord, he'll have to file.
ಯಾವ್ದು ಬಿಟ್ಟೋಗಿದೆ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
The third respondent had issued a notification under section 3 capital A bracket 1 of the National Highways Act 1956 for the purpose of construction of 4/6 lane highway along with maintenance, management and operation of the Belgavi Eastern and Western bypass bracket Belgavi Ring Road bracket close on 13/9/2022 as per Annexure B, which was published in the newspaper having local circulation on 13/10/2022 as per Annexure C. Though the survey number had been, the village name and survey number and extent of land was mentioned in the said notification, the grievance of the petitioner is that, petitioners in each of the above matter is that they were unable to ascertain if their lands were part of the said notification. Since the notification does not specify the boundaries, nor does it contain the name of the owner and or the extent of land proposed to be acquired from each of the owners, thereby making it difficult for the landowners to ascertain if their land was under acquisition, the purpose for which it was being acquired, and thereby submit proper objections in relation thereto. The petitioners, however, filed certain objections again raising this issue by stating that the specific survey number, subdivision, specific extent, specific boundaries of the land and the person from whom the land is proposed to be acquired had not been mentioned, and called upon the respondents to make available the said details. It was also contended that the acquisition notification is not in terms of the provision of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement act 2013, more particularly in terms of form number 2 prepared in person of rule 5 bracket 1 of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement bracket compensation, rehabilitation, and resettlement and development plan bracket close rules 2015. It is further alleged that on the filing of the objections, though notice of hearing was fixed, when the petitioner visited the office of the SLAO, the statement of the petitioners were not recorded, but they were only informed that the objections were overruled.
Page
By
41.
contending on the ground that the Belgavi Ring Road is for use of general public, and as such, it is alleged that the specific objections submitted by the petitioners were not considered on merits and orders passed by the SLAO, but it was only a format order passed by the SLAO by only replacing the name of the addressee and the extent of land, details of the land, and details of the objections filed, the date of the objections filed. Rest of the contents were identical in all the rejection orders passed by the SLAO. Thus, it is contended that there is no application of mind by the SLO while considering the objections filed by the individual landowners, thereby rendering section 3 3C of the National Highways Act 1956 completely redundant, inviting objections for the sake of inviting, rendering the same an empty formality, and thereafter the same was followed up with a notification under section 3D. Final notification under section 3D of the NHA Act declaring that the land has been vested with the central government free from all encumbrances. It is aggrieved by the notification is issued under section 3A1 and 3D2 that the petitioners are before this court on the basis of the above contentions. Apart from the above, Shri Nandish Patil, learned counsel appearing for the petitioners in some of the matters, submits that the whole purpose of issuing a notification under section 3A being to acquire the land of a private person, the rights of the private person are required to be protected, and any action taken by the state in exercise of powers of eminent domain have to comply with the requirement of law, thereby giving effect to section 300 capital A of the Constitution of India, and the property rights of the landowners cannot be negated by use of power of eminent domain without following the due process. His submission is that, firstly, there are no sufficient details provided under the notification under Section 3A to enable the petitioners to submit their detailed and proper objections. Secondly, even when an attempt of filing objections were made, no hearing was provided. And thirdly, that the objections have been rejected in a cursory, mechanical manner, negating the property rights of the petitioners. And lastly, a notification has been issued under Section 3D2, vesting the property of the petitioners with the central government after having violated all applicable provisions relating to eminent domain. In this regard, he relies upon the decision of the Honorable Apex Court in 2005-13 SCC 477, more particularly
Lord, para 7, my lord. Para 6, 7, and 8, my lord.
Para 6, 7, and 8 thereof, which are reproduced hereunder for easy reference.
Please.
By relying on Barangor Jute Factory's case, he submits that a brief description of the land in acquisition notification would require all the details to be furnished so that the notification cannot come under the mischief of it being vague. The absence of the details would negate the right of the landloser to file detailed objections, rendering the protection granted under law against compulsory acquisition redundant. He relies upon a decision of this court in dated 4th December 2024 in WP number 51312 of 2016. More particular para?
Lord, Lord, para 22, my lord. Lord, 16.
14,
16.
16, 18 and 19, which are reproduced hereunder for easy reference. By relying on Sampath's case, his submission is that the notification in the Section 3 capital A would have to contain enough and sufficient details to not only identify the property being acquired, proposed to be acquired, but also the owner from whom the property is proposed to be acquired. Since without the cross-referencing of both these aspects, proper objections could not be filed as provided under Section 3C of the Act. He relies upon the decision of this court in writ petition number 10103 of 2020 and connected matters dated 19/7/2022, more particularly para 17.9. 18.23, 18.24 and 18.25. By relying on the above, he submits that it is a compensation which is determinable under Schedule 1 the benefits and Schedule 2 and methodology is detailed in Schedule 3, which would be applicable even to acquisition under the NHA Act, and these aspects have not been complied with and followed by the NHAI, inasmuch as the notification itself is not sufficiently detailed, the objections filed have not been properly considered, and the entire process and procedure has been rendered an empty formality. On the above grounds, he submits that the writ petitions are required to be allowed and the relief sought for granted. Shri Prasad Patil, Learned Counsel, appearing for the petitioners in some of the above petitions, adopts the submission of Shri Nandish Patil and submit that the petitions filed by him may also be allowed. Shri Sagar Ladda, Learned Counsel, appearing for the NHA, would submit that what is required to be published under Section 3 capital A is a notification giving a brief description of the land, and the substance of the notification is to be published in 2 local newspapers, one of which is vernacular. His submission by referring to Section 3 capital A is that whenever any private land is required for public purpose, for building, maintenance, management or operation of a national highway or part thereof, an intention to acquire the land could be issued under subsection 1 of Section 3 by providing a brief description of the land in terms of subsection 2 of Section 3. Section 3 capital A does not contemplate details of the owner of the land, the extent of land to be acquired from such owner, and or any other details to be provided. This, he submits, is a procedure prescribed under the Act of 1956 in order to speeden up the acquisition proceedings for a public purpose project of the NHAI. His further submission is that it's only after a notification of subsection 1 of Section 3 capital A is published that under Section 3 capital B, it would be lawful for the central government to inspect, survey and measure the property and carry out such actions as may be required. And as such, without publication of a notification of subsection 1 of Section 3 capital A, the NHAI is not in a position to give all the details of the specific extent of land required from each owner, the name of the owner, the boundaries of the said property, which can only be done after the inspection, survey and measurement under Section 3 capital B. He therefore submits that the NHA, having the experts at NHA having formulated the manner and methodology of construction of highways, new highways or widening of existing highways. The experts of NHA having identified the lands, the said identification cannot be faulted with, and in this regard, he relies upon the decision of the Honorable Apex Court in 2011-12 SCC 69, more particularly para 28 thereof, which is reproduced hereunder for easy reference. By relying on Kushala Shetty's case, Supra, his submission is that NHA being a professionally managed statutory body, having expertise, and any proposal being formulated by the experts at NHAI, the scope of judicial review is limited, and this court ought not to entertain the contentions raised by the petitioners in the present matter. Sri Ladda also relies upon the decision in Barangor Jute Factory, which has been relied upon by the petitioner. In fact, he also relies upon the very same paragraphs, namely para 5, 6, 7, and 8, and submits that the Honorable Apex Court has come to a conclusion that since a plan has been mentioned in the notification, any person aggrieved by the notification could visit the office of the SLAO, ascertain if his land is being acquired, and the non-mentioning of the details in the notification subsection 1 of section 3 capital A will not cause any harm and injury to the petitioners, since they always had an option to ascertain if their land were proposed to be acquired and the extent thereof, since the survey number has been mentioned in the notification under subsection 1 of section 3 capital A. Thus, he submits that the Honorable Apex Court in Barangor's decision, having come to a conclusion that the plan would be sufficient compliance, that the existence of a plan prepared by NHA would be sufficient compliance, the contention of the petitioner would have to be rejected. Insofar as the orders passed by the SLAO on the objections filed by the petitioner, his submission again, by relying upon Kushala Shetty's case, is that the experts having decided the location of the concerned road and the road being developed for the purpose of, in the interest of the general public benefiting from creation of such a road. These aspects have been considered by the SLAO, and the objections filed by the petitioners have been rejected. His submission is also that the private interest is to be subservient to the larger public interest, which in this case is the establishment of the highway, which the respondent number 3,
2 and 3.
with the National Highway Authority of India is in the process of implementation. On all the above grounds, he submits that the above petitions are required to be dismissed.
Lord, insofar as the map, my lord, I have placed on record objections, my lord. That may be.
In objections.
My lord, yesterday I have filed it.
Yesterday you filed. Have you served it?
So, sir, madide.
What do you have to say?
Yesterday night I received a copy.
Yes.
I took instructions from my client, and I have been instructed that
what we have said is, my lord.
My lords, the contention of the petitioners is that the notifications which were quashed in 1819 have been, which were published in 1819 have been quashed by this honorable court. Well, they were caused on our submission itself, and the submission was made because there was a disagreement between the central government and the state government with regards to funding of the project. That is the reason the notifications were caused. But however, the project did not change at any point of time. Project remained the same. And another contention of the petitioner is that
project has changed, my lord,
in
for the
earlier
reason
matter,
being.
30 villages to 33 villages.
Yes. Even to that, I'm
So, my lord, the map
agreeing,
will anyway have to change, my lord. They'll have to do it.
Malas, even to that, I have been instructed that in
Third.
that land plan also, the villages were same, and even present the land villages are same. These are my instructions.
Heard so and so, various papers. The points that would arise for consideration are whether a notification issued under subsection 1 of section 3 capital A is to only contain a brief description of the land, meaning thereby the survey number and the extent proposed to be acquired, or would it require other details like the type of title, type of land, area under acquisition, total extent of land, area under acquisition, name and address of the persons interested, the boundaries of the survey number, as also the boundaries of the proposed land to be acquired. In the event of there being any buildings, the nature of the buildings, the extent and measurement of the building, so as to enable the landowner to submit his objections. Whether while considering the objections filed by the land loser, the SLAO would have to consider each and every objections raised by the land loser, or could the SLAO reject the objections filed by the land loser on the ground that the implementation of the project of the NHAI is in the larger public interest. 3, whether either 2 ತಗೊಳ್ಳಿ, whether the making available of the detailed plan in the office of the SLAO NHAI and permitting inspection thereof would be sufficient compliance with the requirement of the principle of natural justice in putting on notice the land loser of the extent of land that is proposed to be acquired. Whether the position ಎಲ್ಲ ಬೇಕಾಗಿಲ್ಲಲ್ಲ. That's not required. What order? Answer to point number 1. The submission of both the councils have been extracted here and above. The submission of Sri Nandish Patil being that sufficient details have not been provided to identify the extent of land and the owner from whom the land is proposed to be acquired, and the purpose to which the land of the petitioner is proposed to be used. so as to enable the petitioner to submit a detailed objections. As a submission of Sri Sagar Ladda, Learned Counsel for NHAI, is that it's only a brief description of the property which is required to be furnished, which has been so furnished. And as such, the petitioner could visit the office of the SLAO to ascertain if their land is being acquired and if so, what extent. Once earlier, when the matter was taken up for hearing, when such a submission had been made, Learned Counsel for the NHA was directed to produce the plans prepared for the purpose of this project. It is in that background that the SLO of NHAI was present before this court on 21/2025 along with the maps, stroke plans. The purport of the said plans being made available in the office of the SLAO as contended by Mr. Sagar Ladda was for a land loser to be able to visit the office of the SLAO to ascertain if his land is being acquired and to what extent. It is for that reason that this court put a question to the SLAO as to what is the extent of land in survey number 14, 15 and 74 shown in the said plans which were being acquired and in whose name those lands stand, as also the extent of property, extent of land in those survey number which are proposed to be acquired. The SLAO made an attempt to answer the same by referring to a notification published under section 3D, which notice, needless to say, would be, which notification would, needless to say, is published only after rejection of the objections filed by land loser and the said notification, the final notification vesting the land with the state. Thus, he was called upon to answer the query without referring to the 3D notification and only referring to the 3A notification. When the SLO submitted that by only referring to section 3A notification, he would be unable to answer any of the above queries. Now, if the said answer by the SLO is taken into consideration along with the submission made by the counsel for the NHAI, then the such submission would have to be rejected, since even if a land loser were to visit the office of the SLO himself is not in a position to explain the extent of land proposed to be acquired in the survey number and in whose name the land stands. Thus, without those answers, the land loser's visit to the SLO's office is again an empty formality to be only informed to look into the notification under subsection 1 of section 3A and no further information being provided. The reliance placed by both the council by Sri Sagar Ladda on Barangor jute factory to contend that that while preparing a plan, all the details would be taken into consideration, and the plan, if made available for inspection, the requirement under subsection 1 of section 3 is satisfied, will not be available to the petition to the NHA in the present case. The Honorable Apex Court in Barangor's case has categorically held that In many cases, small parts of larger chunks of land having been notified for acquisition, the same would not be possible without preparing a plan and came to a conclusion that the notification does not make any reference to any plan. Without the plan, the Honorable Apex Court held as at questioned as to inverted commas, how can anybody know that there was a plan which could be inspected and inspected where? Inverted commas close. And further held that the absence of any plan linked to the notification fortifies the argument that the description of the land under acquisition in the impugned notification fails to meet the legal requirement of a brief description of the land which renders the notification invalid. And the Honorable Apex Court went on to uphold the judgment of the High Court and dismiss the special leave petition filed by the competent authority and the National Highways Authorities of India. Thus, the decision in Barangor Jute Factory does not support the case of the NHAI. The submission that there is a plan in existence in the present case, which was not so in Barangor's case, and therefore the plan satisfies the requirement of subsection 3 capital A, does not hold much water as afore observed. Even the SLO who was present before this court was unable to, SLO was present before this court with all his rich experience and knowledge of the matter, was unable to point out the extent of land in each survey number and the owner from whom the said land was proposed to be acquired. Thus, even though a plan has been prepared in the present matter and the notification 3A1 notification of subsection 1 of section 3A makes a reference that the plan is available for inspection at the SLO's office, the same does not change the situation in any manner than that as considered by the Honorable Apex Court in Barangor's case. Since as observed supra, even a visit by any land loser to make enquiries on the same would be empty formality without any details being provided to the land loser. It is on account of various inadequacies in the land acquisition proceedings earlier under the Land Acquisition Act 1894, as also under various other enactments where acquisition of land is permitted, that the Parliament enacted the right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act 2013. The very name of the enactment indicates the reasons why the enactment was introduced. Firstly, for fair compensation. Secondly, for transparency in land acquisition. Thirdly, for rehabilitation. And fourthly, for resettlement. The object of the said enactment is to ensure that a humane, participative, informed and transparent process for land acquisition, for industrialization, development of essential infrastructural facilities and urbanization with the least disturbance to the owners of the land and other affected families, as also to provide just and fair compensation to the affected families whose land is acquired or proposed to be acquired or are affected by such acquisition, amongst other aspects. though the aspect of rehabilitation and resettlement would not apply insofar as acquisition of land for the formation of a highway as held by this court in its judgment in Manohar Patel's judgment Supra. This court has come to a conclusion that the Schedule 1, 2 and 3 of the Act of 2013 would be applicable even to acquisition under the National Highways Act. The Form 2 of the Right to Fair Compensation Transparency in Land Acquisition so and so Resettlement and Development Plan Rules 2015 is reproduced hereunder for easy reference. The said Form 2 I mean prepared in terms of Rule 5 of the aforesaid rules. The said Rule 5 is also reproduced hereunder for easy reference. A reading of the above would indicate that in order to bring about transparency in the methodology of acquisition, the Parliament has categorically even prescribed a general form of preliminary notification. Though certain aspects as regards social impact assessment, resettlement, etc., would not be applicable to NHAI, the said form makes it clear that the preliminary notification needs to contain the serial number, survey number, type of title, type of land, with the number of trees, along with variety thereof, the extent of land, the area under acquisition, name and address of the person interested in land, as also the boundaries thereof, including the details of the structure with the type and plinth area. And the considered opinion that these details, which have been mandated in terms of Form 2 of the aforesaid rules, could be made use of NHAI, and those details published in a preliminary notification as subsection 1 of section 3, subsection 1 of section 3 capital A, which would provide transparency in the acquisition proceedings and also not give rise to the objections raised by the petitioners in the present matter. This also being for the reason that the acquisition earlier initiated for the very same project by NHAI having been quashed is now required to be quashed the second time on account of NHAI not following the due procedure and making available the necessary details. If at all those details had been so furnished, the petitioner could not have raised such a ground, nor would this court have interceded in the matter. Hence, I answer point number 1 by holding that so and so. Answer to point number 2. The petitioners, the land losers, have filed objections to the notification under sub-rule 1 of Rule 3A. Many of the notification, most of the objections are again centered around the details of the land proposed to be acquired not being mentioned. There being several owners of the land it is not clear as to whose land is proposed to be acquired. The land standing in the name of different owners. Only the main survey number is being mentioned without the sub-survey numbers being mentioned. Therefore, it was contended that the notification is not published properly. There are details which were furnished as regards the improvements which have been made on the land, the existence of various trees, houses, shops, pump sets, and other aspects relating to land, as also the nature of crops which were being grown and the status of those crops, including fruit-bearing trees, etc. It was further contended that
Court officer, the honorable court is not visible or audible. It's not even in the meeting, it seems.
the SLAO has only stated as well as development of Belgavi city and around the area. The proposed ring road will also reduce the pressure of transport and smooth traveling. As stated, accordingly. Whenever any objections are filed by a land loser to a notification for acquisition, the least that the SLAO is required to do and pass an order when a- when the right to property guaranteed under the Constitution upon by the state by exercise of powers of eminent domain. In my considered opinion, the manner in which the SLO has dealt extent of land which is proposed to be acquired and each survey number, and the person from whom it is being acquired, but has chosen perfunctory grounds without dealing with the objections filed by
क्या नहीं है
past is completely inhuman, non-participative, and non-transparent. In that view of the matter, I answer point number 2 by holding that so and so. Point number 3, in view of my answers to both point number 1 and 2, the writ petitions are allowed. The preliminary notification dated 10/10/2022 bearing number so and so, published on 13/10/2022, issued by respondent number 3 at annexure C, issued by respondent number 3, as also the final notification dated 27/7/23 bearing number so and so, issued by respondent number 3, published on 4/8/2023, are quashed insofar as the lands of the respective petitioners are concerned, as detailed in para number blank above. Liberty is however reserved to the NHA to initiate fresh acquisition proceedings by strictly complying with the applicable law and rules and taking into consideration the aim and objective of the Act of 2013.
Read for minutes.
Lord, one judgment on cyclostyle orders, my lord.
ಬೇಕಾಗಿದೆ.
Please. Publish.
ಎಷ್ಟೋ judgment.
Read for minutes.
Yes. Told 89.
89, Mrutyunjay.
Please, my lord.
ಚಳಿಕೆರಿ ಏನು ಅಷ್ಟು ಅರ್ಜೆಂಟ್ ಏನೋ ಅಂದ್ರೆ
My lords, petitioners, my lord, 2 and 3 are the advocates of the petitioner number 1 in the suit. It is a suit for declaration, my lord, that the plaintiff was the, my lords, may I take my lords to page 44 genealogy? I would be better able to explain, my lords. Page 44.
Page 44.
44.
Yes.
My lords, this Baslingappa Gaurava, his son, my lord, Shekappa, Shuputrappa and Basuraj. My lord, now the Shekappa has died, my lords. So the Shuputrappa, my lord, files, this Shekappa, my lord, is died intestate, my lord. My lord, he had, this is the divided family, he had certain properties, my lord, so which came to be acquired and compensation was granted. He has, my lord, deposited, my lord, that amount in some of the cooperative banks, my lords, in the many fixed deposits. There, my lord, he nominates the defendant number 3, who is a stranger to the family, as a nominee, my lords. Now this brother, my lord, Shuputrappa, he files a suit to declare that, my lord, they are the class 2 heirs of Shekappa, and they are, my lord, entitled for the share there, my lords. Now, my lord, the defendant number 3, my lords, who is a nominee for the fixed deposits. My lord, she comes and files an application under Order 7, Rule 11, that she is the nominee, she is the absolute owner, suit is not maintainable. That application came to be rejected. Thereafter, my lord, they devise, my lord, this method. They file an application before the court for seizing the wakalat of petitioner number 2 and 3 before my lords, who are advocates.
Shows the application.
My lords would find the application, my lords, at page number 85, my lords. Affidavit is page 86. Paragraph number 3 would be relevant. May I read it, my lord?
You have a conflict of interest.
No, my lords. This is MC number 37 of 2008, my lords. Petitioner represented deceased Shekappa against his wife, my lords, in a matrimonial dispute, my lords. Now that came to be concluded, my lords, long back. Then criminal miscellaneous of 159 of 2011, there also these petitioners represented him in a matrimonial matter.
In the interest of your clients,
None of my clients are there, my lords.
it is in the interest of your clients in this petition
Please.
to not appear for the plaintiff,
Yes, sorry, my lords.
to not appear for the plaintiff, to avoid all these kind of allegations.
My lord, that the allegations are not genuine is.
Advocate should return the file and close it.
My lord, the allegations are not genuine because of some third person comes and makes an allegation. My lord, that they do not become
Nominee, nominated by Shekarappa.
nominated by Shekappa,
And now you are filing a petition
claiming a share, my lords.
contrary to your earlier client's nomination.
No, my lords, there is no other nomination.
Your nominee, your Shekarappa's nominee is defendant number 3.
Yes, my lord.
Plaintiff has filed saying defendant number 3 is not the nominee and it has to be given to me as a class 2 heir.
Yes, my lord.
You are virtually acting contrary to what instructions. You are negating your client's action.
No, my lords, these cases got, my lord, disposed of about 8 years back, my lords. Thereafter, my lord, in his own individual capacity, he does it at some point of time. The deceased Shekappa, these cases got over 8 years back. There
So
is,
much of interest to be tied to this matter, Mr. Alikari.
my lord, if that application is not there, my lord, and if that order is not there, my lord, then it is fine, my lords. Having made such
Voluntarily
allegations,
give it up.
please, my lord.
You should voluntarily issue a no objection wakalatnama and go away.
My lord, those persons, my lord, have no interest there, my lords.
You
Those
are
persons,
identifying with the client. That's the problem.
because there is an allegation against me.
We are not
My
going to
lord,
interfere.
because there is an allegation against me.
We are not going to interfere.
My lords, may I kindly, my lords, kindly see this, my lords.
This is dispensed with for why?
No, my lords, I am not representing anybody's conflicting anybody's interest, my lords. I am not interested in representing anybody's interest.
Don't make us make comments which you will not like.
I'm
Don't make us make comments which you will not like. You are appearing for all 3.
No, my lords, I am not appearing for all 3. I am appearing only, my lord, I am appearing only for one of the brother.
Where is Mr. Kaddevar?
My lord, I am appearing only for one of the brother.
Where?
Shankardevar.
My lord, I am not appearing, my lord, against the interest of my client.
Where is Mr. Kaddevar? The counsel for the petitioner is present, none appears for respondent number 3. Relist, since the matter was taken out of turn at the request of counsel for the petitioner, the absence of respondent number 3, he is justified. Relist on 29th January.
My lord, interim order may kindly be extended, my lords.
What is the interim order? We'll vacate the interim order.
My lord, so that operation of that order is stayed, my lords. And the further proceedings are stayed, in fact.
Interim order earlier granted is extended till next hearing.
Great.
Fast over matter. Serial number 3, D. Ravi Kumar Gokakar.
Counsel for the petitioner has carried out amendment. Relist on 28th January.
Ten Vittal Teli.
Counsel for the petitioner has complied with office objection. Relist on 28th. Ready?
It's government has to say.
It is the government.
Yen, Mr. Kannur.
NA order is cancelled by the deputy commissioner. It is contrary to the NA notes.
Without notice, sir, with notice.
Notes one, he has no powers. This court has taken page number 179 is the order.
With notice or without notice?
Without notice.
Page?
Page 179 is the impugned order. Annexure Q, my lords. Typed copy is next 181, my lords. He cancels, my lords, that my lords, we are the my lords, after conversion order is passed, my lords, the original owner, my lords.
Why was it cancelled?
Lords, it was cancelled at the behest of a private respondent who has converted this land and sold to the respondent number 9 and 10.
On the ground what?
No, my lords, nothing, there is nothing is mentioned. He made an application for cancellation.
Somebody makes an application, he will cancel.
Yes, that is to be.
Ground illa.
It was not considered a lordship, they have to pass.
How can you cancel conversion?
That too, layout is laid, we are the purchaser subsequently after layout is done.
Once land is converted, it is converted unless there is fraud.
Yes, because lordship, he has no power to cancel that.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the conversion order converting the land of the petitioner from agriculture to non-agriculture purposes dated, when is that?
That conversion order is at annexure C, my lords. C and D, that is 7/4/2015. Two conversion orders by
7/4/2015
yes,
has been unilaterally cancelled
and 22/5/2015 two orders.
on
22/5/2015 annexure D also, my lords. This is also conversion order.
5/2015 wide annexure 22/5 6/5 antiದೆ.
These are the NA orders grant. Two NA orders, my lords. Annexure C and D.
Your prayer is for quashing the order dated 6/5 annexure Q.
Q, that is the only ones.
17/119. Order dated 6.
He mentions two dates. That is at page number 179, my lords. 6/5 break again they mention central notes.
6/5/2016 at annexure Q. The submission of the counsel for the Shri Vittal Teli learned counsel for the petitioner is that once the land is converted for non-agriculture purpose, the deputy commissioner is rendered functus officio and can no longer cancel the said conversion. If at all any challenge is to be made to the conversion, they can be only on the ground of fraud or otherwise, but the same cannot be made before the deputy commissioner. This court has
Notes, page number 182 and 187.
this court, by a judgment dated 14 November 2013 in WP number 45634 of 2013, has categorically held that once a conversion order has been passed under section 95, the deputy commissioner becomes functus officio and no review of an administrative action can be made since the statute does not provide for it. The said judgment would be equally applicable to the present facts. And as such, I pass the following order. Writ petitions allowed. A certiorari is issued, so on to order at annexure Q. He is squashed. Needless to say, the conversion order dated
Annexure C and D, my lords, 7/3/2015.
7/3/2015 shall continue
Notes,
to
one
be
more.
in, and all actions taken pursuant thereto shall continue to be in force.
26, Srikanti Patil.
Challenging, my lord, annexure C and annexure E.
Not the,
ಬೆಳಗ್ಗೆನ ಒಬ್ಬರೇ ಬಂದಿದ್ವಿ. Again appearing for R4, R1.
R1 man.
R4 and R6 ಇಲ್ಲ.
ಅವ್ರು.
ಬೆಳಗ್ಗೆನ ಅದಕ್ಕೆ
But,
ಪಾಸ್ ಓವರ್ ಆಗಿದ್ದಲ್ಲ.
2 and 3, my lord, they are the contest, 1 and 2 are contesting, and 6 is, my lord, the.
Only 1 and 2 na?
1 and 2 and, my lord, 6 is also contesting, but it is served.
Though learned counsel for the petitioner and respondent number 1 have been present both in the forenoon and the afternoon session, none appears for respondent number 4 and respondent number 6. If none were to appear for respondent number 4 and 6 on the next date of hearing, the petition would be taken up for consideration on the basis of the counsels present and ready to address argument, the matter disposed. Relist on 30th January.
Please.
As ಬೆಳಗ್ಗೆ IA 1 of 23 is allowed, IA 1 of
56,
53.
53. S.C. Hiramad.
None appears for the petitioner though for twice, once in the morning session, once in the forenoon session, once in the afternoon session. If none were to appear, dismissal relist on 5th February.
6, P.V. Somapur.
Yes,
Though counsel for the
First,
petitioner has been present both in the morning session and the forenoon session and afternoon session, none appears for
Kayak is on VC, he told.
on VC. Automatic ಬರ್ತಾ ಇಲ್ವಾ?
56,
My lord,
Yes, Mr. Kaikmat.
my lord, this writ petition is not maintained, my lord, by reason that the.
ನೀವು ರೆಡಿನಾ?
Ready, my lord, ready, my
ಸೋಮಾಪುರ್
lord.
ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾರೆ, ಆಮೇಲೆ ನಿಮಗೆ ಬರೋಣಂತೆ.
Sorry, my lord.
ಕಂಟೆಸ್ಟಿಂಗ್ ನೀವು ಒಬ್ರೇನಾ? ಇವ್ರಿಲ್ವಾ? LS Otin?
yes, contesting ಅವರೊಬ್ರು contesting.
LS Otin ಇಲ್ಲ.
14 ಅವರು.
R5 is not a contestant.
Not a contesting.
ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ?
Take 20 minutes. 20
minutes ಆಗುತ್ತೆ. ನಿಮ್ದು ಎಷ್ಟೊತ್ತಾಗುತ್ತೆ ಮಿಸ್ಟರ್ ಕಾಯಕ್ಮಠ್?
My lord, ನನಗೊಂದು 15 minutes ಸಾಕು, my lord.
ಹಾಗಾದ್ರೆ ಇವತ್ತು ಬೇಡ. Relist on 31st, first working ಅಲ್ವಾ?
First 31st ಆಗಿಲ್ಲ, my lord, 31st.
First working day ಇದೆ.
ಇಲ್ಲ, first, my lord, I'll be in trial court. I'm sorry, my lord, I'll be in trial court on first.
ಬರೀ ನಮ್ ವರ್ಕಿಂಗ್ 31st.
Much obliged, my lord.
57, Dinesh Kulkarni.
Yes, ma'am. On last occasion.
My lord, morning I couldn't come. My lord, what has happened, my lord? One Nityananda had borrowed loan.
You have to produce.
My lord, what has happened? One Nityananda had borrowed loan from our bank.
You have to produce.
But this is what has happened. My lord, actually one Sridhar who is the.
EC produce ಮಾಡಕ್ಕೆ ಏನು ಮಿಸ್ಟರ್ ಬಿಲ್ಕಿ ಪ್ರಾಬ್ಲಮ್?
ಇಲ್ಲ, I requested the bank, but they are not sent.
Online application EC.
ಅಲ್ಲಿ ಇವರು ಆಕ್ಚುಲಿ ಇವ್ರು ನಮ್ಮ ಬ್ಯಾಂಕ್ಗೆ ಪ್ಲಜ್ ಮಾಡಿರ್ಲಿಲ್ಲ, ಮಾರ್ಟ್ಗೇಜ್ ಮಾಡಿರಲಿಲ್ಲ ಪ್ರಾಪರ್ಟಿ. ಬಟ್ ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್, ಇವರು he was a guarantor for the loan taken by another person in our bank. So we issued a legal notice to him, and we also filed a suit for recovery. In recovery
said if you don't produce it, adverse inference would be drawn. Do you want to take that risk?
I informed my lord.
We'll give you one more time. ಆಮೇಲೆ ಇಲ್ಲ. Or you want to address arguments without it, it's fine. Is unable to produce and record ಮಾಡ್ತೀವಿ ಅಷ್ಟೇ.
I had informed my lord, but they are not yet sent it to me.
You are not going to produce, or you want time to produce?
One more time I will ask.
Counsel for respondent number 3, he is granted 10 more days time to comply with the order date 6/1/2025. It is made clear that if the said order is not complied by 6th February, the matter will be proceeded with and no further adjournment would be granted.
Please.
58, Sanjay Katiyari.
Could it be next week, my lord? Could it be next week, my lord? It will take some time.
We'll take some, we'll have it on Saturday.
Next Wednesday.
Sorry, my lord.
Free ಆಗಿದಾವೆ.
Yes. No. Sorry, morning I was held up in other court. Sorry.
ಜ್ಞಾಪಕ ಬಂತು, Saturday working day ಇದೆ.
So we have got.
ನೀವ್ ಹೆಂಗ್ ರಜಾ ಮಾಡ್ತೀರಾ?
Please.
ಈ ಸ್ಯಾಟರ್ಡೇನಾ ನೆಕ್ಸ್ಟ್ ಸ್ಯಾಟರ್ಡೇನಾ?
Next Saturday.
ಇಲ್ಲೇ ಇರ್ತೀರಾ, ಬೆಂಗಳೂರಿಗೆ ಹೋಗ್ತೀರಾ? ಬೆಂಗಳೂರು ಹೋಗಿ, ಹಾಗೆ ನೀವು ಹೋಗಿ ಬೆಂಗಳೂರು.
Any
Due to
date
paucity of time, the matter cannot be taken up today. Relist on 29th January.
Please.
60 PM Shilwant.
ಇದಾಗಲ್ಲ ಇದು.
Saturday.
It'll take some time, Saturday. 60 relist on 25th
Please.
due to paucity of time. Again, list 2.
List number 2. Serial number 1, Sadiq Gudwala. List 2.
List 2 compliance ಆಗಿದಾವ?
61 minutes.
List 2 also will repeat on Saturday. ಏನೇನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆಯೋ ಅಷ್ಟೊಳಗೆ ಮಾಡ್ಕೊಳ್ಳಿ. So that you will pass orders on it. ಸುಮ್ನೆ ಒಂದು ಡೇ ಕೊಟ್ಟು ಅದ್ ಮಾಡಿ ಬೇಡ ಅಂತ ಎಲ್ಲ ಬೇಡ. ಇಲ್ಲ ಲಿಸ್ಟು ಇವತ್ತೇನು ವೆಡ್ನೆಸ್ಡೇ, ಫ್ರೈಡೇ ಮಾಡೋದ ಸ್ಯಾಟರ್ಡೇ ಮಾಡೋದ? ಲಿಸ್ಟು ಏನೋ ಮಂಡೇನೂ ಮಾಡಿ ಅಂದ್ಬಿಟ್ಟು ಸ್ಯಾಟರ್ಡೇ ರಿಪೀಟ್ ಆಗಿದೆ.
Interim order ನೋಡ್ರಿ.
It is going to be extended ಅಂತಾನೆ ಇಟ್ಕೊಳ್ಳಿ.
My lord, serial number 91.
23.
My lord, serial number 91, my lord. Kindly.
ನಿಮಿಷ ಇಲ್ಲಿಂದ ಬರ್ತೀವಿ.
98 my lord.
ಹಾ 98 ಏನ್ ಹೇಳಿ?
First week.